Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Room buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, stand shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning. Hello, everybody. Good morning. Hi, Hannah. Hi, Zizzy. Good morning, everybody. Welcome in. Today's Thursday. I was gonna say today's Tuesday. I clearly missed a day there. Oh well, 2 days. So we are getting up to get ready for another day of trial, another day of coverage. Today, actually, right? I want because several people have come to me talking about this trial. But before we go there, apologies for not being on camera today. I'm sorry, I did not feel like to be on camera today. It's still recovering from the whole mess of yesterday. Um, so today I'm just taking it easy-ish. So I hope you all can hear me. Still, yeah. As you can, which is good. So we're still recovering from that, just making, like, I prioritize my mental health. I'm okay, I'm kind of rested, but yeah, just staying behind the scenes today. Hello, Maria, good morning. Good morning, I hope you're okay. I hope you had a good rest. Hannah, yes, I do read your mind sometimes, and I have awesome people that also reach out to me and give me ideas of cases, and this one was one of them that I've seen around, and I actually wanted to cover, but there was not an actual feed. Good morning, Kara. Hi, good to see you, my friend. I'm waving at at the screen like you can see me, but yeah, not today. I think she's happy to see you, Hannah. So we are. I'm hoping that the feed that I found for this trial actually works. Awesome. Yay, you waved back. That's awesome. I hope that this feed that I found does work, that we can see at least today of the case, because we are kind of late for the party, because I think this case is actually quite finishing already. But what we can do is um see, like, because I think they're going to deliberate today. I know they are going on verdict watch today, but during that said verdict watch, we can always look at the videos that there is online on court TV website about the case, about some, I think, some of the testimony that has been ongoing on this that we have missed. But if not, well, we'll see, and I can do like a bit of a reading of the case synopsis, so you guys can know exactly what the case is about. I'm just waiting on people to get here, because I am a little bit early to the live stream, because I initially put this for 10 a.m. Eastern, and I know people are not here yet. But I've got good news. The feed that I was waiting is on. This is so awesome. The feed is actually on. So hang on, I need to try to share this, which is amazing. I am very happy about this. I hope the sound is good. So there we go. That is the court we've been watching for. That is, I think, live streaming this case. So yeah, so we're just gonna hang on and hang tight to see if they come back. So um I'm going to try to read a little bit the synopsis of this case, so we at least know what the case is about. I know probably some of you guys already know what it is, but for others that are listening and lurking, you guys can know what it is. We are going to, like, again, jump into this case like halfway through, not even like almost all done. But we'll be here for it. It's gonna be good. I need to keep checking this, and if you have any like Colorado cases, let me know, because that's probably gonna be our base state because of this feed thing that I know that it is there. So yeah. Um I was not looking at the guy, but well, I cannot go back. That's the thing with this. We do need to watch it live. We sadly cannot pause, go back or anything because it's a WebEx stream. So, but probably was. He's just tired. Um, I think you are. I'm so sorry. Can I scroll back on WebEx? I don't think you can. This is on WebEx, Kara. I don't know if you can. I cannot figure it out how to do it. Sorry, my apologies. Um, but oh wait, I can scroll back on my own stream. Hang on. Duh, I'm such a dum dum. Don't forget, I'm having one of those days. See, I'm still waking up and getting over. I don't know. Hang on. Let me go back. Let me go back. Oh yeah, I think I saw it. Hang on. It was Kara. It was. It was. Oh, it was picking his nose. If you go back on my stream, right? Because I have a feed on my stream there just to make sure everything is working and operational. Um, he does kind of picks up his nose, but the microphone is right where his nose is, so he didn't really like. Oh, oh, I need to tell you which side it is, girl. I'll tell you in Discord. I like yeah. Oh, I yeah. So this case, we are in Jefferson County, Colorado. It's Joseph. I don't like the last name. I'm gonna butcher it. It's fine. Um, Koenig is on trial for on charges that he unalived a young woman by throwing a rock at her car, smashing her windshield. So now I'm gonna give you a head. If you have the Amazon Assistant in your home, I would give you the idea of maybe muting it because the victim's name in this case is the name of that device, and I don't want to be setting yours off. I know I'm already going to set mine one off, by telling by saying the name, but yeah, just a warning because then I can set put stuff on your shopping lists. No, I'm joking. I'm not gonna do that. But the name of this witness is Alexa. So and now probably all your Alexis just went bing. So Joseph is charged with first degree. Mornings, Lizzie. Hello. Sorry, I am early. I am a bad girl. I know. I went early, live early. But I yeah. Hello. Good to see you. It's nice to see you. I missed you, everybody, yesterday, by the way. I was in and out of chat, but um I was so tired and it was so much going on that I needed a day off. But I'm back today and you don't get rid of me that easily. So this is the feed for our new trial that we are waiting on to start. I don't know which day we are. Uh what? I don't fit in the circle? What circle? Huh? I'm confused. You always fit in a circle. You are the center of the circle. We can be doing being here without you. Um so yeah, hang on, sorry. Garden bot is texting me that which candy that I want. I want strawberry pencils. Hang on. I'm texting. Stop texting me back. Garden bot. Okay. So there's people joining the WebEx thing. Sorry. Do we know the I do not know. Oh, but time zone circles. Yeah, no, sorry. But you're here early. So hey. Um do we know? I don't know. I have absolutely no clue, Kara. So it's just hang on. Oh, garden bot is getting me some sweet watermelon slices then. I don't know. I'm assuming the fence because that's normal the side where the defense sits closer to the jury, or I don't know, I just me guessing, I don't know. Um so I'm in no time zone. Hannah, we both in England, we are both in the crazy time zone. Oh yeah, and I appreciate you are around a lot. That's great, and I know you are in AS a lot as well, which is amazing. She's a great creator. Um, So yes, Hannah is in my time zone. So for me and Hannah right now is 5 minutes to 3 p.m. So hey, we are in the same time zone, which is cool, which is really really cool. Um, like I was saying, Joseph is accused of first degree unaliving, attempted unaliving, second degree assault, second degree assault in connection with the 2023 death of Alexa Bartell. Bartell was unalived on April 19th, 2023, when a large landscaping rock crushed through her windshield as she was driving in Jefferson County. So, hello, Maria. Don't go to work. We are saying there's gonna be a busy work today, so just stay home. That's what we're foreseeing from the future. Stay and hang out with us. Um, this court looks really good. I just hope that the sound is as good as the courtroom looks, which would be interesting. I don't know which day we are on. I don't know which case we are on. Coming at you from the future. Yes, this is that's us. Um, so I don't know if we are in the prosecution case in chief. I don't know if we are on the defense case in chief. I think we're gonna figure it out together. The information that there was about this case was not a lot, but then I do have the opening statements, but we like to be able to watch this live. We need to watch this live because we cannot go. It's not a recording. This is just a live stream. There is online, and then after the day is finished, the live stream is gone forever. So we have to do it. I was thinking that during verdict watch, if they do go verdict watch today, we can watch all of the information that I have about the coverage of this case and then go from there, obviously. So it's just something that I found, and it's actually a good case that I had several people reaching out to me asking to cover, but there was not really. There is a way of doing this, but yeah, no, court is not started yet. It is empty. Sound is not on yet. Yeah, I think they might still only start it for another couple of minutes, and everyone coming in late. I don't know. Um, I like I said, on the system on the court docket, it was started. The start was at 8 a.m., which is in about 2 minutes. So yeah, exactly. Probably is not gonna start on time. Probably because I've seen that like on the docket says 8 a.m., but I seen the information somewhere else that says that started at half 8. So we might either have half an hour or 2 minutes for the starting to the court. So yeah, sorry, it's not very well organized, but it's not really up to me sometimes, the organization of the court. So my apologies in advance for this. But I honestly, it is something different than Karen Reid. So it's just trying to provide something a little bit different for those that of us that are not really interested in the case. But don't get me wrong, it's spicy over there. So oh, the lady is, and I think that's the defense table. I am not sure because then again, it's Colorado. There's no documents. There's no nothing, no information or whatsoever. So it's, I think there where the like the microphone. Let me see if you guys can see my mouse on the screen. No, you can't. So I think it is. I'm not sure. They do have a lot of boxes behind them. That is for sure. They maybe be building a box fort out of them, like Daryl Brooks did. So yeah. Ooh. No, yeah, no, I was wrong. So that's our defendant there. They just got in with the solo person that was at the desk, the nose picker. That is the defendant next to him. Oh, actually, I completely forgot to do something. Hang on, let me try to see if I can do something. Yeah, so the solo pick, the nose picker, is the defense attorney. See, we're figuring out things. We got this. I actually forgot to download something that someone suggested me to do it, so I can do it. But I forgot. Let me see if I can try to do this before court starts. Yes, I know. I know. I want to add extension. There we go. I think it's added. I consent to whatever it is. Um, where is it? Oh, here. I want to pin it. There we go. So, one second, guys. Sorry, everybody. Sorry about that. Garden Bot just got home. I heard testimony of the cop smacking of between Ward saying that they were trying to put the crime on her, and wow, that's crazy. Oh no, no worries, Izzy. Like, wait, we're trying all to figure it out together about this case. So no one is wrong, no one is right. It's just it is what it is. So now let me try. I'm gonna minimize this one because I want to try something. Aha. So this is our defendant. I think you can see. I found this Roba has this extension thing that she was using yesterday. I saw she using it, and I loved it. So I was like, I need that because that's going to be a great addition to the stream. So oh, I'm wrong all the time. So girl, don't you worry about that. I'm like literally 99% of the time I'm wrong. So I think the court is gonna be an empty courtroom today because literally is empty to to the bones. Sorry, 1 second again. Hold, please hold. Sorry. Pronounce his name Koenig or Kane. I don't know. I don't know. I absolutely have no clue. But I think we're gonna hear when the judge calls the case, maybe. Which they are behind, obviously, because it's 2 minutes past 8 o'clock in the morning. It's actually quite early, for court to start 8 o'clock in the morning. To be fair, I'm not gonna lie. Um, plus s yeah. um but I do like that it is extension. Like, I'm not gonna, oh, I can use it again. Look, is it, can I, where is it? I'm pressing it, but it's not working. Oh, come on, don't stop working, extension. You were so handy. Okay, that side is working, this side is working, but on this side that I need it is not working. Really? Let me see if by zooming out or by, okay, because I was, so this is the defendant. It's on the screen. I highlighted. That's him. That's Joseph. The case that we are starting halfway through. So yeah. Um Oh yeah, exactly. We're here for this, obviously. Beliefs are always 109 years old. Absolutely. Oh, that is hilarious. Yeah. Oh my days. I missed you all yesterday. Yeah, so the judge better be nice to us. I hope so too. Like, I hope he understands that we are very late to this case. We are very late to the party. And we definitely need that to have a little bit of leniency in terms when it comes. Oh, snacks. I want snacks. I don't know if Garden Bot got me my snacks. Oh, I forgot. Why is it? Good thing that I keep my vitamins in my desk because every single day in the morning I forget to take them. I look over and I just saw them and I remember I need to take them. Good morning, William. Buenos dias, my friend. You made it, and it's Thursday. Happy Thursday, friend. I hope you are having a smashing week. My week is getting better, that is for sure. I sadly did not go today to my sister-in-law's to see the baby. I took the morning off to just relax, binge watch a show, and do some research about this case, about other stuff that's ongoing and other projects that I'm trying to work on. So I tried to take a day for that and just, do my own stuff. I do miss baby girl a lot. But she's growing. She's well. I did check in with my sister-in-law. She did had a good night. So, oh, judge, I think he's coming into chambers because everyone is getting up. We might have a sound soon. Hopefully. Let me see. Oh, that's the judge. I don't have
Good
sound
morning.
yet.
23 CR 1034, People versus Joseph Koenig. Entries.
Catherine Decker and Bryn Chase for the people, with investigator Daniel Manka. Our paralegal Leticia Moda will be joining us. We're also here with Kevin McReynolds to address jury instructions this morning.
Good morning.
Martin Stewart and Tom Ward on behalf of Joe Koenig.
Good morning. Well, as mentioned, we're set for closings a little bit later this morning. We finalized some jury instructions. And after the conference, we incorporated the edits discussed on the record, did one more read through, found a couple of things to, no major modifications then, but there were a few typos and things like that that we corrected, namely places where the lesser includeds, the introductory paragraph didn't mention all of them. Couple of erroneous the word this in front of the description of the principal versus complicitor instructions, had a few of those we eliminated. And then in one or two places, the defense proffered language about directing the jury that they don't have to consider the lead charge first. We deleted that remained in a couple places, and we took that out pursuant to the court's prior ruling. So I had intended to try to get those to you last night, and what I would call technical error, but others would probably say user error, kept me from doing that once they were finalized. So you have them this morning, and anything else you want to discuss with regard to jury instructions?
I'm going through them, Your Honor. I've found one potential typo issue with regard to instruction number 31, which is one of our complicity for lesser includeds in that one iteration. So the intro paragraph from the model instruction, complicity is not a separate charge, but a legal theory, is omitted from just that one of this series. So for consistency, the people would ask that be inserted as it is in the other lesser complicities.
Okay. Any position on that from the defense, acknowledging the defense's prior objection stated to that introductory line?
Yes, Your Honor. I mean, no objection to making that change to keep them uniform.
Okay, thank you. Any others?
I'm up to the verdict forms, but I have not seen any other things that varied from my notes from yesterday's conference.
We will make the change on 31. We can just wait while everyone's completing review and
Right. So now that while they're finalized, I'm going to be talking in and out because
as we're doing that, have you all tested out the technology this morning? I know Bruce was in here to make sure everything seemed to be working. You're welcome to try to check out your connections if you'd like.
Yes, please, Your Honor.
We've done it already. Thank you.
Okay.
Seems to work.
Yep.
Shall I just stay plugged in?
That's fine.
Very quickly before the judge talks, but I thought
So I
maybe
think our plan will be
I was not fast enough.
read the instructions. I expect that to take a while. Short break, people's closing, probably short break, then defense closing, and then any rebuttal.
And would the court mind giving the people, I'm doing first closing notice when I've reached 45 minutes?
Sure. So 15 left.
Yes.
Okay, got you.
And also, should we discuss the alternate juror, who that is? I believe the court said they were 5 and 9, so perhaps 9's the one who's excused.
We should. Thank you. Would you like a warning before I forget to ask?
Nope.
Okay. Um, Our juror who will be excused, I have as juror who was in seat number 9, that would be Mr. Olson. The first in place at seat number 5 is now incorporated into the jury. Any disagreement on that?
No, Your Honor.
Agreed.
The people have finished the review. That was the only edit. Obviously, the people stand on their prior objections regarding the conference, but other than that, I did not see anything.
Great. Thank you all for that final read through. Anything else on your end?
I haven't seen anything.
Okay. We ready to break? Okay. And again, just a reminder, we'll FTR the reading of the instructions. I don't plan to say anything in advance other than I'm about to read the instructions or maybe give an outline of what the morning looks like generally. So any objection if I tell Rhonda she doesn't need to sit in court for that session once we begin at 8:30 and send for the jury. We'll just do that on FTR.
No objection.
Objection from defense.
Okay, great. Okay, see you all at 8:30.
All right, so court is on break for the next 15 minutes, which is okay. That gives us time to talk about this case. I mean, we can. What I was gonna say is, during the breaks and during like lunch and the verdict watch, we're gonna be able to know a bit more about this case. Hi, Bianca. Good morning. Hi, welcome in. Let me just grab a Anna. Oh, I'm gonna butcher your name. I'm so sorry, Anna. Anne. I'm gonna just say Anne before I mispronounce big time the last name. Hello, Anne. I am waving behind the camera. Apologies for the camera today. But yeah, welcome in everybody. We caught this case literally yesterday. Today is the first day we are streaming it. Because it was like literally a last minute case that we found out about. They are going to be doing closings today and the jury instructions. Normally we never do jury instructions in this channel, but because it's a new case, they can give you an idea of like the charges that he's facing and everything. And then we're gonna have closings and verdict watch. My plan was, and let me know if you guys agree, obviously, is that during that verdict watch that we're gonna have today, we can watch the coverage that has been on this case on this case from Court TV. So there is quite a few videos on that are available. There's like little snippets that they've been able to gather. From this case, but I do feel bad that we did not found this case sooner. I honestly I am upset at myself that that I did not found this case before today or before yesterday, and then we had to wait. But we are here for it no matter what, and gonna still watch the closings. Courtroom is pretty empty today. I mean, it's yeah, it's not good looking for like it. There's a few people scattered out in the back there, towards the wall behind the prosecution stable, but that is pretty much it. There's not much more people in there. So yeah, welcome back everybody. So yeah, I mean, I can read the a news article that is about this case, and then we can go from there, and that should be for the judge to come back. So I read earlier the charges. The charges are first degree red rum, attempted red rum, second degree assault, attempted second degree assault. This happened in 2023, in April 19, 2023. So almost 2 years ago, or if 2 years ago more. So and then the article says that approximately a week before the Alexa Bartell's death and arriving, police arrested Joseph, as well as Zachary Kowak and Nicholas Carroll Chick. That's the two other defendants that are involved in this case. Both Kowak and Carroll pleaded guilty, accepting deals with the prosecution that require them to testify against Joseph. So we definitely need to catch up that testimony there. Hello, Anne. Good morning, everyone. I hope you are okay today. Happy Thursday. We are nearly the end of the week. It is good. It is gorgeous. That is almost the weekend. We can all relax and put our feet up and have a good time. So one of the co-defendants, Kowak, described what happened that day, saying that they had gathered the landscaping rocks from a median area along the road in the local area. At some point, Kowak said that Carol Chick and Joseph began throwing rocks at stationary cars, describing Joseph as throwing with his dominant left hand and shot put style. Then Kowak and Carroll face potential sentences up to 32 and 72 years respectively, and when they are sentenced. So they haven't been sentenced. They so there is the testimony from them in videos that we are going to be watching while on verdict watch, but we're going to be able to hear as well the closings. Closings obviously will give us a bit more of the insight and what happened during the trial that sadly we did not yeah. Um Oh, hi, Bianca. I absolutely love your accent. So gorgeous. Much love on my Thursday evening. Oh, wow. You're in Australia. That's amazing. I'm over in England, but I'm originally from Portugal. So, hi. Good. Oh, my days from Australia. I would love to go there, but time zones and the fact like sometimes it impresses me that the seasons are different than ours, and I found that amazing and very very interested. But thank you very much for joining in. It's very nice to meet you and good to see you as well, Bianca and everyone. Good morning. I vamos buenos dias, my friend. Hi. Well, I'm waving behind the screen. You so oh wow. Oh, it's oh my days, it's Friday already. So happy Friday for you, Bianca, from the future. See, Maria, there's someone even further from the future here than me and Hannah from UK. So there's still someone further ahead than us. See, we're not just us. So yeah, so during the verdict watch, um we're gonna watch the videos, which I think is gonna be rather interesting, and then we can have our own assumptions. But at least we have two of the key witnesses testimony um, about um, about this, and also there is also a someone that was with the victim because I don't know. I'm really interested. I'm so sad that oh, I'm so sorry, Ivamos. I am having a day off camera today, and I apologize for that. It's just my zombiness. It's not looking good, and not even makeup would fix that. So, yeah, absolutely. So, yeah, I know another friend from the future. I love that. I absolutely love that. So, absolutely, thank you very much for that, Susie. It does help the channel a lot, and also share with friends, like friends that like true crime and everything. Share the channel out. Obviously, like invite people over to see if they like the vibes, and yeah, I hope they do and they stay. Um, William, I Ramos. Um, Well, we'll definitely see. Oh, nice. Oh, we are on a big screen. Nice. That's awesome. And we definitely you're a coffee drinker. You're gonna fit right in. I love coffee. My middle name is Coffee. I drink about 4 coffees a day, and I cannot live without it. I literally am hooked on coffee. I'm addicted to coffee and true crime. So I think you are in the right space. I am waving to you. I normally have my camera on, but it's just today that I'm having an off day. I will be back tomorrow. Um, that is my best joke to my American mate. So funny, yeah. So, oh, I'll yes, definitely. I will have definitely some coffee for sure. Even though I've already had 3 coffees today, I definitely need another one. Hey, Theo. Hello. Good morning, my friend. I've already talked to you anyway, but good morning. How hope. Oh, there's more people coming. Oh, see now the courtroom is getting full, guys. Look at that. Oh, is that a baby? Oh no, my brain is literally um turned right now. Oh, are you dropping more coffee? Nice. Oh, thank you very much for that, Bianca. I really, really appreciate it. Coffee and morning waves to everybody. Thank you. I really appreciate it. Feel free to ask any questions, or just reach out. I absolutely love it. Um, I think she did, Anna. I think she did smelt the coffee from all the way from where Zio is. Is it good? Is it Portuguese or is it Colombian coffee? I want to know. So what's gonna happen next? When they come back, I think they're gonna go to jury instructions, which I know it's gonna be a little bit boring. We normally don't do them, but it's gonna give us a bit of an insight on a case. And then they're gonna have a short break, and then it's gonna be the prosecution's 45 minutes first of the closings, and then another break, and then defense closings, and then another break, the rebuttal, and then after that, either they go into the deliberations straight away, or they go to lunch and then deliberations, or they just do go straight into deliberations. I don't know a lot about this case, but I'm assuming that it's not going to be a long deliberation, because I think this only started the other day, like 2 days or something. So it hasn't been a long case. So I don't think deliberations is going to be that long, which, yeah. So it's not going to be a long one. Ooh, Cafe de Ola. I don't know that coffee, but I need to know. Um, oh no, that's fine, Bianca. Neither are we. We literally just picked up this. Oh no, it's absolutely fine. You don't need, like, we can explain, give you a little bit of an overview of the case, which is absolutely fine. And then there's a smell as well on the description, about it. But don't worry, absolutely none of us have know much of this, because I literally just found out this case yesterday. So we the thing is, like, I'm doing this case today kind of to because I really wanted to hang out with you guys, so I needed something to watch. And Karen Reid is one of the trials that I'm not really super interested. So and I'm expecting that on Monday we're gonna have new cases started. So yeah. Yeah, Hannah says, I found this case last night and was researching it, and Katya read my mind and decided to stream it. Exactly, I did. I absolutely did. I absolutely did that, because we are in the same country. I can read her mind quicker. So, so oh yeah, so exactly. We are here to help each other out, to just, yeah. But never be embarrassed. Exactly, Zizi is correct. Never be embarrassed to ask anything. We are here to help you. We are here to help each other out. So yeah. Hey, good morning, Rava. Hello. Thank you. Like, literally, you need to sleep, girl. You have done amazing. Thank you very much, Robert, for your help. That well, we try, so it sounds like oh, sorry. I did say it incorrectly. Oh, see, the courtroom is getting packed now. It's getting full. I think people were only starting to get there to actually the 7:30 start, and not the 8 o'clock that they had to simmer down the jury instructions to finalize those for the day. Like I was saying, I don't think the verdict watch on this one is going to be very long, because it was not a long case. I think it was like a what, 2-day case. I Let me see, when is this article from? It can't be from. It can't be from 18th of April. Surely not. Hang on, let me have a look. 1 second. Trying to find a bit more. I should have seen when this started, but court records only guard docket, sorry, only gave me so much information about this case. Oh, 5 days ago, apparently. So this case started about 5 days ago. It seems so. I don't think it's going to be that bad in terms of verdict watches. I don't know. So, oh no, it's absolutely fine. Do not worry. It's absolutely fine. We're here to help each other out, Bianca, and you can always as many questions as you want. Um, so many on the descendants or defendants? No, like the one with the white top is the prosecution side. The side that has a lot of people, that's the prosecution side. The defendant side, I think it has like, I can see two heads behind the chair. I think, I don't know. So because this, the chair that is closer to us, I need to use the magnifying glass. Hang on. Oh, okay. Sorry. See, this is what another thing. My English is not 100%, so I don't know sometimes the meanings of words. So people have to help me. So, yeah, I appreciate it. Thank you very much. That descendant, it means victims. So yes, there's a lot of people in the victim side, which is good, because it was a horrible situation, that a very sad horrible situation. So yeah, um that yeah, thank you for the correction, guys. I absolutely love it. So yeah, appreciate that you guys help me out. So that does say a lot, lack of support, but we'll see. Well, yeah, we'll see. Oh, actually, no, I was just looking. There's some people coming in on the defendant side. It might be family. I think it might be parents or anything, because I think he's only 20 years old, because he was 18 when he got arrested in 2023. So he's very young. He was literally in his teens. It was, yeah, this happened in April 23, so he was 18 at the time. So I think he is around 20 years old right now. So it's not um yeah, it's a very sad case. I mean, it's absolutely horrible. I think now more people are coming in, and yeah, sorry, I just got a notification that, ooh, Donna Alderson has a hearing on the 30th of April. I need to keep that put that on the calendar. So if we can watch it, that hearing of Donna Alderson, because that's a case that we are going to be following later in the year in here, because the Adelson saga, my days, we need to keep an eye on that one. That is for sure. It is the case to watch indeed, because I think Wendy is going to be next. I hope Wendy is going to be next to go to jail. I know. I just hope we know, William, that the courtroom fixes the audio issues. So, oh, Zizi, thank you for the reminder. I completely forgot about that, because you did the amazing work. Let me pull up the information. So, our lovely Zizi was, she's amazing. We already knew that, right, guys? So, I know about the snafu, and I was trying to help Robert last night with the snafu of the court that happened, that the hearing got cut short. So, Zizi was great and did some investigation and got us some information about this. So, what is the result that the judge said, and I'm going to read from the information that I got, it is they will issue a written ruling on the three motions that was filed by the defense: the motion to delay, the motion to suppress the cell phone history, and the motion to suppress investigate the interrogation video. All the motions must be filed by the 30th of June 2025, and the trial has been delayed to the 14th of July of 25. So yeah, we definitely need to keep that an eye on that fuzz as well. It's gonna go on a calendar to remind me of that, because that's definitely something to do. So we are just waiting now for the judge to get back. He did say he was gonna come back at half past, which is now, but we'll see exactly what happens, because I know it's gonna be they're never going to be on time. We already been here for half, not even half a day, a couple minutes, and they've already been late. So yeah. Oh, I completely agree, because I think most of the stuff that, at least for this trial, because this is the CSAM trial that we are talking about, this first trial that he's facing, the Stephen Stearns case, is the CSAM trial. And if that's that even if the interrogation video gets tossed out, I think it's going to be sadly helping him too much, unless Jennifer steps up and talks about it, say something about it. So yeah. We'll see what happens. Hopefully, it won't, because the last motion that he wanted was to stop the media from out of his trial. Yeah, it got denied. So hopefully, this will be denied. I don't see the judge. I don't see any problem of that coming into the trial. Uh, the cell phone history was also very, yeah. So I hope that they keep it. Um, yeah, exactly. I agree with you. Anna says that in her opinion, the judge will deny the motions. Is just entertain the defense for appeal purposes in the future, and absolutely they have to. And I guess in a way, it's Stephen's constitutional right to be heard and having a hearing on this. Yes, it does suck in a way that the trial is delayed yet again for about with all of this, but justice will be served for Madeline. She will get the justice that she deserves. Absolutely, I am hoping, and I am oh my days, I am hoping that she does definitely get the justice that girl deserves. So uh yeah. But anyway, with this case, I don't know, what do you guys think? I know we are just doing the closings and the verdict watch. Oh, judge is coming in, everybody. Please stand. uh please stand as well. The judge is coming. We are about to start the day with the jury instructions. Oh, I was gonna say, where did I go? I'm in the top corner. I forgot that I put myself in the top corner. Oh my days, I need to find. Here you go.
Good morning again, 23 CR 1034. Looks like we're ready for the jury.
Yes, Your Honor.
Right, jury is coming in. We are ready for the day to start. Let me know just if the sound is any good when they start talking again, not me. So obviously I can try to see if I can do anything about it from my end. So yeah. Um but yeah, just let me know. Yes. So this guy was pitching huge rocks into cars from the side of the highway. His accomplice already had his day in court. Both of his co-defendants have already pled guilty. And the deal that they got, again, Colorado does a lot of deals apparently. Oh, jury's coming in. Is that they had to testify against him in the trial because apparently he was the one actually throwing the rocks and the other guys were just standing there. So in a way they didn't had a lot of involvement. He actually did commit the crime. Joseph committed the crime. So that's what I get from the case. Joseph is the
Please
main
be
guy.
seated. Welcome back. Good morning, members of the jury. Members of the jury, at this time, I will read to you the jury instructions. Then we'll take a short break, and then we'll begin with the closing arguments. Instruction number 1. Members of the jury, the evidence in this case has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you to the jury room, but first, I want to mention a few things you need to keep in mind when you are discussing this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. You must not communicate in any way with anyone else about the case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have a cell phone or other electronic device, you must keep it turned off during jury deliberations. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During the trial, you received all of the evidence that you may properly consider in deciding the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. You should not allow bias or any kind of prejudice based upon gender to influence your decision. You must also not be biased for or against the defendant, any witness, or any other party based on any identifying characteristics such as race, religion, age, gender, gender identity, gender expression, sexual orientation, ethnicity, national origin, disability, socioeconomic status, or any other such characteristic. You must not allow bias to influence your verdict. Remember that you must also guard against unconscious bias, also called implicit bias. Unconscious biases are stereotypes, perceptions, attitudes, or preferences that people may hold without being aware of them. Such biases can affect how we evaluate information and make decisions. You must not allow unconscious bias to influence your verdict. One way to guard against unconscious bias is to ask yourself during your deliberations whether your views and conclusions would be different if the defendant or the witnesses were of a different race, religion, age, gender, gender identity, gender expression, sexual orientation, ethnicity, national origin, disability, socioeconomic status, or any other such characteristic. If the answer is yes, then you should reconsider your views and conclusions along with the other jurors and make sure that your decision is based on the evidence and not on any such stereotypes, perceptions, attitudes, or preferences. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Finally, You should consider all the evidence in light of your experience in life. Instruction number 2. The charges against Joseph Koenig are not evidence. The charges against him are just accusations. The fact that he has been accused is not evidence that he committed any crime. Joseph Koenig is charged with committing the crimes of murder in the first degree, criminal attempt to commit murder in the first degree, assault in the second degree, and criminal attempt to commit assault in the second degree in Jefferson County, Colorado, on or about April 19th, 2023. Criminal attempt to commit murder in the first degree and criminal attempt to commit assault in the second degree in Jefferson County, Colorado, on or about April 1st, 2023. And criminal attempt to commit murder in the first degree and criminal attempt to commit assault in the second degree in Jefferson County, Colorado, on or about February 25th, 2023. Joseph Koenig has pleaded not guilty. Instruction number 3. Every person charged with a crime is presumed innocent. This presumption of innocence remains with Joseph Koenig throughout the trial and should be given effect by you unless, after considering all the evidence, you are convinced that Joseph Koenig is guilty beyond a reasonable doubt. The burden of proof in this case is upon the prosecution. The prosecution must prove to the satisfaction of the jury beyond a reasonable doubt the existence of each and every element necessary to constitute the crime charged. This burden requires more than proof that something is highly probable, but it does not require proof with absolute certainty. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. After considering all the evidence, if you decide the prosecution has proven each of the elements of a crime charged beyond a reasonable doubt, you should find Joseph Koenig guilty of that crime. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements of a crime charged beyond a reasonable doubt, you should find Joseph Koenig not guilty of that crime. Instruction number 4. In this case, a separate offense is charged against Joseph Koenig in each count of the information. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find Joseph Koenig guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against him. Joseph Koenig may be found guilty or not guilty of any one or all of the offenses charged. Instruction number 5. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice Joseph Koenig. It is not evidence, does not prove anything, and must not be considered for any purpose. Instruction number 6. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that he looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Instruction number 7. You are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case, and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Instruction number 8. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight you give the testimony is entirely your decision. Instruction number 9. During this trial, you were permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror is not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making your decision, you must consider all of the evidence that has been presented. Instruction number 10. Defendant Carol Chicks and Defendant Kwok's guilty pleas in their cases may be used to assess their credibility as witnesses and their acknowledgement of their participation in the offenses. Their guilty pleas may not form the basis of any inference of Defendant Koenig's guilt. Instruction number 11. The number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove that fact. Instruction number 12. The court admitted certain evidence for a limited purpose. You are again instructed that you cannot consider the evidence. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. Instruction number 13. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. Voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Instruction number 14. The prosecution alleges that the defendant is guilty of the crime of murder in the first degree, extreme indifference, as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 15 describes the principal theory of liability, and Instruction 16 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability, and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 15. The elements of the crime of count 1, murder in the first degree, extreme indifference are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, under circumstances evidencing an attitude of universal malice manifesting extreme indifference to the value of human life generally, 4, knowingly, 5, engaged in conduct which created a grave risk of death to a person or persons other than himself, and 6, thereby caused the death of another. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree, extreme indifference. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree, extreme indifference. Instruction number 16. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the crime of murder in the first degree, extreme indifference, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person committed the crime of murder in the first degree, extreme indifference, as defined at the end of this instruction. And 2, the defendant, with the desire or purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4, the defendant was aware of element numbers 1, 2, 3, 4, and 5 of that crime as defined at the end of this instruction. For purposes of this instruction, another person committed the crime of murder in the first degree, extreme indifference, if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person, 2, in the state of Colorado at or about the date and place at issue, 3, under circumstances evidencing an attitude of universal malice manifesting extreme indifference to the value of human life generally, 4, knowingly, 5, engaged in conduct which created a grave risk of death to a person or persons other than himself, and 6, thereby caused the death of another. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree, extreme indifference. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree, extreme indifference. Instruction number 17. The offense of murder in the first degree, extreme indifference, as charged in the information in this case necessarily includes the lesser offenses of murder in the second degree and reckless manslaughter. The prosecution alleges that the defendant is guilty of the lesser included offense of murder in the second degree and reckless manslaughter as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 18 describes the principal theory of liability for the lesser included offenses, and Instruction 19 describes the complicity theory of liability for the lesser included offenses. You should consider the theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability, or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 18. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of murder in the first degree extreme indifference, as charged in the information in this case, necessarily includes the lesser offenses of murder in the second degree and reckless manslaughter. The elements of the lesser included offense of murder in the second degree are: 1. That the defendant; 2. In the state of Colorado at or about the date and place charged; 3. Knowingly; 4. Caused the death of another person. The elements of the lesser included offense of reckless manslaughter are: 1. That the defendant; 2. In the state of Colorado at or about the date and place charged; 3. Recklessly; 4. Caused the death of another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the crime charged and one or more elements of the lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in your verdict. While you may find the defendant not guilty of the crimes charged and the lesser included offenses, you may not find the defendant guilty of more than one of the following offenses: murder in the first degree, or murder in the second degree, or reckless manslaughter. Instruction number 19. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the lesser included offense of murder in the second degree, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of murder in the second degree as defined at the end of this instruction. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, and 3 of that crime as defined at the end of this instruction. For purposes of this instruction, another person committed the crime of murder in the second degree if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person; 2. In the state of Colorado at or about the date and place at issue; 3. Knowingly; 4. Caused the death of another. For the defendant to be guilty as a complicitor of the lesser included offense of reckless manslaughter, the prosecution must prove the following elements beyond a reasonable doubt. 1. Another person committed the crime of reckless manslaughter as defined in this instruction below. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, and 3 of that crime as defined in this instruction below. Another person committed the crime of reckless manslaughter if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person; 2. In the state of Colorado at or about the date and place charged; 3. Recklessly; 4. Caused the death of another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the crime charged and one or more elements of the lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in your verdict. While you may find the defendant not guilty of the crimes charged and the lesser included offenses, you may not find the defendant guilty of more than one of the following offenses: murder in the first degree, or murder in the second degree, or reckless manslaughter. Instruction number 20. The prosecution alleges that the defendant is guilty of the crime of attempt to commit murder in the first degree, extreme indifference, counts 2, 3, 4, 5, 6, 7, 14, 16, and 17, as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 21 describes the principal theory of liability, and Instruction 22 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability, or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 21. The elements of the crimes of count 2, 3, 4, 5, 6, 7, 14, 16, and 17, attempt to commit murder in the first degree extreme indifference are: 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Engaged in conduct constituting a substantial step toward the commission of murder in the first degree extreme indifference as described in Instruction 15. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of attempt to commit murder in the first degree extreme indifference. After considering the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of attempt to commit murder in the first degree extreme indifference. Instruction number 22. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the crime of attempt to commit murder in the first degree extreme indifference, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of attempt to commit murder in the first degree extreme indifference, as defined at the end of this instruction. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of all of the elements of that crime as defined at the end of this instruction. For the purposes of this instruction, another person committed the crime of attempt to commit murder in the first degree extreme indifference if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person, 2. In the state of Colorado at or about the date and place at issue, 3. Knowingly, 4. Engaged in conduct constituting a substantial step toward the commission of murder in the first degree extreme indifference, as described in Instruction 15. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of attempt to commit murder in the first degree extreme indifference. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of attempt to commit murder in the first degree extreme indifference. Instruction number 23. The offense of attempt to commit murder in the first degree extreme indifference, as charged in the information in this case, necessarily includes the lesser offenses of attempt to commit murder in the second degree, attempt to commit reckless manslaughter, and reckless endangerment. The prosecution alleges that the defendant is guilty of the lesser included offenses of attempt to commit murder in the second degree, attempt to commit reckless manslaughter, and reckless endangerment as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 24 describes the principal theory of liability for each of these lesser included offenses, and Instruction 25 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 24. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of attempt to commit murder in the first degree extreme indifference, as charged in the information in this case, necessarily includes the lesser offenses of attempt to commit murder in the second degree, attempt to commit reckless manslaughter, and reckless endangerment. The elements of the lesser included offense of attempt to commit murder in the second degree are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Engaged in conduct constituting a substantial step toward the commission of murder in the second degree. The elements of the lesser included offense of murder in the second degree are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Cause the death of another person. The elements of the lesser included offense of attempt to commit reckless manslaughter are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Recklessly, 4. Engaged in conduct constituting a substantial step toward the commission of reckless manslaughter. The elements of the lesser included offense of reckless manslaughter are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Recklessly, 4. Cause the death of another person. The elements of the lesser included offense of reckless endangerment are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Recklessly, 4. Engaged in conduct that created a substantial risk of serious bodily injury to another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the greater offense and one or more elements of the lesser included offenses, you must find the defendant not guilty, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in your verdict. You may find the defendant not guilty of the crime charged and all of the lesser included offenses. However, you cannot find the defendant guilty of more than one of the following offenses per charge or count: attempt to commit murder in the first degree, or attempt to commit second degree murder, or attempt to commit reckless manslaughter, or reckless endangerment. Instruction number 25. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the lesser included offense of attempt to commit murder in the second degree as defined in this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of attempt to commit murder in the second degree as defined at the end of this instruction. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of all of the elements of attempt to commit murder in the second degree as defined in this instruction. For purposes of this instruction, another person committed the lesser included offense of attempt to commit murder in the second degree if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person. 2. In the state of Colorado at or about the date and place at issue. 3. Knowingly. 4. Engaged in conduct constituting a substantial step toward murder in the second degree. The elements of the crime of murder in the second degree are 1. That the person. 2. In the state of Colorado at or about the date and place charged. 3. Knowingly. 4. Cause the death of another person. For the defendant to be guilty as a complicitor of the lesser included offense of attempt to commit reckless manslaughter, as defined in this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of attempt to commit reckless manslaughter, as defined at the end of this instruction. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of all of the elements of attempt to commit reckless manslaughter as defined in this instruction. For purposes of this instruction, another person committed the crime of attempt to commit reckless manslaughter if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person. 2. In the state of Colorado at or about the date and place charged. 3. Knowingly. 4. Engaged in conduct constituting a substantial step toward reckless manslaughter. The elements of the crime of reckless manslaughter are 1. The person. 2. In the state of Colorado at or about the date and place charged. 3. Recklessly. 4. Cause the death of another person. For the defendant to be guilty as a complicitor of the lesser included offense of reckless endangerment as defined in this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of reckless endangerment as defined in this instruction below. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, and 3 of the crime of reckless endangerment as defined in this instruction below. Another person committed the crime of reckless endangerment if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person. 2. In the state of Colorado at or about the date and place charged. 3. Recklessly. 4. Engaged in conduct that created a substantial risk of serious bodily injury to another person. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the crime charged and one or more elements of the lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in your verdict. While you may find the defendant not guilty of the crimes charged and the lesser included offenses, you may not find the defendant guilty of more than one of the following offenses: attempt to commit murder in the first degree, or attempt to commit murder in the second degree, or attempt to commit reckless manslaughter, or reckless endangerment. Instruction number 26. The prosecution alleges that the defendant is guilty of the crime of assault in the second degree, counts 8, 9, and 10, as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 27 describes the principal theory of liability, and Instruction 28 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 27. The elements of the crime of counts 8, 9, and 10, assault in the second degree, bodily injury with a deadly weapon, are 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. With intent, 4. To cause bodily injury to another person, 5. Cause such injury to any person, 6. By means of a deadly weapon. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, bodily injury with a deadly weapon. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, bodily injury with a deadly weapon. Instruction number 28. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the crime of assault in the second degree, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1. Another person committed the crime of assault in the second degree as defined at the end of this instruction. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, 3, 4, and 6 of that crime as defined at the end of this instruction. For purposes of this instruction, another person committed the crime of assault in the second degree if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person, 2. In the state of Colorado at or about the date and place at issue, 3. With intent, 4. To cause bodily injury to another person, 5. Cause such injury to any person, 6. By means of a deadly weapon. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree. Instruction 29. The offense of assault in the second degree, as charged in the information in this case, necessarily includes the lesser offenses of assault in the third degree and reckless endangerment. The prosecution alleges that the defendant is guilty of the lesser included offenses of third degree assault and reckless endangerment as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 30 describes the principal theory of liability for the lesser included offense, and Instruction 31 describes the complicity theory of liability for the lesser included offense. You should consider the two theories separately. your determination of whether the defendant is guilty of a lesser included offense as a principal should not affect your determination of whether the defendant is guilty of that crime as a complicitor. Similarly, your determination of whether the defendant is guilty of a lesser included offense as a complicitor should not affect your determination of whether the defendant is guilty of that crime as a principal. You may find the defendant not guilty of a lesser included offense under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of a lesser included offense as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 30. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charge of assault in the second degree, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The charged offense of assault in the second degree necessarily includes the lesser offenses of assault in the third degree and reckless endangerment. The elements of the lesser included offense of assault in the third degree are: 1, that the defendant; 2, in the state of Colorado at or about the date and place charged; 3, knowingly or recklessly; 4, caused bodily injury to another person. The elements of the lesser included offense of reckless endangerment are: 1, that the defendant; 2, in the state of Colorado at or about the date and place charged; 3, recklessly; 4, engaged in conduct that created a substantial risk of serious bodily injury to another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the charged offense and one or more elements of the lesser included offenses, you must find the defendant not guilty, and you should so state your verdict. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state your verdict. You may find the defendant not guilty of the crime charged and all of the lesser included offenses. However, you cannot find the defendant guilty of more than one of the following offenses per charge count: assault in the second degree, or assault in the third degree, or reckless endangerment. Instruction number 31. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. To find the defendant guilty as a complicitor of the lesser included offenses of third-degree assault or reckless endangerment, the prosecution must first prove certain elements beyond a reasonable doubt. For the defendant to be guilty as a complicitor of the lesser included offense of third-degree assault, the prosecution must prove the following elements beyond a reasonable doubt. 1, another person committed the crime of third-degree assault as defined in the instruction below. And 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4, the defendant was aware of element numbers 1, 2, and 3 of the crime of third-degree assault as defined in this instruction below. Another person committed the crime of third-degree assault if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person. 2, in the state of Colorado at or about the date and place charged. 3, knowingly or recklessly. 4, caused bodily injury to another person. For the defendant to be guilty as a complicitor of the lesser included offense of reckless endangerment, the prosecution must prove the following elements beyond a reasonable doubt. 1, another person committed the crime of reckless endangerment as defined in this instruction below. And 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4, the defendant was aware of element numbers 1, 2, and 3 of the crime of reckless endangerment as defined in this instruction below. Another person committed the crime of reckless endangerment if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person. 2, in the state of Colorado at or about the date and place charged. 3, recklessly. 4, engaged in conduct that created a substantial risk of serious bodily injury to another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the charged offense and one or more elements of the lesser included offenses as a complicitor, you must find the defendant not guilty and you should so state your verdict. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven as a complicitor and you should so state your verdict. You may find the defendant not guilty of the crime charged and of all of the lesser included offenses as a complicitor. However, you cannot find the defendant guilty as a complicitor of more than one of the following offenses per charge count: assault in the second degree, or assault in the third degree, or reckless endangerment. Instruction number 32. The prosecution alleges that the defendant is guilty of the crime of attempt to commit assault in the second degree. Counts 11, 12, 13, 15, 18, and 19, as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 33 describes the principal theory of liability, and Instruction 34 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether the defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether the defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 33. The elements of the crimes of counts 11, 12, 13, 15, 18, and 19, attempt to commit assault in the second degree, bodily injury with a deadly weapon, are: 1, that the defendant; 2, in the state of Colorado at or about the date and place charged; 3, with intent; 4, engaged in conduct constituting a substantial step toward the commission of assault in the second degree, as defined in Instruction 27. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of attempt to commit assault in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of attempt to commit assault in the second degree. Instruction number 34. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the crime of attempt to commit assault in the second degree, as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person committed the crime of attempt to commit assault in the second degree as defined at the end of this instruction, and 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing the crime. 3, aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4, the defendant was aware of all of the elements of that crime as defined at the end of this instruction. For purposes of this instruction, another person committed the crime of attempt to commit assault in the second degree if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person. 2, in the state of Colorado at or about the date and place at issue. 3, with intent. 4, engaged in conduct constituting a substantial step toward the commission of assault in the second degree as defined in Instruction 27. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of attempt to commit assault in the second degree. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of attempt to commit assault in the second degree. Instruction 35. The offense of attempt to commit assault in the second degree, as charged in the information in this case, necessarily includes the lesser offenses of attempt to commit assault in the third degree and reckless endangerment. The prosecution alleges that the defendant is guilty of the lesser included offense of attempt to commit third-degree assault and reckless endangerment as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 36 describes the principal theory of liability for the lesser included offenses, and Instruction 37 describes the complicity theory of liability for the lesser included offenses. You should consider the two theories separately. Your determination of whether the defendant is guilty of a lesser included offense as a principal should not affect your determination of whether the defendant is guilty of that crime as a complicitor. Similarly, your determination of whether the defendant is guilty of a lesser included offense as a complicitor should not affect your determination of whether the defendant is guilty of that crime as a principal. You may find the defendant not guilty of a lesser included offense under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of a lesser included offense as a principal, as a complicitor, or as both a principal and a complicitor. Instruction number 36. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charge of attempt to commit assault in the second degree, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The charged offense of attempt to commit assault in the second degree necessarily includes the lesser offenses of attempt to commit assault in the third degree and reckless endangerment. The elements of the lesser included offenses of attempt to commit assault in the third degree are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly or recklessly, 4, engaged in conduct constituting a substantial step toward the commission of assault in the third degree. The elements of the crime of assault in the third degree are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly or recklessly, 4, cause bodily injury to another person. The elements of the lesser included offense of reckless endangerment are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, recklessly, 4, engaged in conduct that created a substantial risk of serious bodily injury to another person. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the charged offense and one or more elements of the lesser included offenses, you must find the defendant not guilty and you should so state your verdict. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find the defendant guilty of the offense proven and you should so state your verdict. You may find the defendant not guilty of the crime charged and all of the lesser included offenses. However, you cannot find the defendant guilty of more than one of the following offenses per charge or count: attempt to commit assault in the second degree, or attempt to commit assault in the third degree, or reckless endangerment. Instruction number 37. Complicity is not a separate crime. Rather, it is a legal theory by which the defendant may be found guilty of a crime that was committed by another person. For the defendant to be guilty as a complicitor of the lesser included offense of attempt to commit third-degree assault, the prosecution must prove the following elements beyond a reasonable doubt. 1. Another person committed the crime of attempt to commit third-degree assault as defined in this instruction below, and 2. The defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, and 3 of the crime of attempt to commit third-degree assault as defined in this instruction below. Another person committed the crime of attempt to commit third-degree assault if the prosecution proves each of the following elements beyond a reasonable doubt. 1. That the other person. 2. In the state of Colorado at or about the date and place charged. 3. Knowingly or recklessly. 4. Engaged in conduct constituting a substantial step toward the commission of assault in the third degree. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. The elements of the crime of assault in the third degree are 1. The person. 2. In the state of Colorado at or about the date and place charged. 3. Knowingly or recklessly. 4. Caused bodily injury to another person. For the defendant to be guilty as a complicitor of the lesser included offense of reckless endangerment, the prosecution must prove the following elements beyond a reasonable doubt. 1. Another person committed the crime of reckless endangerment as defined in this instruction below. And 2. The defendant, with the desire or the purpose or design to aid, abet, advise, or encourage the other person in planning or committing that crime. 3. Aided, abetted, advised, or encouraged the other person in planning or committing that crime. And 4. The defendant was aware of element numbers 1, 2, 3, and 4 of the crime of reckless endangerment as defined in this instruction below. The elements of reckless endangerment are 1. The person. 2. In the state of Colorado at or about the date and place charged. 3. Recklessly. 4. Engaged in conduct that created a substantial risk of serious bodily injury to another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the charged offense and one or more elements of the lesser included offenses as a complicitor, you must find the defendant not guilty, and you should so state your verdict. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged, or of a lesser included offense as a complicitor, you should find the defendant guilty of the offense proven, and you should so state your verdict. You may find the defendant not guilty of the crime charged and all of the lesser included offenses as a complicitor. However, you cannot find the defendant guilty as a complicitor of more than one of the following offenses per charge or count: attempt to commit assault in the second degree, or attempt to commit assault in the third degree, or reckless endangerment. Instruction number 38. If the defendant's criminal liability is based upon the behavior of another, it is no defense to the crimes of murder in the first degree, attempted murder in the first degree, assault in the second degree, attempted assault in the second degree, and the lesser included offenses of those charged crimes, that the other person has been convicted of different crimes. Instruction number 39. In this case, certain words and phrases have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in instructions that define crimes, defenses, special rules, and verdict questions. Act means bodily movement and includes words or possession of property. Bodily injury means physical pain illness, or any impairment of physical or mental condition. Deadly weapon means a knife, bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, that, in the manner it is used or intended to be used, is capable of producing death or serious bodily injury. Omission, omission means a failure to perform an act as to which a duty of performance is imposed by law. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Serious bodily injury means bodily injury that, either at the time of the actual injury or at a later time, involves a substantial risk of death, a substantial risk of serious permanent disfigurement, a substantial risk of protracted loss or impairment of the function of any part or organ of the body, or breaks, fractures, a penetrating knife or penetrating gunshot wound, or burns of the second or third degree. Universal malice means conduct evidencing a willingness to take human life indiscriminately. Instruction number 40. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. Instruction number 41. If there has been or is any news coverage of this case, you must completely disregard it. Your decision in this case must be made solely on the evidence presented at the trial. I have two final instructions. Those will be read following the closing arguments by the attorneys. Let's take our short break, about 10 minutes. We'll see you soon. Remember, still, do not discuss the case amongst yourselves. Do not do any form of independent investigation or research. Have a nice break.
All right, so 10-minute break. Finally, see, we did it, guys. We survived the jury instructions. It's all right, no worries. Thank you very much for hanging out. Speak to you soon. See you soon, Zizi. So now that we have 10 minutes to literally
Please be
hang
seated.
out. Oh, we'll see.
We'll break
if
as well.
The judge. The judge is gonna
Is the
break.
court intend on reading the verdict forms?
What? Yes, we did.
Let's talk after we have our reporter. After closings is the short answer.
Okay.
All right, so court is on a short break. So what I'm gonna do is I'm gonna try and play a video that is about 9 minutes. That is some testimony of this case. It might have ads in the middle, but I'll try to skip those. Let me just share this tab instead. Where is it? There. Put this bigger. There we go. And we're gonna watch just some testimony. This, I forgot what this is. This is the victim's girlfriend. Describes the moment that the rock crashed into the car. So we're just gonna watch this one while we are on break, and I'm keeping an eye on it. So, let me turn.
Did you know her?
Yes.
When did you meet her?
Like 4 summers ago in July of 2021, 22, I think.
And describe for the jury your relationship with her.
She was my girlfriend.
And for how long were the two of you in a relationship?
Like 2 years.
And was that 2 years leading up to April 19th of 2023?
Yeah.
On that date, April 19th of 2023, where did you live at that time?
In Lafayette.
And where did Alexa live at that time?
In Arvada.
Where were you working at that time?
I worked at a restaurant called Old Chicago in Broomfield.
And what did you do there?
I was a server.
So talking about that evening, what were you doing that evening of April 19th, 2023?
I was at work.
And what was Alexa doing?
She came in to visit me that night with some friends. And I think she went, or I know she went to the friend's house that night after she came into work.
And how long was your shift typically?
I don't remember, but this night it was like they kept me longer. I don't remember why, because I didn't sweep the floor right. I didn't sweep it right. He made me do it again.
What was the plan after you got off work?
We were going to go home and sleep.
And was she going to stay at your place? So that was the plan?
Yeah.
Okay. And did there come a point around 10:40 when you were off work at that point and you were talking to her on the phone?
Yeah.
And was it your understanding she was driving?
Yeah, she was driving.
And where were you at that time when she was driving in her car and you were somewhere else?
I was at work and I was watching her location while I was on the phone with her to see if she was coming over, or she told me she was coming over, both of them.
So you're on the phone with her, also watching her location. And are you watching her kind of travel towards your home?
Mm-hmm.
And you're still at work. What happened during that phone call? Did anything cause you some concern?
We were talking about coming over, and we were in.
And did the phone call disconnect or something like that?
Yeah, it just stopped. It went silent, but it didn't hang up. It just went silent.
And so what did you do when the phone went silent?
I said, hello, honey, hello. And then I hung up and I thought she was mad at me. And then she just didn't call back. She didn't call back. So I kept folding my silverware and hoping that she just threw her phone out the window or something. I don't know. That's what I thought.
And did you try and call her back?
Yeah, I called a lot. I don't know how many times, 10 maybe.
And what was happening with that phone call? Was it connecting in any way?
I don't remember. I think it would ring. I don't remember if it would just go to voicemail or I think it just probably went to I don't remember. I'm sorry.
It's okay. She wasn't answering the phone. Given that you were calling her repeatedly, maybe 10 times, and she wasn't answering the phone, did you do anything to try and figure out where she was?
Yeah. I looked at find my friends on her iPhone.
And what did you see?
It was in the middle of it was off the road. Her location wasn't driving on the road. It was off the road.
And was it moving or was it stopped?
It wasn't moving. It was stopped.
And was it off Indiana Street?
Yeah.
Once you saw that she seemed to be stopped off the street, off Indiana Street, what did you do once you saw that?
I drove there.
Did you make any phone calls?
I called my mom to see if Alexa had come home yet, and she didn't. So then I called my friend Jordan, and she didn't answer. And then I called her mom, Alexa's mom. And
why'd you call Alexa's mom?
To see if she had heard from Alexa that night, or I don't know. I don't know what was going through my mind. I just thought she'd heard from Alexa to see if she had called her.
So after you called these people concerned about Alexa, having seen where she may be on your phone, what did you do?
I'm sorry, what?
Did you go to that?
Yeah, I went to the location. I was driving to the location while I was on the phone with her mom.
And how long would you say it took to get there from Old Chicago where you'd been?
10, 15 minutes probably.
And once you got close to her location, when was it that you first saw her?
What time? Or
sorry, bad question. Were you still on the road when you were able to see her car?
Yeah.
And then once you saw her car, where was her car?
It was in the field, off Indiana.
And what did you do once you saw her car in the field off Indiana?
I drove to it.
And can you kind of describe that drive? Was it off of the road?
Yeah, it was like the fence was broken, like where she like where you could like where the car went, and I drove through the fence to get there.
And did you get there?
Yeah.
And did you park next to Alexa's car?
Yeah.
And so while you're still in the driver's seat, what did you see?
The back windshield was like shattered, and there's a big hole in the front windshield.
Did you know whether her mom was on her way there too?
Yeah, her mom told me to call 911 when I saw her car.
And did you know she had been driving a Chevy Spark around that time?
Yeah.
And so did you recognize this car to be the one
Yeah.
you knew she was driving? And what kind of car did you drive?
A Kia Soul.
Was that a blue car?
It's blue Kia Soul.
And did you see any, you mentioned that you saw damage to the car. Did you see any indication that she was hurt? And I won't ask you to go into too much detail. Can you just tell us generally? How did you know she was hurt?
Her head was down against the steering wheel, and there was like blood on the car.
And once you saw the damage to the car and the blood everywhere, did you call 911?
Oh, I was on the phone with 911 when I saw.
And were you there? Were you still in your car when police arrived?
I don't know. Yeah, I don't. Yeah, I think so.
And did you go to, once police arrived, did they speak with you and did you go sit in their car after that?
They asked me what happened, and I didn't know. I didn't know what happened, and they like tried to talk to me in the car, and then I'm sorry. I don't know, but they just took me over to one of the cop cars, and I sat there.
And was it after you were there that Kelly Bartell arrived?
Yeah.
Cross-examination?
No questions.
All right, so that was the testimony of the girlfriend of the victim, Alexa Bartell. That was heartbreaking. You know, and that's definitely a very heartbreaking testimony right there. Finding her girlfriend like that, and everything that went through. Oops, sorry. It was very emotional. Of course, she'll be back any minute now, and when we do get back, we're gonna go start with the closings of this case, and then throughout breaks and everything, we're gonna just check out the testimony that we had throughout this case, and then wow, indeed, Bianca, I absolutely agree. It's yeah. Oh yeah, I know. It's just your name was just Journeys before, but that's fine. No worries. Welcome in. Good morning, my friend. Good morning, Case One as well. Hello, well, Hannah. Welcome back, Zio. So yeah, so we're just doing. This is the last day of this trial. I don't think that this is gonna take that long in terms of deliberations. I think it's gonna be rather quick. And court, it looks like they're setting up again for carry on the closing. Sorry, I need to move myself again. I keep moving myself on the screen. I keep turning. Good morning, Denise. Welcome in. You haven't missed much. I found this trial literally yesterday, and I decided, because there is a live feed that we can use, I decided to jump on, but the case is literally finishing today. We are about to hear closing statements on the case. Prosecution obviously goes first. This is analyzing trial that is suspected to throw a rock into a windshield of a car that unalived a young girl, 20, I think she was 20 years old. Her name is Alexa, the same name as the device. So if you have one, please, I'm so sorry. That's gonna probably alert that it is a very sad case. So what we're doing is watching the live feed while and then after on verdict watch we're going to be just doing a bit of a recap of this case to obviously know where we are. The defendant is right there drinking some water or whatever he's drinking. Is blonde. He is 20 years old at the moment. He was 18 when this all happened back in 2023. So I just thought it would be a great case for us to follow. I wish I would have found it sooner, but we're here. It is what it is. But we're gonna be okay. Courtroom is packed now. Earlier was absolutely empty, but now it's starting to fill up with both sides. Pretty full actually, in my opinion. So yeah, so that's where we are. This is like a literally brief case of the case. I am thinking very seriously thinking of if they come back with a verdict today. It's okay, case one. It's absolutely fine. I understand. I was just gonna say that if they do come back with a verdict today, which I think they should, this case wasn't that long. The verdict is gonna take that long. I'm gonna take the day off tomorrow. I might record a video just to keep the algorithm happy and you guys happy with something entertaining. But if the verdict comes, I have decided to take a day off tomorrow and then the weekend, and we be back with a new trial on Monday. Which one? I still don't know. I'll find something, I'm sure. But yeah, so that's what's gonna happen. I need a day off, and you guys have been so adamant that I take a day off, and I'm listening to you all. Definitely will take a day off. Probably gonna spend with baby girl, and just having my cuddles and just the snuggles with her, and just enjoy some time with family, which is also always good. So, yeah. Court should be back any minute now, and start with the closings. State is gonna go first. Yeah, we're gonna have a trial on Monday for sure. We'll absolutely be fine. But yeah, I did make notes on this. So state is gonna do a closing that's gonna last around 45 minutes, and then they're gonna leave 15 minutes for the rebuttal. So it's gonna be a prosecution 45, and then defense is we're gonna have a break after the first 45. And then after that we're gonna have the defense talk for an hour, and then if they present a closing, that is, and then we're gonna have the rebuttal statements for 15 minutes, um and then the verdict watch. Sorry. Getting a little bit emotional there. Thank you very much for that. Appreciate it. But yeah, I'll definitely spend some time with the family. I think judge is coming in because everyone just stand, and then everyone is going to stand again for the jury, because we kind of do definitely need the jury there for that. For this case, we always need the jury for any case. So I'm a bit upset that I did not find this case earlier, because it sounds like it would have been a very good case to follow, and rather short. But we were pretty busy with Lori up until when did Lori finish? Tuesday, yes, Tuesday. Lori finished. Today's Thursday, so I think this started on Monday. I'm not sure, but anyway, judge is here.
Good morning again. We're back on the record. Was there anything you all wanted to discuss before we get our jury?
No, Your Honor.
Thank you.
Ready for the jury?
May we start publishing?
I'll turn it on. It has your feed.
Okay.
I'll unmute right after I say people's turn.
Also, I forgot to say that there's two other people involved in this case. They both took plea deals, and they testified in this case against the guy that is the defendant, the blonde guy. So that I thought, because their names will come up in the closing, I'm sure their names are Quack and Carol Chick. That's the names. So yeah, right. Well, we'll wait for the jury to commit.
Please be seated. Good morning again. Welcome back. At this time, the people may present their closing arguments.
Frequent, focused, and fatal. When you go back into the jury deliberation room, go back to those 3 words. The defendant's attacks were frequent. The defendant's targets were focused. The defendant's weapons were fatal. When you go back to deliberate and ask the question, what was he thinking? That's not a rhetorical one. That's the issue in this case. And when you go back to those 3 words, the evidence has proven the defendant's mental states, what the defendant knew, and what he intended. The defendant's attacks were frequent. He did this over and 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 over until Alexa Bartell's life was over. His targets were focused, always on the driver's side. You see that through the evidence, through the photos, and the testimony of his co-defendant. And his weapons, not just the one that killed Alexa Bartell, all of them, even the smaller rocks, even the softball-sized rocks, they were all fatal. This one was fatal. Go back to those words, frequent, focused, and fatal. You're the fact finders in this case. So let's talk about what actually happened and what the evidence has proven. Going to the time on April 19th, 2023, when the defendant, driving his friend's Chevy Silverado, turns left on Indiana Street. After a night of rock throwing, he turns left. It's dark. This road is hilly. He crests the top of a hill. He sees headlights. Nicholas Karolchik, sitting in the front passenger seat, puts this 9-pound rock on the center console for him, bigger than many of the others, which he grabs with his left dominant hand. And as Alexa Bartell is passing, and he has sped up to at least 80 miles an hour, he throws it like a shot put out of his driver's side window, killing her instantly. That rock crashes through the front windshield, crashes through the back windshield. You have the pictures of what that rock did to her. They continue on. The defendant, after killing her, he whoops. He says, "Holy shit," in a little voice he uses. They say, "We have to go back and see that," because Zachary Kwok has seen her car go off the road. So they do a U-turn. They get rid of all the rocks, do a U-turn, and then they pass her. her car having gone down an embankment through a fence to its final resting place. They pass her, and he's excited. Still. He looks to his friends, smiling. They pass her again. After doing another U-turn. And he does nothing to help. He doesn't call 911. They don't go check on the driver. And yeah, she is really far off the road. So can they be sure she's dead? No. Can they be sure something is seriously wrong for the precise reason that she is so far off the road, down an embankment and through a fence? Absolutely. He does nothing. Obviously. He's charged with extreme indifference, universal malice, purposely throwing that rock at oncoming drivers, intending to hurt people, knowingly putting people at grave risk of death. Having just done those things, of course he doesn't call for help. That's what happened. And you have theories of liability for which the defendant can be held accountable as either principal or complicitor, or principal and complicitor. The defendant was the principal. The evidence has proven that. Mr. Kwok was in the back passenger seat. You heard that from Mr. Bopp, you heard that from Mr. Kwok, and you heard that from Mr. Karolchik. And there are some other details that corroborate that. Mr. Bopp testified, yeah, his feet might have been on a bag of tools. That bag of tools was still there when one of the law enforcement investigators took this photo days later. And Mr. Karolchik, when describing how Mr. Koenig would turn around in excitement, it makes sense that he's turning around to Zach Kwok in the back passenger seat. And if Mr. Kwok's in the back passenger seat, think about what that means. The damage to Alexa Bartell's car, using your common sense alone, would not be this. You heard testimony from Detective Steiner that to get trajectory analysis, you need 2 nice holes. These are not that. These are not nice holes. So he couldn't give you trajectory analysis, but think about it. Even if Mr. Kwok is throwing rocks at parked cars or other cars, he's using his right hand. He's throwing them out the right side of his car, or he's lobbing them, like Mr. Karolchik, over the truck at oncoming cars. This damage is not consistent with a lob. This damage is consistent with tossing it like a shot put with a left hand. Mr. Koenig is left-handed. Mr. Kwok is right-handed. You also heard testimony from Joe Bopp describing Mr. Kwok, quiet and reserved. Mr. Koenig, he would do crazier things with Mr. Karolchik. And then you have Mr. Kwok's interview. When he was confronted with a non-existent video that investigator Manka said he had, he says, okay, that's when he starts admitting his involvement. Because he was involved. He admits that. He was collecting rocks. He was passing them forward. But then when investigator Manka says, well, what if we test that rock for your DNA? Will your DNA be found on it? And he says, no. So think about that. In that interview, Exhibit 264 you have, he says, I want to make it very clear, I did not kill that girl. He says, I did not throw that rock. I did not throw that rock. You gotta believe me, I did not throw that rock. You have this clip of video. Mr. Kwok has been consistent throughout. Mr. Karolchik hasn't. And let's talk about why. He testified, it was obvious to me that I was not being completely truthful in the first 3 interviews with them. In the fourth, he was still minimizing. After the first interview, you heard on cross-examination what was going on. So you have the backstory. After the first interview in April of 2023, an email comes to the prosecution. Mr. Karolczyk, from his attorneys, Mr. Karolczyk's attorneys, Mr. Karolczyk was not honest in his interview about who threw the rock that killed Alexa. In his interview, he said it was Mr. Kwok who threw the rock. Mr. Karolczyk was trying to protect Mr. Koenig for reasons that we will be able to explain. So we have an interview in January of last year. And then he gets cold feet. He's still blaming Kwok. And he says it's because his attorneys showed him a picture of the rock and it might not be the rock. Use your common sense. He's still protecting Mr. Koenig in this January interview because that's his best friend. His motive, still at that time, even on cross-examination when asked, at that time you were desperate to get a deal. He says, I don't know if I was desperate to get a deal. In fact, I still owed something to Joe. I still felt I owed something to Joe. He was like a brother to me. So that's his mindset. The most important admission that he makes is to his attorneys. That's attorney-client privilege. That privilege was pierced when his attorneys reached out to us, telling us, Mr. Karolczyk has been very clear with us since the beginning that it was Mr. Koenig who threw the rock that caused the death of Alexa. He always knew Mr. Koenig was the one who threw that rock, always. When asked, so why did you say you didn't know and that your understanding changed at certain points if you knew the whole time? He said, I still felt the need to protect him and protect myself, and Zach was easy to blame because I barely knew him. This all makes sense. Mr. Koenig was the principal, but for the sake of argument, forget all that. We don't have to prove he threw this rock that killed Alexa Bartell. We don't have to prove he threw any rock that night. We only need to prove the elements of the charges. Can't go through all 19. The judge just did that. The elements of murder in the first degree extreme indifference, that it was the defendant, either as principal or complicitor and complicitor in Colorado on April 19th, 2023. These attendant circumstances that you have knowingly engaged in conduct which created a grave risk of death to another and thereby caused the death of Alexa Bartell. This is all we need to prove, and the defendant was at least complicit in all of the crimes. He's repeatedly throwing rocks. He's the one who's driving. He sees all the headlights. With regard to Alexa Bartell, it said last one, it's getting close to 11 p.m. He's the one who speeds up, following those directions of faster, faster. The rock is thrown using the passive voice. Go ahead and believe it was Mr. Kwok. Mr. Koenig knew exactly what would have been going on at that point. And then excitement. He was at least complicit. After the excitement, they didn't help. With regard to these attendant circumstances, the defendant says, holy shit, in that little voice he uses. He whoops. And Mr. Karolczyk explains how he looked like he felt after killing Alexa Bartell. He would just be smiling. This is after they passed her. When she's come to her resting place in the field, he'd just be smiling. He would just look at us with a big smile on his face. The elements of knowingly and intentionally for the various charges, how have those been proven? Mr. Karolczyk tells you, we took it a step too far targeting people who were driving that night. It felt wrong going against a person versus just going after a car. I just had a feeling someone was going to get injured. There was always the possibility that it could go through the windshield and hit someone. knowing damn well that if you throw something at them, they could lose control or get injured by it, or, any of that. Mr. Karolchik knows any one of them could have killed someone on any of those instances. How did the defendant know he was creating this grave risk of death? Well, he saw the damage repeatedly. He saw damage to just parked cars. He saw damage, rocks going through windshields at just parked cars. Forget the momentum of an oncoming car. He saw the damage of Michael Marasco. He saw that damage of the windshield when they went back after the very first instance. Saw the damage after throwing the statue head. Saw the damage of Mr. Smar after he'd pulled himself over on the side of the road on April 19th. He saw the damage. They heard the damage. You heard Mr. Kwok describe loud booms. He knew rocks could go through parked cars. If they can go through parked cars with no one in them, they can certainly go through windshields of moving cars.
Jeff, that's a misstatement of the evidence. Rocks going through parked car windows.
The jury's reminded that it is for the jury to determine the facts in the case. The attorneys may comment on the facts and argue the facts at this stage, but that is solely a jury function to determine what the facts are.
Remember what Mr. Karolchik told you about what they saw with regard to parked cars. And yet, he would speed up to create more impact at oncoming drivers. He didn't need any of that. He didn't need to see, hear, or know any of that. All he needs is common sense to know that when you're throwing a large landscaping rock at high speeds at an oncoming driver, one is creating a grave risk of death. The defense witness testimony does not negate the defendant's mental states. With regard to adolescence, Dr. Steinberg said, the adolescent who commits a crime rarely is so deficient in his decision-making capacity that he cannot comprehend the immediate harmful consequences of his choice or its wrongfulness. By age 7, they can form criminal intent. By 16, they have adult intellectual capabilities and logical reasoning abilities. Adolescents aren't any worse than adults in how they make decisions. And risk-taking is a subset of decision-making. He said, the notion that adolescents take risks because they don't know any better is ludicrous. You remember how he acted on the stand. He believes this so much, he wrote this in a book. They're just as likely as adults to know what's risky, he said. They're just as knowledgeable as adults about the dangers associated with various acts. Adolescents do not differ from adults in risk perception. If anything, young adolescents overestimate the risks involved in potentially harmful behavior. Heightened risk-taking is not due to cognitive deficits or intellectual immaturity. Adolescents are aware of the dangers of risky behavior. There is substantial evidence that adolescents are well aware of the risks they take. Yep, damn well aware. So what's the difference? They prioritize the feelings of rewards. The defendant's reward, what's the defendant's chocolate cake? Take a look. The defendant had no decision-making issues. When you heard from Dr. Lynch, she said, Mr. Koenig's diagnoses are clinically unlikely to have caused significant impairments in his rational understanding of his external circumstance.
I object. That is a misstatement of what her opinion was. We have discussed this repeatedly at the bench. It refers to a different legal standard that's not applicable to this case.
And that's incorrect.
Give me just one moment. This is supplement material, so overruled.
So you can pay attention to that. His decision-making ability was scored as above average. He had no decision-making issues. Did he make a lot of bad decisions? Yes, knowingly and intentionally. There was no concern with executive functions pertaining to impulsivity. No concerns with regard to inhibition, foresight, planning, problem solving, or concept formation. With regard to this borderline personality disorder diagnosis, okay, so he feels these abandonments because a girl he was with maybe cheated on him, because his mom goes away for work, and because he's graduating high school and some of his friends are moving on. So he has these real or perceived abandonments. He has chronic feelings of emptiness. He has intense anger. Okay, so that leads to impulsivity, to avoid those feelings. Okay, that does not mean all of his acts are impulsive. In fact, with regard to ADHD, Dr. Lynch forgot what's in the DSM-5, which states signs may be minimal. Signs of ADHD may be minimal or absent when the individual is receiving frequent rewards for especially interesting activities. Okay. Unfortunately, his ADHD symptoms when throwing these rocks were completely absent because he enjoyed it. Because throwing these rocks and causing this harm was the reward. If only he didn't listen to going faster, faster, the instruction from his friends. If only he lost the rocks. If only he got sidetracked while driving. If only he forgot what he was doing. If only he didn't have the attention span 5, 10, 15 seconds before seeing the oncoming headlights. If only he couldn't follow the assignment between him and his friends to carry through this rock throwing. If only he would have avoided or was disinclined towards it. If only he couldn't focus on it. If only every single one of his ADHD symptoms had been present, Alexa Bartell would be alive. Dr. Lynch didn't read the book, ADHD is Awesome. His ADHD, if it had manifested, would have been awesome because Alexa Bartell would be here. She couldn't say, Dr. Lynch, that rock throwing was done with impairments to impulse control, judgment, and decision making. That would be impossible for me to assess, she said. And there are certain things that defense said in opening you can go ahead and agree with. That adolescents are more impulsive, risky, reckless, that they show off for their friends. They try and go bigger. They try and one up. Okay. That the defendant didn't have an intent to kill. That's not one of the elements. That they're teenagers, not terrorists. There was no political motive. No one's saying he's a terrorist. You can believe that Kwok threw the rock that killed Alexa Bartell because, as they said in opening, as a legal matter, who threw the rock doesn't matter. You can believe that all three are guilty, yes. And you can believe the prosecution will tell you that each and every instance is an attempt to commit first-degree murder. Yes. The evidence is different for each charge individually, and you can consider it all in totality. Each charge has been proven beyond a reasonable doubt. The evidence is different in that in some instances we have the suspected rocks. In some instances, we have the known rocks. In different instances, different objects were used, a statue head, a brick of concrete, still causing extreme damage. In some instances, we don't have the objects at all with regard to Nathan Tipton and Mr. Smith. And with regard to the incident on Highway 93 involving Nathan Tipton and Mr. Smith, you heard Nicholas Carolchuk testify there were 3 instances that night on Highway 93 in which they targeted oncoming drivers. proving that even though Mr. Smith didn't see it, much like many of them didn't, Mr. Smith was targeted. Some of them have pain or injury. That's why you have assault charges for some, but not all. Mr. Smar, Miss Davis, and Mr. Mueller. Injury means pain or any impairment. For Mr. Smar, he couldn't drive home because he had glass in his mouth and his eyes. It caused discomfort. That's enough. You see the blood on Miss Davis, and Mr. Mueller, it hit his shoulder, ricocheting around in his car. And then all of the charges happened at different times, of course. So ask, did they know the risk? Did the defendant know the risk at first? Okay, Mr. Marasco, the very first in time? They knew damn well. Mr. Karolczyk said that if you're going to throw a rock at an oncoming driver, you'd know damn well. Because, like an adolescent, 18 years old, they have deductive reasoning abilities and hypothetical reasoning abilities, because those reasoning abilities level off at age 16. You have a growth of knowledge and a growth of experience. There's a little asterisk here, which we'll get to. It looks like this. If they're starting at parked cars, they know the damage to those parked cars. And then in this order, they keep throwing rocks. They see the damage to the parked cars. They see Mr. Marasco, the glass on the ground after he leaves, knowing that it crashed a windshield, Mr. Karolczyk told you. They see the damage to Mr. Bryan's car after throwing a statue head at him. They see Mr. Smar on April 19th pulled over on the side of the road, maybe needing help. So they had this growth of knowledge and experience that was completely unnecessary, because they also had common sense, deductive reasoning. When it comes to the first-degree murder of Alexa Bartell, their acts had been the most frequent. She was the last. By the time she had been killed, they had been doing this the most. With regard to her first-degree murder, the defendant hit his target. It was the most focused. And with regard to her first-degree murder, it didn't just put her at a grave risk. It caused her death. It was fatal. Certain portions of the defense's opening was contradicted by the evidence. But this is a stupid prank. All these incidents, just a stupid prank. You heard the co-defendants testify. They knew this was extreme. And they knew the difference. Throwing an egg, throwing a snowball, throwing a water balloon, that would be a stupid prank. Tipping over a golf cart, sure. They knew the difference. They didn't have a plan, no plan at any time. You don't need to talk about something to discuss it for there to be a plan. Dr. Lynch, she was asked repeatedly a number of questions about preparation and what they did. They had a plan. No thought of targeting people with cars in them. Mr. Karolczyk said they were targeting drivers. They didn't think they'd use these rocks to hurt people. Well, Mr. Kwok even admitted to you he could think logically at age 18, and he was different. While he could think logically, he might have engaged in trying to hurt people. And Mr. Karolczyk told you he felt wrong targeting people who could get hurt. They didn't know when they hit their target. Well, that makes no sense, because they'd cheer when they hit their target. They didn't have any reason to know that anyone was hurt. By the very fact that Alexa Bartell was so far off the road, they had every reason to know. And Mr. Karolczyk told you they did. They're telling you that he's guilty of reckless manslaughter. Necessarily he is, because that's a lesser included offense of murder in the first degree. But he's not just guilty of reckless manslaughter, because this was not reckless. The defendant, he wasn't consciously disregarding a substantial and unjustifiable risk. He was actively pursuing it. When we talk about lesser included offenses, you can think of it like getting a speeding ticket for going 20 miles over the speed limit. Necessarily, you're going 15, 10, 5 miles over the speed limit. So explaining this when it comes to murder in the first degree, the lead charge, and the lesser included offense of murder in the second degree, the elements are slightly different. It's for murder in the first, knowingly engaged in conduct which created a grave risk of death to another and thereby caused the death of Alexa Bartell. The lesser included is just knowingly caused the death of another. And so first lead charge has been proven. Necessarily then proving the lesser included offense and all of the lesser included offenses. Remember, when you're deliberating, use your reason, use your common sense as you're instructed by the court to do. Remember that two things can be true at the same time. An 18-year-old is also an adult. They didn't discuss a plan, and yet they had a plan. The prefrontal cortex may not be fully developed, and yet the defendant had the complete ability to form the culpable mental states. The defendant may have been susceptible to impulsivity for whatever reason, and yet the evidence has proven his crimes were not impulsive. It felt thrilling. Sure, it did feel thrilling to him. And also, he knew the risk. He knew the risk. Go back to those three words: frequent, focused, and fatal. His attacks were frequent. His targets were focused. His weapons were fatal. Find the defendant guilty of all 19 charges. Find the defendant guilty of the lead charge, murder in the first degree, for the murder of Alexa Bartell.
Go ahead, and I think I mentioned we would take a brief break. So we'll go ahead and give you that brief break. Remember, do not discuss the case among yourselves or with anyone else, even now. And do not do any independent investigation or research. We'll come get you in about 10 minutes or so.
All right, we're gonna go on break now. Hannah, let's crash YouTube service. Let's start singing. Zio, you can come up and help me sing if you want to. Lol. So yeah. Oh yeah. So at the very beginning of the case, thank you very much for reminding me of that, Carol. I
Please be
appreciate it.
seated.
Oh, hang on. Let's see. Hang on. If the judge is
Just a
saying
quick
anything.
reminder, there's a decorum order in place. There's only some exceptions allowing for certain individuals, those associated with the teams, respectively, and respectfully, and the media may have electronics powered on, but they need to be silent. Others should have them powered off. So phones should be off if you're here in the courtroom and you're not falling within one of those exceptions. Anything before we break?
No, Your Honor.
No, thank you.
All right, thank you. See you in 10 minutes.
So, Zio, you are on stage. Let's start singing then.
I'll skip that. I just came to say hi.
Hello.
skip
But
the
yeah,
sing-
so
Oh,
if
handed me the mic. Okay, it is my turn.
see, she's handing it. So, hello everyone, welcome Zio, and She's a very good friend of the channel. But I was just gonna say, let me take this out of the stage for a second, so we can have a break. I'm keeping an eye on the feed. But yeah, so if you guys rewind to almost at the very beginning of the stream, you can see the defense attorney picking on his nose. It is absolutely hilarious because it's like it seems like he's really in there. So it's yeah.
That's
Uh,
not okay. That's not okay in any way. Did anybody see him use sanitizer?
No, it didn't. It did not to use sanitizer after that. It was a hot mic moment. Was a no a nose hot mic moment. The
Lord.
oh my days. It was interesting. I think we're gonna hear from him on the defense case. I mean, but yes, this case is heartbreaking, man, and I'm so sad that we did not catch this from the beginning. I need to be paying attention more to cases that are ahead than drama in my life.
Well, I wasn't sure. I think when we found it, it was already a couple of days, in,
In yeah,
and then, we there was no way for us to go back and get the feed because once that feed was gone, it was just like, psh. So I think
yeah,
since you've signed up for this particular court, because they have a lot of stuff going on, we just can't see it until almost the day of.
yeah. Thank you, Paula. Yeah, I'll check that image. But yeah, that is for sure. But it was like it's a case that I need to look up. Oh, Anna, yes, please. I can read your mind, or you can just text me what you thinking, because sometimes my interpretation of English language, it's not the most correct. So sometimes it breaks. So you can always DM me on Discord, Facebook, email, whatever you want to reach out to me, you can reach out. So yeah. It is the we heard the a girlfriend testimony earlier on the other break, and it was very very heartbreaking. Indeed. I think during like verdict watch and everything, since this case is gonna go on verdict very very soon, we're gonna look at the opening statements. We're gonna be looking at the testimony that happened throughout this trial. There's like some bits and pieces around, and there's also the testimony of the co-defendant um on this case, because Quack and Carol Chick, that is the other two guys that were involved in this case, they pled guilty with the plea that they would get like a reduced sentence. Like because it's the same state. The Stacey Rodriguez case, Zia, we covered.
Yeah, yeah, I remember.
Yeah, so Hosanna, her co-defendant, she did a deal with the state. She would get a reduced sentence, and this is exactly the same. So I think Colorado, there's a lot of deals in cases apparently.
Did you see the windshield?
I know it is on a thumbnail of the
It's,
thumbnail for the stream. Yeah, I know. It's my
just
days.
look at
If you
this. This is
Yeah,
crazy.
I was gonna say
It's
if you
just
have it up, yeah.
it's just like I there's just no way. There's just no way you couldn't have survived that. It just
Oh no, I'm so sorry, Jade.
what happened,
Oh,
Jade?
I hope she's all right though. Oh my days, that is so scary.
Oh my
Oof.
goodness.
I know. I was like, I'm so sorry, Jade. I hope she's all right, and you are all right as well, because this doesn't affect just one person. Um,
Well, yeah, that
yeah,
scares the whole community. Like,
I know. Yeah. So it's hey Denise, welcome in. Hi. Thank you for the recommendations. I think it was you that recommended this case as well for me, to me and Zio. To yeah,
awesome. I'm glad that there's so many people from different communities that are reaching out, like, and wanting to
yeah.
cover different things because I understand high profile, I understand Lori Vallow and getting Karen Reed out there and stuff like that, but there are so many cases that fall at the wayside that nobody ever talks about, that we're not talking about them because we're not looking into them. So it helps a
Yeah.
lot.
Indeed, it's like even the small cases need to a voice. Like the victims need a voice. I'm like, look, Laura Vallow was okay. Karen Reed is just another world of case that I don't want to get too into it. Oh, absolutely, Jade. Absolutely, 100%. that needs to be reported to the police, because it's horrible, absolutely. But yeah, but it's just I like small cases. It's less oh yeah, I was gonna cover that one, Hannah. I had planned covering, but they moved the trial file like a week or so, and then Lori Vallow showed up, and I was like, okay, we'll do her, do Lori, and then yeah, but
So
it's over.
is that the one that Rubber did the first day, the first 4 days? She
I
did a 10-hour stream that day. I was very proud of her.
I know, I was very proud of her. She is absolutely um amazing. Oh my days. Jade said her sunglasses saved her from getting glass in her eyes. Wow. That is wow, that is some very good sunglasses there. I'm telling you that. Um but I'm glad that she's okay. So of course I just feel bad that I'm late to the party, but we still can do a little bit of impact there and get it out a little bit, isn't it? So it's a good thing, but yeah. um I know, that I want to watch that, but I don't think we're gonna have time. I don't know what to do about that one. I do want to go back somehow, but I need a
So
day.
this is her obituary. I found that online,
Thank
and
you.
you're welcome. They're just she's such a pretty thing. She's so young, like 2002 to 2023. My son was born in you know, like, oh, it just hurts. Like, she's just a young, very young girl.
Yeah,
Needless growth.
all of them were very young. They were all in
Yeah,
their teens when this
just
happened.
kids. So
So
they labeled it as a vehicle incident in Arvada, Colorado, and she was born to her parents, obviously Greg and Kelly, and she was known to all of her family, friends, and coworkers as outgoing and loyal, compassionate, loving, energetic. She liked basketball and music, and she would light up any room that she walked into. So it's really, in lieu
I
of
don't you see.
flowers, the Bartell family asked everybody to send stuff to Memorial Fund for her if they were still doing that. I don't know. Of
Still
course,
do
that was
it.
2 years ago. So
Yeah, I think it's, yeah, I'll see you very soon, Paula. I hope everything goes well. Dentist
bye,
appointment is
Paula.
not fun. Trying to avoid the dentist like a plague. No, no, thank you. I haven't been I haven't been to the dentist like in 20 years, man. So I ain't going now.
I agree with that, Jade. It's really weird, right? Really good people
Mm,
that are affected by a very bad person's behavior.
yep.
More than you know. We
Oh
feel
yeah.
I'm feeling that.
Oh yeah, that is very true. Thank you for saying that. I really, really appreciate that. Garden bot?
Nancy's here. Nancy's here. I haven't seen
Nancy,
Nancy in a minute.
hello. You got a new puppy. Oh, nice. Oh,
A
name
walking
ideas.
partner.
Oh, I am the worst person to ask for ideas in terms of
She's
names.
she's a
So,
yellow lab puppy. Anybody got any names for Nancy?
I would call Nemo, but I did that to my niece. My niece, I
Nemo?
gave her the nickname of Nemo. So I don't know if it is appropriate for a puppy though.
Did you see the rock? Did you see the rock that he threw?
Yeah, it's like a landscaping rock.
My heavens.
I know it is like a massive rock. Like, I'm not gonna lie, it's. Have you got a picture of it?
Unfortunately, yeah.
Oh, by the way, Nancy, congratulations on a new puppy, on your new addition. And oh, I like that, Denise. Sunshine,
Sunshine. Oh,
9 pound rock. Man,
look at
that is a very
this.
heavy rock. I need to call
This
my garden expert. I think my garden expert, because he's my husband. No, it's
uh-oh.
not.
Uh-oh. There it goes.
What did you do?
I broke it.
Okay, just give me the.
9-pound rock.
Yeah, 9 pound rock. That's a heavy rock. So, um, I think they should be back any moment now. That people are getting into the courtroom again, like the prosecution side. Thank you for that. Prosecution side is getting back in, and now we're gonna listen to the defense closing statements. We'll see what is their defense. if they have one even, because I don't know even if they put any case on really. um I absolutely have no clue. Neva,
Nevea is a pretty name.
Nevea. Oh,
Sunshine.
sorry, that's how.
Nevia, Nevea. I don't know. Either way, both of those are pretty.
Yeah,
You could.
and
I'm
Sunshine is
gonna
good.
jump down while you're getting back to it. I just wanted to come up and say hi to everybody in chat and hope everybody had a really good Easter last weekend. And nice to see you all. And I'll be down in the chat.
In the chat. Thank you very much for popping in, Zaya.
You're
I
welcome.
appreciate you.
Y'all have a good one.
You too. Oh, Linda is the good name, William, but we just had a defendant called Linda, and maybe I think that they were thinking I'm joking. Lincoln to Linda Sturma. I don't know. I'm just joking. I'm joking. So yeah, it is. It is indeed. But then the pronunciation would be hard. So, but yeah, but it's up to you, really. Yellow lab. I did it again. What? Reminds of cake. Oh, cake. Now you're making me hungry, Theo. Thank you very much. Why? We always listen to you, but it's just defendant names should be off the table. I'm joking. We would never name anything or anyone. But oh, I like that. Misty, Molly, Lila, and now I have a Lily Joy. That's such a cool name, Jade. Um, oh, Judge, I think is getting into the courthouse, everybody. We need to get ready. Court is back. Nivea. Okay, thank you, Hannah. See, my
Back on the
English
record.
continue.
We ready for the jury?
Yes,
Do you want me to connect to your table?
yes, please.
I have 28 minutes remaining. Do you want that warning as well, or not needed now?
I'm all right, thank you.
Please be seated. Welcome back. At this time, the defense may present closing arguments.
This case was not about who, what, or where.
Sure, take a moment.
Okay, that's not what the case was about, and we all know it. From the beginning, we told you what this case was about. You can just turn it off, Judge, I don't need it. Is why? Why did Joe Koenig do what he did with those two other boys? And when we talk about why, what I'm talking about is what was going on in his head. What was his mental state? That's what this case is about. Now, the judge has instructed you on the law, and there are 4 different mental states. The bottom one, negligence, we're not worrying about here. The top 3 are intentional, knowingly, and recklessly. Now that top one, intentionally, that only really applies to those assault charges, folks, because to convict on second-degree assault or attempted second-degree assault, the prosecution needed to prove to you that it was Joe Koenig's and the other boys' specific intent. Their conscious objective was to go out there and throw rocks to hurt people. Specific intent. Is that the evidence that you heard, folks? And we had evidence from Mr. Karolchek and Mr. Kwok. Whatever you may believe about those two kids, one thing that they were consistent about from start to finish is it never entered their minds that they were going to hurt, let alone kill anybody. What were they doing when you asked them? They were throwing rocks at cars. And when the prosecution puts up on the screen, you know, this little sentence of Mr. Karolchek saying, oh, we were targeting people. Remember the context of where that came out, folks. That was in his first interview, the night he was arrested, after, essentially, he was admitting to everything and saying anything that he thought Investigator Manka wanted him to say. But when it was clarified for him in the subsequent interviews and on the stand, what did he say? He said, well, I meant that we were targeting cars. It never occurred to me until after Alexa Bartell's car went off the road. He consistently said that. And you know what? That Kwok who sat up here and lied and lied and lied, he even said that, folks. He said it never entered our minds that we were going to hurt or kill anybody. Why would he lie about that? He's already got a deal. Remember back in jury selection, folks, when I was talking with you about, you know, different degrees of murder. Everybody agreed with me that that is important. That's the way it should be. Not all homicides are the same. They're all horrible, they're all tragic, but they're not all the same. The way the prosecution has charged this case is under this first-degree murder statute that requires them to prove the intent is knowingly. And you got a definition of what knowingly is. It means that you're practically certain to cause a result. Okay? That is the first-degree murder statute they have charged this case under. But there's another theory of first-degree murder, a lesser degree called manslaughter, and that requires the mental state of knowingly. Are you consciously disregarding a substantial and unjustified risk? When we talked in jury selection, this was clear that this was what the case was about. And I asked you, I said, is it going to be hard for you to know what's going on in somebody's head? And everybody agreed that is hard. And I asked you, would it be helpful to hear from an expert that can tell you about late adolescent brain development? Most of you said that would be helpful. And so that's what we did. We brought in Dr. Lawrence Steinberg. You heard his credentials. It is not overstatement by saying he is one of the world's experts in adolescent brain development. He's been researching and publishing on it for almost 50 years. Colleges use his textbook. And the prosecutor wants to, take out a sentence from one of his 17 books or a line from one of his lectures he has given over the course of 40 or 50 years to suggest that he wasn't telling you the truth or he doesn't know what he's talking about. Well, that's ridiculous. What he told you is, yes, science evolves, and what I believe sort of evolves with the science. But his purpose, folks, was to educate you, to give you information, okay? He's never met Joe Koenig. He doesn't know the facts of this case. He was telling you what the science says. And you know what, folks? Most of this made sense to you anyway. It's not news that 3 18-year-old seniors driving around are going to do something reckless. It's not news to you that these kids didn't appreciate the consequences of their actions. Now, Dr. Steinberg told you why that is. He told you about the limbic system in the brain. as opposed to the prefrontal cortex, and this push and pull that's going on because one's not developed yet and the other one is turbocharged by puberty. And what's the result? It's when you get these kids together and they start feeding off each other that they do impulsive things, that they do reckless things, and that they don't appreciate, they aren't thinking about the consequences of their actions. Now, I know you're sitting here saying, okay, sure, that's what teenagers do. But most teenagers don't throw rocks from moving cars at other moving cars. And you're right. What Joe Koenig and those other two kids did are crimes. And I told you, neither myself or Mr. Ward were ever going to get up here and tell you that Joe Koenig is not guilty, because he is. We're asking you to find him guilty of what he did. Okay? So we bring you the science of what was going on in his brain. But we did more than that. Then we brought you a doctor who actually evaluated Joe Koenig, a psychiatrist, who reviewed all of his school records and all of his private treatment records, interviewed his parents, interviewed him on 2 occasions for 3 hours a pop. Now remember who that was. That was Dr. Lynch. She's not my expert, folks. The court appointed her. She is independent. She is appointed by the court to give an unbiased opinion if she could determine what Mr. Koenig's mental condition was at the time of the offense. And that's exactly what she did. Now, again, the prosecutor appeared to think that Dr. Lynch didn't know what she was talking about, that she didn't know how to diagnose ADHD or borderline personality disorder. I think you guys listened to her qualifications, and you know, she's not just a psychiatrist, she specializes in adolescence. And she evaluated Mr. Koenig. And what did she say? She said, at the time of the offense, that his borderline personality disorder was affecting his ability for impulse control and judgment. I'm not saying, again, folks, that he's not guilty because he had borderline personality. What I am saying is your job is to determine what's going on in his mind at the time, and what more relevant evidence could you have than an expert who is evaluating him for exactly what was going on in his mind at the time. Now, one thing we can all agree on is the prosecution really prepared for this case, right? Did you see how prepared Ms. Decker was to cross Dr. Steinberg with the books? She had one book that must have had 50 tabs in it and a binder of all these things that he said and written in the past. They had lots of time, lots of resources. What did you not see from the prosecution? Any experts to rebut what Dr. Steinberg said. Any experts to rebut what Dr. Lynch said. Because they can't. Dr. Steinberg is telling you about the science, and Dr. Lynch, the independent examiner, the independent psychiatric doctor, evaluated Joe Koenig and told you what she found, okay? She doesn't have a dog in this fight at all. She's not getting paid by me, by our side. She just got called as a witness in the case, which is exactly what she is. You heard a lot of the science from Dr. Steinberg about hot cognition and cold cognition. What do you think was going on in that car that night? I agree with the prosecution. It was escalating. Because what happened was, at first, you know, the 3 boys are driving around. They decide, we're going to go pick up Joe Bob. So they go pick up Joe Bob, and they go to Walmart. Little things are happening there. The boys are shoplifting little stuff for the thrill of it. They got money. They don't need to shoplift. They go outside, and you heard that Mitch was like taking little tabs off an advertisement and putting them under windshields. And then Joe says, hey, let's get some rocks. And so they start collecting some rocks. Now, Joe Bopp knew what was going to happen here. He's like, take me home. They took him home. You know who didn't ask to go home? is Quack. Do you believe him at all when he said, oh, I wanted to go home, but they told me you'll go home when we tell you to go home? You believe him when he said he never threw any rocks? That's not believable at all, folks. And so they drop Bob off, they're throwing rocks at cars in his neighborhood, at parked cars. And as they're driving, did you hear that when Mitch was talking about how Zach had this beanie that was a balaclava, like a ski mask, and he pulled the ski mask part down, hops out of the car, and he runs up to a car in front of them and like with the balaclava on, turns the side view mirror, just messing around. And then they start throwing more rocks at cars, and it's escalating. Now, remember what Joe Bopp said. He said that he's hung out with Joe on a couple of occasions, with Joe and Mitch, and Joe's different when Mitch is around. That Joe drives faster, that they feed off each other. That's exactly what was happening. That's exactly what Dr. Steinberg explained happens in these sort of hot cognition situations. And then you take Zach Quack and you throw him into that situation, and it's like throwing fuel on a fire, folks. It escalated and escalated. And they start throwing rocks at oncoming cars. And we know, folks, that Quack's throwing rocks, because when you see 2 hits on a windshield, that had to both come from the left side of the car. There's no way that Mitch is lobbing a rock over, Joe's throwing one, and they just happen to hit at the same time. That's not going to happen. You know that. So Zach Quack is lying about his involvement. But he admits, yep, it escalated, and then we flipped over the golf cart, and Mitch said, yeah, Joe and I probably wouldn't have done that if Zach wasn't there, because it's escalating and they're egging each other on. But remember what you also heard is that a lot of times they didn't even know if they hit a car. They're going so fast, it's going like that. So they aren't seeing all this damage the prosecution says that they must have known, that they must have seen, that they must have been targeting those people. This is going fast, and a lot of times they didn't know. And they never, ever knew that anybody had been hurt, ever, until the last rock was thrown. And when that last rock was thrown and they realized, oh, something's wrong, that car is going off, that was the last rock that was ever thrown. The first time they realized anybody had ever gotten hurt, that anybody had lost control even of their car, the first time, and they were done. When you hear the evidence of whooping and smiling, that's horrible to hear. And it's obviously horrible for Alexa Bartell's family to hear. But you guys have a job, and you have to set aside your sympathy. You have to set aside your rage for what has happened here, because your job is to determine what the evidence is. Your job fundamentally here in this case is to determine if the prosecution has proven knowingly beyond a reasonable doubt. Were those boys going out there that night practically certain that what they were going to do was going to kill somebody? That is not the evidence, folks. You may think probably, you may think it was highly probable that they thought that, and that's not enough. That is not proof beyond a reasonable doubt, okay? Were they consciously disregarding a substantial and unjustified risk? You bet they were. That is exactly what they were doing that night. And you know what, folks? That's called manslaughter. This has been a long, hard trial, folks. And it hasn't been easy. But it's pretty straightforward, because that's what this case is about. Now, I will suggest that there is some variation when we're talking about throwing, a fiberglass lawn ornament at a car when you're going 10 miles an hour. Is that attempted manslaughter? Probably not. But for the rest of the counts, the evidence is sufficient. What I'm asking you to do, folks, is to go back there, talk about all of the evidence that we heard, all the evidence that we saw, and return verdicts of guilty on manslaughter and attempted manslaughter, because that's what Joe Koenig did. Thank you.
When you're ready, rebuttal, if you wish.
Thank you, Your Honor. The sound. Explosive. One big boom, like a gunshot just went off. A cannonball. The sound. Wind whipping by at highway speed. Laughter, cheering, excitement. Impact, like those artillery shells they describe in the World Wars. Holy shit. And that little voice he does. Whooping, cheering. The sound. Sounded like the call just cut off. Silence. Silence is the loudest of the sounds. You had the opportunity to hear from the 9 other victims and watch their demeanors, their expressions, as they described the sounds of those nights from February 25th, 2023, April 1st, 2023, and April 19th, 2023. You got to hear about the sounds from 2 of the people who were in the car with the defendant. From Alexa Bartell, silence. Silence because her brain was blown out of her skull into the backseat of her car by Joseph Koenig, the defendant. Silence from Alexa Bartell because Joseph Koenig was in the driver's seat. Joseph Koenig was in the driver's seat not only insofar as he was physically in the driver's seat for the entirety of April 19th of 2023, as these 3 young men terrorized the town, but Joseph Koenig was not only physically and literally in the driver's seat, he is figuratively in the driver's seat, which means he knows damn well what he was doing, what he was going to do before he did it, and what he had done. Joseph Koenig was in the driver's seat. His attacks were proven to be frequent. No doubt about that. His attacks were always focused right on that driver's windshield area of all of the vehicles that were hit. And his attacks finally turned fatal, because that was the ultimate goal. We don't have a burden to prove to you all that the thought that was in his head simultaneously with throwing that rock and allowing it to shot put out of his hand, we don't have to prove to you all that that last thought was, as soon as I throw this, the person driving is going to die. We have to prove to you that he knew what his conduct entailed, that he knew that that conduct created a grave risk of death, and that in doing so, he caused the death of Alexa Bartell, and that the circumstances surrounding manifested that universal malice.
I'm going to object. That's a misstatement of the law. Knowingly applies to more elements, reducing the burden.
The attorneys may comment on the elements of the case and the law that the jury has been instructed in. The jury must follow the court's instructions. It is correct that the knowingly element applies to the following elements listed in the instruction after knowingly. You may resume.
Thank you, Your Honor. The people don't disagree with defense counsel or the court. The knowingly does apply. Let's talk through some of the reasons that we can feel confident in terms of what we know, what the evidence showed about the defendant's state of mind. Now, this isn't about his mental condition. Mental condition and state of mind are different topics. You're allowed to use the evidence put on about his mental condition in terms of the circumstances that surrounded his knowledge. You're allowed to use it. You're also allowed to disregard anything you heard from those experts, because you heard two experts sit on that stand and simply affix a bunch of scientific terminology to common sense. As you enter the courtroom, you don't abandon your common sense at that door. You take it with you, and you take it with you back into the deliberation room. You're allowed to use your common sense when you're working through the facts in this case. Unless and until the legislature of this state decides that ADHD is an affirmative defense to murder, the people have no burden to disprove the fact that Joseph Koenig has ADHD. He can have it, he cannot have it. That's not relevant. That's not an element. We're asking you to focus on the elements and focus on the other factors that show that state of mind, that knowledge. Now, you're going to get a packet with all of those jury instructions that the judge read through. Nobody expects you to have retained all of that information. It's very dense. But what I'm going to ask you to focus on in terms of knowledge, first of all, is the concept of direct versus circumstantial evidence. Now, you're going to see in the definition of knowingly that both direct and circumstantial evidence can be used by you in determining whether someone did something knowingly. You don't have to just have a direct statement from the defendant's mouth about his knowledge. You're allowed to use the surrounding circumstances, other relevant facts to determine his state of mind. And that's what we're asking you to do. It stands to reason that the majority of crimes don't necessarily have some kind of manifesto attached to them. We're not here talking about premeditated murder in the first degree occurring after deliberation. I talked to you all in jury selection about that. We're talking about an entirely different concept of murder in the first degree. We don't have to prove that Joseph Koenig was trying to commit murder, that he planned out every single step of how he was going to commit a murder. That's not what the statute says. So in addition to paying attention to the fact that you can use both direct and circumstantial evidence, I ask you to focus on universal malice and that definition that you're given in your instructions. Because that definition of universal malice says that you take into account the conduct when you're determining whether somebody is manifesting universal malice. It doesn't say you just take into account their statements, their conduct. You have significant evidence of the conduct in this case. We're not here talking about charges that we brought of manslaughter because we didn't bring charges of manslaughter. We didn't bring charges of manslaughter because this is murder. This is murder, and manslaughter is a mere fraction of what Joseph Koenig did. We're not here talking about Joseph Koenig speeding somewhere between 80 and 100 miles per hour and hitting Alexa Bartell head on, and that's what caused her death. Maybe then we'd be talking about recklessness. We're not talking about recklessness. We're talking about knowledge of volitional acts. That's what applies here. Joseph Koenig was in the driver's seat. Joseph Koenig and Nicholas Karolchik had gone together on previous occasions up to 10 times, according to Mr. Karolchik's testimony. They'd caused the type of damage to oncoming drivers prior to April 19th, 2023, dating back to 2 months prior. April 19th, 2023 did not constitute an escalation that came out of nowhere, and just because of the missing ingredient of Zachary Kwok being added into the mix. Joseph Koenig and Nicholas Karolchik did the same things prior. Sure, there were more incidents on the night of April 19th, 2023, but it was the same conduct. You also heard about how Joseph Koenig was the one who reached out to Nicholas Karolchik to hang out. They were focused on doing something with Joseph Koenig's truck because he flips old cars. That's his hobby. He has a job in the automotive industry. He is able to flip cars, very adult job, very adult hobby, all while balancing his school. Joseph Koenig was the one who reached out to Zachary Kwok. Joseph Koenig was the one who reached out to Joseph Bopp. Joseph Koenig's phone was connected to the car. Joseph Koenig told others to collect rocks at the Walmart. Joseph Koenig drove for hours and hours and hours and hours. This wasn't a crime spree that took 45 minutes in total. You heard investigator Menka talk about the fact that even just driving the route, start to finish, no stops, 3 straight hours. Adding in all their stops, hours and hours of this night, Joseph Koenig was in the driver's seat. Joseph Koenig picked up the rock from the center console. Joseph Koenig used a specific arm motion that he preferred to throw that rock at Alexa Bartell. Joseph Koenig made active choices time and time and time and time and time and time again. You don't have to believe he threw it, but he did. Joseph Koenig was in the driver's seat. Alexa Bartell's silence is the sound that endures because Joseph Koenig was in the driver's seat. He turned that car around and around and around. Oh shit, we got to see that again. We got to go back. Not just once, but let's go back multiple times. Joseph Koenig coordinated with Nicholas Karolchik that they weren't going to talk about this. Don't say anything. Joseph Koenig coordinated a backup plan to use the scapegoat that they'd added into the mix in Zachary Kwok. Well, if police get to us, blame it on him. Joseph Koenig knew damn well exactly what he was doing. This is murder. It's murder in the first degree because our legislature gave us this particular iteration of murder in the first degree as murder with an extreme indifference mental state. Joseph Koenig is also guilty of attempted murder in the first degree because just because you don't bat 1,000 doesn't mean your grand slam doesn't count. Near misses by inches or feet were still a substantial step toward murder. Substantial step does not mean that he was trying to commit murder. It's still that same knowingly mental state that applies. It just means that he acted in the same way. We meet the same elements, but he missed. Joseph Koenig was in the driver's seat, and he is guilty of murder in the first degree, as well as 9 additional counts of attempted murder in the first degree. That sound of silence resounds because Joseph Koenig was in the driver's seat.
Instruction number 42. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and the verdict forms at the end of the case. Instruction number 43. The bailiff will now escort you to the jury room, where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on according to the rules that I am about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. Only one verdict shall be returned signed for each count. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 19 verdict forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. I will now read to you and describe to you the verdict forms. You must not draw any inferences based on the order in which I read them. The verdict forms you will receive read as follows. So, as to count 1, this is the charge of murder in the first degree. There's a Roman numeral 1 and a Roman numeral 2. Roman numeral 1 reads, "We, the jury, find the defendant, Joseph Edwin Koenig, not guilty of count number 1, murder in the first degree, and the lesser included offenses of murder in the second degree and reckless manslaughter, and a place for the foreperson to sign." Roman numeral 2 reads, "We, the jury, find the defendant, Joseph Edwin Koenig, guilty of," and then a place to mark either murder in the first degree or murder in the second degree or reckless manslaughter by placing an X in the appropriate box, and then a place for the foreperson to sign. The foreperson obviously will sign one or the other, not both. For counts 2 through 7, 14, 16, and 17, the verdict form operates basically the same way, but these pertain to the charge of attempt to commit murder in the first degree. Count 2 pertains to the alleged victim, Max Mueller, for instance. Roman numeral 1 reads, "We, the jury, find the defendant, Joseph Edwin Koenig, not guilty of count number 2, attempt to commit murder in the first degree, and the lesser included offenses of attempt to commit murder in the second degree, attempt to commit reckless manslaughter, and reckless endangerment, with a place for the foreperson to sign." Roman numeral 2 reads, "We, the jury, find the defendant, Joseph Edwin Koenig, guilty of," and then a place to mark either attempt to commit murder in the first degree or attempt to commit murder in the second degree, or attempt to commit reckless manslaughter or reckless endangerment by marking an X in the appropriate box, and then a place for the foreperson to sign. As described before, the foreperson signs under Roman numeral 1 or Roman numeral 2, not both. As I mentioned, that same count is alleged in counts 2 through 7, 14, 16, and 17. Turning to count 8, this operates the same way. However, it pertains to the charge of assault in the second degree. for 8 through 10. Roman numeral 1 to reflect a finding of not guilty, and Roman numeral 2 to reflect a finding of guilty, with a place for the foreperson to mark either assault in the second degree or assault in the third degree or reckless endangerment. Again, the foreperson would sign one or the other, not both. That charge is alleged in counts 8, 9, and 10. And then counts 11 through 13, 15, 18, and 19 allege the charge of attempt to commit assault in the second degree. Roman numeral 1 for a finding of not guilty. Roman numeral 2 for a finding of guilty, with the place for the jury to mark the appropriate level of either alleged attempt to commit assault in the second degree or attempt to commit assault in the third degree or reckless endangerment. On these counts, the foreperson will also sign one or the other and not both. For each of them, it is a Roman numeral 1 for finding of not guilty, Roman numeral 2 for finding of guilty, and one verdict form pertains to each charge you've heard about. So this time, we will let you go and begin your deliberations. There is one final matter that you might be mindful of that we do have to address, and that is that members of the jury, you'll recall that we seated alternate in this case, alternates. And there is one alternate in this case at this time, and this time I have to announce who that is. As I do so, and before I do so, I want to remind you that I chose the seat numbers for alternate jurors randomly. We choose the seat number before we even know who is summoned for jury service. So it just depends on where you're seated when we begin the case. So for this case, the alternate in this case is the juror who was seated in seat number 9 at the beginning of this case. We're going to ask the alternate to remain behind here for a moment. And I'll have further instruction for the alternate. The remainder of you can begin your deliberations at this time. Thank you. Please be seated. We are outside the presence of the other jurors. We remain in the jury or in the courtroom with the alternate juror. What I wanted to do is thank you, first of all, for your time, your attention, and your service. We very much appreciate that. Now, if you're willing, and I emphasize it's just picked by random seat, in a moment, we'll give you an opportunity to retrieve any personal belongings you might have in the jury room and that sort of thing, and you will be excused with the thanks of the court. However, for now, what I'd ask of you is if you're willing to keep following those instructions. So I'm not completely discharging you from jury service yet. I'm excusing you temporarily. If you're so willing, will you continue to follow all the instructions I've been giving you? And the reason is that there's a chance that if one of the jurors deliberating unexpectedly becomes unavailable, I may be in a position to call on you to replace that juror. So you may go about your life as you were doing before you first reported for jury service. But if you would, please, you must continue to follow the instructions until my staff notifies you that you are discharged. In other words, do not discuss the case with anyone until that time, and do not do any form of independent investigation, research, or any sort of thing electronically about the case. Do you understand that? Are you willing to do that?
Yes.
We very much appreciate that. I'll ask the bailiff to make sure we have really good contact information for you. We will let you know when the case has concluded, and at that time, you may discuss the case. Once the bailiff notifies you, you can discuss it with whomever you choose. That is entirely your decision. And it's proper for others to discuss the case with you at that point, but you need not do so. And I have full anticipation that everyone will respect whatever decision you make with regard to that. If somebody were to persist over your objection, please let us know about that, and we'll make sure we know. Okay. With that, again, thank you. Please make sure you have good contact information for the bailiff. Thank you so much again for your time, your attention, and your service in this matter. And with the instruction, you're excused to be on your way at this time. Thank you very much. Please be seated. If I can make sure that the attorneys are within 10, 15 minutes or so, in case there's any developments, we will reach out to you. The exhibits, I'll ask you each. I know it sounds like you've had some communications and you have the same lists. I have my list up here if you need to triangulate anything, if there's any discrepancies or anything like that. We'll get the jury the exhibits as soon as we can. The bailiff will be back here for that purpose momentarily. It's 11:30. I don't know what the jury will choose for lunch or if they're at the end of the day. So I guess that prompts my question. Do you all want to be, maybe it just makes sense to do it that way. Do you want to be present if I advise them as they break for lunch and go out their separate ways? Or do you want to waive that and just have me advise them?
The people don't need to be present for that.
Agreed.
Okay, defense doesn't need to either.
No.
And Mr. Koenig as well? And you accept a waiver for, this is just instructing the jury that they will not deliberate when they go to lunch, if there's a couple of them together, that sort of thing. You wish to waive your appearance for that as well? Okay, the court will handle that outside the presence of the parties. Anything else?
Your Honor, is the court going to swear the bailiff?
Yes, thank you. I am.
Right. I don't know what we're waiting for. So, instructions, verdict. I don't know. I have the clock running. Obviously, you guys cannot see it because the camera is off today, but it's at 6 minutes already today. So we'll see how long they take. If they would only take about 2 hours and 45 minutes, like Honey's saying, that would be
Could ask our
amazing.
bailiff to raise your right hand, please.
Ooh, bailiff.
Do you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return with them into court?
I do.
All right, thank you. Anything else? All right, thank you all. We'll be in touch when we hear anything. And thank you. We're off the record. Thanks.
All right, court is off the record. I don't know if they're gonna keep the feed up or not. I'm gonna keep a very, very, very close eye on it because we are not gonna have anyone on X or anything telling us that the verdict is reached in this case. It's just literally movement in court. Hopefully they will live it up. If they not, I don't know. We'll get it somehow, one way or the other. We will get it. I don't know if they're gonna turn off the WebEx thing. I'm gonna keep an eye on it, obviously. But I was thinking, meanwhile, we are waiting for the verdict. We could get started on watching some testimony and some little videos that they are here and there from court TV about this case, and get a bit of a more knowledge of this. So the first one we are gonna be listening to, it's Alexa's mother. She testified. The video that I have is relatively short, but it's good in terms that we're gonna hear from her side. So let's get started on that one. Oh, hang on, need to put some sound.
Her
There you go.
alive.
So we got home that evening and she had told me that she was going to go to Jenna's work and have dinner there because she worked at Old Chicago, and that she'd be staying the night. And I said, okay, because she'd stayed at my house and was there the night before, and we'd spent time together. So I got the dogs. And I was going to take the dogs for a walk. She was still there. And so I got the dogs together and I put them, was getting ready to walk out the door. And I said, you know, I love you, be careful. And then I remember stopping before I went out the door and just had a sense to go back and give her a hug. I mean, we always said I loved you and we spent so much time together, but something just pulled me that night. And so I went back. She was in her room and I went back into her room and I just said, hey, I love you. And I gave her a hug and just said, be careful tonight and be safe and let me know, you know, that you're good. And then I went out the door and I went to walk the dogs. That was the last time I saw her.
You said you told her, let me know if you're good. Is there anything you would ever do to kind of know where she was, keep tabs on her, things like that?
Yeah, I was probably a helicopter parent who got like, I always checked on her and where she was and checked her location. You know, just give yourself peace of mind, know that she's okay.
What kind of car was Alexa driving at that time?
That night she was driving I don't even know what it was called, a yellow
Spark?
Spark, yes, thank you. A yellow Spark. It was her dad's girlfriend's car that she was borrowing.
Was that not her car that she usually drove?
No.
What-
She had a Jeep Liberty and she had it in the shop getting fixed.
Did you hear from her girlfriend, Jenna Griggs, later that night?
Yeah, yes.
About what time in the evening was that?
It was a little after 11:10, I think.
And what was Jenna Griggs' demeanor on that phone call with you?
She was confused. I could tell she was a little panicked. She said, I'm sorry, I'm calling you. I'm probably panicking over nothing. It's probably nothing. I'm sorry. But I can't get a hold of Alexa. I was talking to her and the call dropped.
What did you do once you heard that?
Well, she said I checked her location and it was on Indiana and it's not moving. And so I said, she said, I'm driving towards her. I'm driving to where it is on Indiana. And I said, keep driving. Let me try to get a hold of her.
All right, so that was the mom. That was a bit short, but that was all that we had about the mom. It was absolutely heartbreaking. You know, it's having to witness this, and the feeling that she had, she was describing about having to witness that is just heartbreaking. Okay, the next one, it says on the title that it's Kelly Bartell. On learning that Alexa died, I screamed and fell to the ground. But the person that is on the stand, it looks like the mother still, so I don't know, but let's just watch no matter what. Let me do the share screen to this one and then put it like that.
Her location,
It is.
and it was Indiana. But then I zoomed in and it wasn't on the road. Oh, sorry, it was off the road. It's like in the field. And I didn't understand what it could be. She called back, or I called her back, I'm not sure. And she said, I said, she's not answering me either. And she said, I'm almost there. And I don't remember what else we talked about, what could have happened. And she got there and she said, I'm at the spot on Indiana. And she's not here. She's not here, Kelly. I don't know where she is. And I said, look in the field, because it shows she's in the field. And she goes, oh my God. She's in the field. I see her car. And I said, please call 911. I'm on my way. I will be right there. I'll go to her. Go to her, please. I'm on my way.
You told Jenna to go to Alexa's car in the field. Had you also called 911?
I did. I don't remember. I put sweats on or something, and as I was running out the door, I called my sister and said, I don't know what's happening, but Alexa's car is in the field and she's not answering her phone. And so I went out the door and she said, I'm on my way. And when I got in my car, I called 911 and said what had happened and that I was going there. And I don't know, but I think we need emergency vehicles there and for them to get it, but they wouldn't send them because I wasn't there and I couldn't confirm what was happening or what had happened.
And so once you get dressed a little bit after 11 o'clock at night, do you go there?
Yeah.
How long do you think it took from your home to get there?
I think it's 5-10 minutes, if that. I don't think it's that far.
And what did you see when you arrived near this area where
I
you
could see the lights. Before I even got there, I could see all the lights. So I knew that. And I realized it was going to be something bad because there was a lot of lights.
And when you say lights, are you talking about emergency?
Yeah, sorry, the ambulance, I think fire trucks and
Police.
There was a lot of vehicles there.
And so amongst all these vehicles, fire trucks, ambulance, police, what did you do once you got towards those vehicles?
I saw Jenna's car in the field as well, and I saw her car, and so I pulled off the road down to the fence, and then I just instantly ran to the ambulance because I thought she would be in there. So I ran through the fence to where the ambulance was, and she wasn't there, and nobody was saying anything. So I was just looking around and I saw her car, so I ran to her car. But there was a policeman or firefighter, I'm not sure, standing there. he said, you can't go see her. And I just remember standing there. I feel like it was forever. I don't know how long I stood there trying to figure out what was happening. And then I think it just all clicked. I don't know. Then I just screamed and fell to the ground and just realized something bad had happened.
Did responders tell you that Alexa was dead?
I honestly don't know if they did or didn't. I think I figured it out, but I don't remember. I think when my sister and brother-in-law arrived and I don't remember. I think I said, I think she's gone. And my sister was down on the ground with me. We were screaming. And then my brother-in-law went and talked to
You might
the
not reply
cops that I
anymore
think they
because
told
it's after
him.
5 o'clock.
Were you able to verify that it was in fact Alexa who was killed?
He came back and told us.
And you mentioned you weren't allowed to go see your daughter, correct?
Correct.
Did you hold a memorial service for her in the coming weeks?
Yeah.
It's okay.
Establishing identity of the decedent.
Overruled for now.
Did you?
Yes, I did.
Okay. No further questions.
Oh, sorry.
Cross-examination?
Hang on. I forgot that the
You don't have
mic
any
was on.
questions. Thank you.
Oh my days, I am so sorry. I had the microphone on. And I was having a meltdown over here. I'm so sorry. Oh my days. Great. My apologies. I was having just a small meltdown. Everything is fine. Well, it's not fine, but it's fine. My apologies, and now I've lost the thing that I had up. I apologize. I am so sorry, you guys. Oh my days, this is not going very well, is it? Everything is fine. Don't worry. I'll be okay. It's let's get crack on, and I will be sure now to make sure that my thing is off. So now the next video, stop it. It's actually a long one, which is good because that gives me time to go under, sorry, a rock, and to not live that place for forever. So, and thank you for alerting me to that fact. So now we are just gonna see the video that is with the surviving victims, because obviously this got this three young teenagers, right? They were throwing rocks at several people, not just one. um Actually, there's a whole thing that Core TV did, and we're gonna watch the whole things to give us a bit of more context on a case. So the surviving victims of that whole incident describe having the rocks thrown at their vehicles. So we're just gonna watch that one for now, and yeah, just carry on like we've been doing until a verdict is reached. I am refreshing the page every like 2 minutes or 3 minutes just to see if there was a verdict, because obviously they turn off the link and everything, so now they will, I think they will only come back when there is a verdict or a question, and that obviously is something that I'm gonna have to check manually every so often, obviously. So yeah, so let's just get cracking with the video and me turning off the mic.
Court TV is bringing you the rock-throwing murder trial for a 20-year-old. The defendant is Joseph Koenig in Colorado. Now, this trial began on Monday while we were bringing you the Lori Daybell trial. So today, we are bringing you key moments from this really compelling Colorado trial. Koenig is accused of first-degree murder for throwing a rock at a young driver's car that smashed her windshield and killed her. The prosecution claims that Koenig was one of 3 then 18-year-olds who threw rocks at cars in April of 2023. 2 of the teens took plea deals, and they are scheduled to testify against Koenig. Before we bring you more testimony, let's get you caught up on this case. 20-year-old Alexa Bartell was killed on April 19th of 2023 when she was hit by a rock that was thrown at her windshield. Joseph Koenig, Zachary Kwok, and Nicholas Kirillchik were arrested and charged with first-degree murder. Several other people were injured by rocks that they threw during joyrides.
Throwing large landscaping rocks primarily at oncoming drivers as they passed, creating enough force for those rocks to smash through windshields, to destroy the bodies of cars, to destroy the bodies of humans.
Kwok and Kirillchik took plea deals and will be sentenced next month. They say it was Koenig who threw the fatal rock. Koenig pleaded not guilty.
The defendant reaches across his body, grabs this landscaping rock with his left dominant hand, and throws it outside the driver's side window as she passes like a shot put.
Koenig's defense attorney doesn't dispute that his client was involved, but he says Koenig did not throw the fatal rock and argues that his actions do not warrant a murder charge.
He didn't intend to hurt anyone. In Mr. Koenig's mind, he wasn't targeting drivers. They were throwing rocks at cars. The evidence will clearly show that Zach Kwok and not Joe Koenig threw the final rock of that night, the rock that killed Alexa Bartell.
Let's get you back into testimony now. We're picking it up with the final moments of the direct examination of Eleanor Davis. She's one whose car was hit by one of those rocks thrown on the highway.
Had you seen where this rock had come from?
Somewhere off the left side of my car.
Did you see any cars or trucks or vehicles coming in the opposite direction at that time?
I did not.
Is Highway 93 a dark road?
Yes, it is.
Are there many lights on that road?
No.
Were you in an area where it was dark out?
Yes.
And so once you pulled over and assessed the damage to yourself and your car, what did you do next?
I determined that I may still be in danger, that there was a rock in my car, and obviously that had to have come from somewhere. If whoever, whatever, had put that rock in my car were to come back, I did not want to be where I was. So I decided I had a choice between going home to my parents, about 24 minutes, and turning back around and going home, which was about 14 minutes. And I decided that my parents would be more apt to provide me with support and medical attention. And so I decided to go home to my parents' place.
And while you were parked on the side of the road and making that decision, how long did that all take?
I don't know.
A couple of minutes?
Probably.
Were you
more than 10.
Did you call 911 at that point?
I was too terrified.
Did you call anybody at that point?
No.
Did you have your cell phone on you?
I did.
Okay.
So I had one hand on the wheel and one holding my neck.
In terms of you holding your neck, were you still in pain when you decided to continue driving to your parents' home?
Yes.
What was your pain level?
It's hard to remember the exact level of pain because reflecting on pain is a difficult and subjective experience. I would say that it was greater than I would have liked.
Do you remember telling Officer Whitesides that you were trying to force the pain down to a 4 out of 10?
Yes.
And it had been kind of a 6 out of 10?
Yes.
Is that true?
Yes.
Did you ever call a friend, Charles Latau, if I'm saying that? And tell us when you called him.
I believe I called him, I want to say around 11:30. The exact time is not salient to me.
Was that after you'd arrived at your
Yes,
parents'?
it was after I arrived at my parents' place.
And did you tell your friend what had happened to you that night?
Yes, I did.
So you mentioned that from where you braked on the side of the road, it was about, did you say 24 or 26 minutes to get to your parents' home?
24.
And did it take you about that long to get to your parents' home in Littleton?
Probably took a little bit longer because I was driving cautiously, given that I had a hole in my front windshield and my back windshield was entirely blown out.
Once you got home, what did you do?
I thought it would be funny if I startled my parents. And so I acted like everything was normal. I walked in, I greeted my stepfather. I walked into the kitchen and I said, "Hey, Mom, it's good to see you." And she, of course, didn't pick up that anything was wrong. And so she, with her back to me, says, "Oh, hey, honey, it's good to see you too." And that's kind of when the tension of the moment snapped. And I asked her to look at me. And I still hadn't seen the full extent of the damage to my face because my mirror had been blown out. So when she turns around and I see the look of horror that eclipses her expression, I realize how bad I must look.
And so you had injuries that were visible to her at that time?
Yes. Lacerations across my face and neck.
To be clear, was there glass still on your body?
There was, yes.
Where was it?
It was in various nooks and crannies. As I said, some of it got in my mouth. I was pulling glass out of my eyes and ears for at least 24 hours. And it was the thing about windshields when they break is that they kind of powder. And so there was this kind of powdery glass filament in a lot of the creases of my clothes.
So did you get in the shower with your clothes on?
I did, yes.
Is Exhibit 60 a fair and accurate representation of how you looked when you got home that night of April 19th, 2023?
When I got home in the moment, I looked much less cheerful.
Describe that. Why do you look cheerful in this photo?
I look cheerful in this photo because when somebody's gone through enough horrific experiences, as I have, you learn that there's not much else you can do but react to it in a way that makes you feel stronger.
And did this smile that you have in this photo make you feel stronger?
Yes.
Relevance and leading.
Permit the leading as to that question overruled. You may raise further objections as we go.
Your answer was yes?
Yes.
Did you do a closer assessment of your car and its damage than you were able to do while you were off on the side of the road once you got to your parents' home?
Of course, but not until I attended to my wounds.
Right. And after you had tended to your wounds, and I assume changed your clothes, is that when you looked at the damage to your
Yes.
car? What damage did the rock cause to your car?
Well, there was an entry. There's an entry mark through the front windshield. There is a deep indentation in my back seat, approximately 3 inches deep, 5 inches across, where the rock made impact with my back seat. And my back windshield is entirely blown out.
If you'd please look at,
furthermore, the rear view mirror is gone.
Morning, Ms. Davis.
Good morning.
Just want to ask you a couple clarifying questions about your testimony that you just gave.
Of course.
Pertaining to Life 360, does that also track your speed?
It does, I believe.
Do you know what your speed was from that night?
I do not.
Okay. The other question I want to ask you about is at the beginning of your testimony, you talked about just before your car was hit, you thought you saw a bird or a hawk or something. Do you recall that testimony?
Yes.
And then it was about a second or two when your car was actually hit by the object?
Yes.
When you saw what you thought was a bird, where was it in your field of vision? You recall? Up?
Mm-hmm.
I'm sorry.
If I were to be looking straight at the road, this would be where I saw the object.
Okay. And can you recall the trajectory of the object? Was it moving straight? Was it coming down? Do you recall?
It moved in an arc.
Okay. Thank you. No further questions.
Let's welcome our guest for this hour, defense attorney, former head prosecutor Bob Bianchi. Bob, great to have you on. So glad you're on with.
You dance with the one you detailed description of the going through. Excellent witness, and you dance with
That the jury just the cross-exam
Convicted for the murders of her.
them. There were 3
For work, Mr. Smith,
I'm a program manager at Google.
can you please introduce yourself to the jury?
Yes, my name is Brian Smith.
Common spelling.
Common spelling, yes.
What do you do for work, Mr. Smith?
I'm a program manager at Google,
And where do you live?
Netherlands.
And what kind of car do you drive?
I was driving at the time a Subaru Forester.
And when you say you were driving at the time, you obviously know why you're here.
Yes.
We're going to talk about what happened to you on April 19th of 2023. So you're driving a different vehicle now than you were driving on that date?
We still have that vehicle, but that's my wife's, and I have mine.
Okay. On April 19th, 2023, what was the make and model and color of the car you were driving that night?
It was a black Subaru Forester.
And the year being a 2021?
Correct.
And if I could just have you turn over the reports in front of you.
Just turn them.
Oh, yes.
Where were you driving that night around 10:30? Where were you going from and where were you going to?
I was on my way back from Denver International, and I was going back to my house.
The airport?
Yes, the airport.
Were you driving behind anyone?
I was.
What kind of car were you driving behind?
Minivan.
How far behind the minivan were you?
2 to 3 vehicle lengths, the kind of a standard distance for that speed.
Was anyone coming northbound, rather driving northbound while you and the minivan were driving southbound?
Yes.
And what happened when you and the minivan were driving southbound and someone else was coming northbound?
So the vehicle coming northbound, something came out. I wasn't sure if it was a pickup truck or a flatbed truck, but something came off the back of the truck, struck the minivan in front of me, and then came off the minivan's vehicle and hit my vehicle.
And so describe what you could see, given that it was nighttime. How were you able to make out that this was either a flatbed truck or a pickup truck?
I mean, generally, I'm pretty observative. And when something came off the back, it made it very clear. I wasn't sure if it was ice or something. And then in my side view mirror, I looked back and was able to see that it was a truck of some sort and not a closed top vehicle.
And so did you say that you saw it was a truck after it had passed?
Correct, yes.
And so not before it had passed you, is that fair?
Yes.
And did you see anyone in the truck?
No, it was dark and they had their lights on, so I couldn't see into the vehicle.
And describe what you saw in terms of this truck first passing the minivan in front of you.
So like I said, as it was passing the minivan, I saw something come out of the back. At first, since it was kind of the tail end of winter, I thought it was maybe a sheet of ice or something coming off. But whatever it was struck the vehicle ahead of me and then came and hit me. So all I saw was 2 headlights from the vehicle. So I knew there was a car coming at me, and that was basically it.
So just to be clear, you say all you saw was 2 headlights. Can you be sure where in that flatbed or pickup truck this item came from?
No, I cannot.
And you didn't see anyone in that truck throw anything?
No, I did not.
Was there damage to your car?
Yes.
What was that damage?
Our windshield cracked in multiple spots and our sunroof cracked as well.
Did you take photos of that?
I did not, no.
Did you go get that fixed?
Yes.
You mentioned that you pulled over behind the driver of the minivan. Did you discuss what had just happened to him and to you?
Yes, we did.
And what was that discussion?
So at the time, I mean, I think we were both in shock. We didn't know exactly what happened. We didn't discuss like what we saw. It was mostly I made sure he was okay. I asked if something came out of his vehicle, which did not. And then once I made sure he was okay, he had said he would call the police. And since my wife and I were okay and our vehicle was drivable, we left.
What was the damage that you saw on the side of the road to this minivan?
Just all of the passenger or all of the driver's side windows looked like they were completely blown out. They weren't there. There's glass in the vehicle and outside of the vehicle.
Did you see glass on the road consistent with the glass that had been broken out of this minivan?
Yes.
And so you mentioned you and your wife went home before police arrived?
Yes.
Okay. I have no further questions.
Cross-examination?
No questions.
Mr. Tipton, where do you live?
I currently live in Mississippi now, Gulfport, Mississippi, but I wasn't living in Lakewood for a long time, for most of my life.
For most of your life?
Yes,
Did you just fly in from Mississippi today?
I did.
And were you living in the area on April 14th, this area, on April 19th, 2023?
Yes,
Where were you living?
in Lakewood.
What was your job at that time?
I was and still am a Lyft and Uber operator.
And so describe what that is.
I drive people from A to B and make money while I'm doing it.
What kind of vehicle were you driving on April 19th of 2023?
I was driving a 2014 Chrysler Town and Country.
Is that a minivan?
It is.
What color was it?
Gray, dark gray.
Were you driving that night for Uber and or Lyft?
I was.
And did you have passengers throughout that night?
Not at that time. I had just dropped off some riders in Boulder and I was headed back to Red Rocks to take advantage of the surge rates there. And so I was deadheading to Red Rocks at that time. And
so you said not at that time. Let me ask you some follow-up questions there. And if you could get closer to the microphone.
Sure.
That would be great. Thanks. So I think you understand why you're here for a certain time. So were you driving from Boulder to Red Rocks when and just wait till I finish asking the question, just because we have a court reporter here who has to write down everything we say. So what was your route from Boulder where you had just dropped off some passengers to go to Red Rocks?
Highway 93 southbound.
So what happened on April 19th, 2023 at about 10:15 p.m.?
As I was driving to Red Rocks from Boulder, I was, doing my normal thing, and then I heard a loud smash, and I swerved a little bit and didn't understand what happened, and then cold air was all over, and I looked over my left shoulder, and I'm missing two windows on the back side of my van. So I pulled over right away and in a spot that I could, and that's when another couple pulled up beside me and asked me if I was okay. And I said, yeah, I'm fine. I don't know what happened. Something hit my car.
And were you in the area of 120th and Highway 93 when this something hit your car?
Yes.
How fast were you driving when something hit your car?
Roughly 60 miles an hour, right around the speed limit.
And you said when you were driving 60 miles an hour, you were just doing your normal thing. What's that?
Just driving, paying attention to the road, and just doing what any operator does when you're driving down the road.
And you said earlier you were deadheading to Red Rocks. Just explain what that means.
That's in relevance. Overall, that means I'm trying to acquire a fare, and in doing so, I saw a larger opportunity at Red Rocks than in Boulder. So at that point, I decided not to take a fare. So deadheading means I'm not picking up any riders at that moment so I can get to where the money is going to be more plentiful. And so that's what the deadhead means. It means I was not picking up any riders on my way to that next destination.
So were you alone in your minivan at the time?
Yes.
When you did pick up riders, where did they sit in your minivan?
Objection, relevance.
Overruled.
Riders would sit. I have it with the minivan. I have 2 rows in the back, and then I also have a front passenger seat on the right side. So typically, it will sit in the 2 captain chairs in the middle of the van. So if I had picked up 2 people, then there would be one behind me, the driver, and the one behind the front passenger seat. That's typically where people sit on a regular.
You mentioned that you were going 60 miles an hour and paying attention to the road. When something smashed into your windows behind you, did you see any oncoming vehicles?
Yes, there was 3 vehicles that had passed me at that time. And my first reaction once I saw my windows were blown out, that was to turn around and go chase down the vehicles, but I did not. Instead, I went home and talked to my wife, and that's when we called Jefferson County Sheriff.
And can you describe the sound that you heard at that time?
Very loud crash. More of it was a multitude of like a pop and a crash at the same time. It was very startling.
Did you know what had happened when you heard it?
No.
Did you see anything approaching those windows or you?
No.
Right before the impact, you didn't see anything?
No. It was a very sudden impact, and it was very startling.
And did you, at that time, have the wherewithal to then pull over?
Yes.
And how soon after you heard this impact were you able to pull over?
Probably within the next 30 seconds. As soon as I had a clearing where I was, there was a guardrail. So there was no room on the shoulder to pull over. So I went to the end of the guardrail, and that's when I pulled over.
And did the couple behind you pull into that?
They pulled up next to me and asked me if I was okay. There was no traffic on the road when they pulled up and asked me if I was okay. And then they said, well, something hit our car too. And I was like, well, I don't know what that was. And I said, and then they asked me if I needed their assistance. And I said, no. I said, I'll figure it out. And then they took off.
And what did you do to figure it out? What did you do from there?
Well, I got out of my car and I had looked at the damage that was done and kind of freaked out a little bit on what am I going to do. I said, well, that's the end of my night. I can't go work. I can't have people in a car like that.
Was there glass covering seats at that point?
Everywhere. Over the whole back of the car.
Cross-examination?
No questions.
All right, so that's the victims, the statement of the surviving victims that were there. So now we're getting into the co-defendant side of things. So I'm gonna open this one up and put it here. I'll talk you through the steps. Why did I do that? So hang on. Do not start, dude. No, should go back. Let's go back. I know. Why is my computer not like obeying me today? It's about 10 minutes, 11 minutes, so it's not too bad. I am still keeping an eye on the feed source thing, just to keep an eye, obviously, if they come back with a verdict. So yeah, I am here. I'm doing things. Let's hear this part then.
Was this the rock on Indiana Street that killed Alexa Bartell?
Yes, ma'am.
Where was everyone seated in the truck at that time?
Joseph Koenig was in the driver's seat. Nicholas Karolchik was in the passenger seat, and I was sitting directly behind Nicholas Karolchik.
And so are you on, if you're looking out of the
Passenger
front?
side, ma'am.
Describe turning onto Indiana Street.
I remember hearing last one. Somebody said last one, indicating to me that this was the last one for the night. I remember I remember hearing faster, faster. I remember hearing the noise that the window makes on the highway. I remember it being very cold, and I remember a really loud noise.
Let's back up a little bit. In which direction was defendant Koenig driving?
Southbound?
And how fast was he going when he initially turned on Indiana?
I'm not sure.
Did he speed up?
Yes.
When did he speed up?
I'm not sure.
Were you able to see oncoming headlights of Alexa Bartell's car?
Yes, ma'am.
How were you able to see that?
Indiana Street, from that point is very, very hilly. I believe she was at the top of her eyes while we were at the top of her eyes.
And what happened once you were able to see Miss Bartell's headlights?
Joseph Koenig sped up.
How fast did defendant Koenig speed up?
I saw the digital speedometer saying 103 miles an hour.
How were you able to see the digital speedometer?
From where I was sitting in the vehicle, in the rear passenger side, you could see it through the center of the steering wheel.
When you first saw Miss Bartell's headlights, was it after that you heard the conversation in the car with relation to communicating that this was the last rock being thrown?
Not sure.
Was there an obvious target that was the last one?
Yes, ma'am.
And what was that target?
Alexa Bartell's vehicle.
Who said last one?
I don't remember.
Who said faster, faster?
I believe it would be Mitch that said that.
And did Mr. Koenig go faster and faster?
Yes, ma'am.
Was this the fastest he'd gone that night?
Yes.
Was there anyone else on the roadway at this time?
No, ma'am.
Was it clear to you that someone was going to throw a rock at her?
Yes.
Describe how it was clear to you that that was about to happen.
The window rolled down. I mean, Mitch handed Nicholas Karolchik handed Joseph Koenig a rock. That noise too.
So you mentioned, were you able to see Nicholas Karolchik hand defendant Koenig a rock?
I saw the motion of it.
How did Nicholas Karolchik hand him the rock, that motion that you saw?
Will me making a motion suffice? Kind of like.
So was he picking up a rock from his floorboard and then?
I believe it was in his lap.
So Nicholas Karolchik had a rock in his lap and handed it to defendant Koenig?
Yes, ma'am.
Describe that rock that he handed to defendant Koenig.
I don't think I saw it.
Do you remember calling it a handful?
Yes. Yes.
So you saw it well enough to see that it was a handful, correct?
After it was passed, I saw the outline of it in Joseph Koenig's hand. Didn't see it directly enough to know, but it looked like a handful.
And do you see exhibit 240 at the floor next to you?
I cannot, but I do recall seeing it.
If I may have co-counsel approach and present exhibit 240.
You may.
In looking at Exhibit 240, does that appear consistent to be the rock Nicholas Karolchik handed to Defendant Koenig?
Yes, ma'am.
How so? In what ways is it consistent?
In size.
Was this one of the larger rocks that they threw this night?
Yes, ma'am.
Was it the largest rock?
Cannot say.
You mentioned that Mitch was saying faster, faster, and Defendant Koenig got up to 103 miles per hour. Was that before or after passing Miss Bartell?
Before.
Was he going that speed when passing Miss Bartell?
Oh boy, let's take a break here. It seemed to be a big rock in that bag. We're going to have more key testimony in the rock throwing murder trial.
Tonight on closing argument.
We are following very compelling testimony of Joseph testifying about rock was driver Alexa Bartell's testimony now on cross-examination.
And you testified today that you also heard Mitch saying faster, faster.
Yes.
And you never said that to Investigator Manka when you first talked to him, correct?
I wasn't that kindly towards Mr. Manka at the time.
Okay. And you never said in any of your conversations with Investigator Dahl that you heard Mitch say faster, faster.
I don't know if I brought that up or not.
Okay. So you're agreeing that today is the first time that you've included that detail in your account?
I don't know if it is.
Okay. And you hear Mitch say last one, and Mitch got the rock in his hand and handed it from the passenger seat to Joe. Right?
Yes.
And Joe has one hand on the steering wheel.
Yes.
And from your spot in the back seat, you can see that the speedometer says 103 miles per hour. Right?
Yes.
And your belief is that those kinds of Chevys are regulated that they can't go faster than 98.
In my experience, yes.
And you see Joe roll down the window first, and he's got the rock in his lap, and he's got a hand on the steering wheel.
Yes.
And that's when you hear the sound that an open window at highway speeds makes, right?
Yes.
And rock in his lap, a hand on the wheel, is rolled down the window, and then he turns down the music too.
I believe so.
And with his one hand on the wheel, with his other hand, he lobs it out of the truck.
Yes.
With one hand.
With one hand.
And you saw the headlights that were coming towards your car.
Yes.
You saw a hand go out the window.
Yes.
Right. And after that rock is thrown, then he rolled the window back up.
Yes.
And you described the sound that you heard as being like a rail gun.
Like I said, it was loud. It was very loud.
And a rail gun, if I understand correctly, is a gun that works on a magnetic field rather than an explosive charge. Is that right?
That's not the noise exactly I was referring to. What they do is they launch a large piece of metal, and when it hits a concrete wall, and it makes a very loud noise. That's what I was referring to.
Okay. And while all of this is going on with this rock and 103 miles an hour, you, who believe yourself to be a leader, didn't say, don't throw that. Did you?
I have to live with that every day.
Right. So that was one of the co-defendants' testimony. Oh, excuse me. Of the case. I mean, it is a little bit incriminatory. Like, about the faster quotes that he was saying, but also it's only now coming up with that. It's a little bit weird, not gonna lie. But I mean, I'm sure like they are guilty. I'm not saying that. I'm not saying otherwise. But it's just weird. That's all. Now we're gonna hear from the other from the other um co-defendant person thing. Sorry, hang on. I'm just setting up. Give me a moment. And then and say, I don't know. Let me know what you guys think. Obviously, in the comments below, because this is rather interesting and it's making me think. And I'm still dealing with garden bots that they got complimenting and complaining mixed up and scared the Jesus out of me. But anyway, let's listen to this. There's still no word from the court, by the way. I am keeping an eye on it. I'm refreshing every few minutes and keeping an eye on it just to make sure that we do not miss anything. And I hope we get a verdict. I mean, it would be pretty bad if we didn't. And I need to open a Colorado news station, because I'm sure they will be reporting if there is a verdict or not as well. So yeah, I know he is guilty. I'm not saying otherwise, but it's just crazy. Right. Let me add this back on and listen to this testimony. See what he has to say. Let me turn.
Who threw the rock that killed Alexa Bartell?
Joseph Koenig.
I'd like to talk to you about the crimes you and Joseph Koenig committed together. Did you two start throwing rocks at oncoming cars at least beginning in February of 2023?
Yes, that sounds accurate.
And was it just the two of you who would do this, you and Mr. Koenig?
Yes, at that time it was.
And did you and he, Mr. Koenig, do this even before you knew Zachary Kwok?
Yes, we did.
Generally describe on February 25th, 2023, how that went down, how that happened.
So it started like pretty much any other day. It was just me and Joe hanging out. And at this point, we had already gotten into, for lack of a better word, a habit of throwing these rocks. And up until that point, it was at parked vehicles. But on that day, we were driving, and I believe it was in my truck, and Joseph happened to be driving. And we were on a 2-lane road, and we had rocks in the car because we had been throwing them at parked vehicles. And on that road, we had a oncoming car coming right at us. And Joe lowered his windshield on the driver's side, and he threw one at the car that was coming towards us.
And I'd like to speak with you to start more generally of the incidents on February 25th, the one incident on April 1st that you're charged with and convicted of, and then the incidents on April 19th. So I'm just going to be focusing on those, okay?
Okay.
So on those 3 specific nights, describe how it would begin, the decision that you and Mr. Koenig would make to throw rocks or other items at oncoming cars. On those 3 nights, how would that decision be made?
So as I said, we were already in this habit of doing it with parked vehicles. So whenever it would get late at night, we would go to certain spots to pick up these rocks, and we would just drive around pretty much anywhere, and we would throw them at vehicles parked, or in the cases of the ones that are charged, moving.
You said you would go late at night to collect these rocks and then throw these rocks?
Yes.
Why late at night?
Because it would be harder to see.
Harder for you to see, or harder for people to detect you?
Harder for people to detect us.
On these nights, were you usually driving, or was defendant Koenig usually driving?
It depends. We switched off driving.
Do you remember telling law enforcement that it was usually defendant Koenig who was driving?
Yes, I do.
And that on April 1st, it was you that night who was driving?
Yes, it was.
And are you right-handed?
Yes, I am.
Is defendant Koenig left-handed?
I'm unsure.
Was it easier for you in April of 2023 to throw rocks out of the passenger side window with your dominant hand?
Yes.
How would you throw rocks at oncoming vehicles?
So for oncoming vehicles, what I would do is I would lower my window on the passenger side, and then with my dominant hand, I would go up and over the roof of the truck.
How would defendant Koenig throw rocks at oncoming vehicles when he was driving?
He would have the driver's side window rolled down, and he would, I guess, kind of shot put it with his left hand.
And would you do this at different times or at the same time?
At different times, but mostly sticking to late evening into night.
And that was a bad question. Would you throw these rocks simultaneously or would you take turns throwing them at different cars?
In some cases, we would throw them simultaneously. In others, we would take turns throwing them.
How would you know when to throw a rock at an oncoming car?
We would communicate to each other if there was a car that we saw that we wanted to hit.
And how would you communicate to each other if you saw a car that you wanted to hit?
Mostly we would either say left or right, or in some cases it would just be speed up, and we would know that at that point, that's when we were gonna throw the rocks.
And how were you able to see the oncoming cars at night?
Through their headlights.
Would you have your headlights on?
Yes, we did.
You mentioned you'd say left or right. Was that things like contact left, contact right?
Yes.
Let's talk about the night of February 25th that you started talking about earlier. Was defendant Koenig driving that night?
Yes, he was.
And you mentioned he had a black Ford F-150?
Yes, dark in color.
And so where did you meet up that night of February 25th?
I believe we met up at Joe's house, and it depends on what truck we would take, but when we were using his, I would park on the street in front of his house, and we would use his truck.
And so did you use his truck that night?
I can't recall which truck we used.
Okay. And so you meet up, and then where did you go to collect rocks?
Typically there were a couple of places that we frequently went. We would go out front of the Stanley Lake Library, I believe, on Sims, and in front by where they have the sign for the library, there's a lot of landscaping rocks there.
Really just such senseless activity by 3 18-year-old boys. We're going to pause it there. We'll cut in for Michael Ayala. Back to Colorado and the rock-throwing murder trial for Joseph Koenig. The trial got underway while we were covering Lori Daybell's trial in Arizona. We're bringing it to you now. It is a compelling trial. Koenig is the third and final suspect who was arrested in connection with multiple rock-throwing incidents, including one that killed 20-year-old Alexa Bartell in April of 2023. We're going to go back into court together. We're picking it up now with testimony from the second co-defendant, known as Mitch. Carolchick is his last name. He's getting into the moment the final rock was thrown that killed Alexa Bartell.
Let's talk about the murder of Alexa Bartell. What road was defendant Koenig driving down?
We were going southbound on Indiana.
Can you describe that roadway?
So on that stretch of road, it's very hilly. There's up and down in the road.
Is it well lit?
No, it is not.
Where were you sitting?
I was on the passenger side.
In the front?
Yes.
Where was Zachary Kwok sitting?
He was in the back seat in the middle.
Do you remember saying on January 4th of 2024 that he was in the back passenger seat?
Yes, that seems accurate.
Is that accurate?
Yes.
What did you see as you were at the top of one of those hills?
So while we were at the top of one of those hills, we saw headlights that had just came past the top of another hill that was right in front of us.
Is that who you now know to have been Alexa Bartell driving that car?
Yes.
What did defendant Koenig do with the speed of the truck once he saw these headlights?
So once the headlights were seen, Joe sped up the truck.
What did he do with his driver's side window?
So he, while he was speeding up, he rolled down the window on the driver's side of the truck.
Was this while Alexa Bartell was driving towards you?
Yes.
How fast was he driving?
How fast was Joe driving? He was going close to 80 miles an hour.
Was his window the only window to be rolled down when approaching Alexa Bartell's oncoming car?
Yes.
What did you hear when he rolled his window down?
So at that point, we were going very fast. So the only thing that you could hear was the wind entering through the window.
Did he speed up before or after he rolled his window down?
It was while he was speeding up that he rolled his window down.
You said he was going about 80 miles an hour when he passed Miss Bartell?
Yes.
How do you know that?
It is because when we were driving past the car, I was tracking it as I was coming towards us. And I was following the way it moved. And when it was beside our vehicle and to the left of it, I was able to look over, and on the dashboard is a digital speedometer. So I saw that he was going 80.
Was Miss Bartell going at normal speeds for that road?
Yes.
Did you hand Joseph Koenig a rock as you had been handing him rocks throughout the night?
I had set it on the center console like I had been doing all night.
Did you put it on the center console for him once you saw Miss Bartell's headlights?
Yes.
Describe how you handed him the rock on that center console.
So I would reach between my legs on the floorboard where the rock was, and I would set it on top of the center console for him to grab.
On this occasion, describe how he grabbed that rock from the center console.
So he had his right hand on the steering wheel, and he reached across his body with his left hand to grab the rock off the center console.
What did he do with that rock once he grabbed it with his left hand?
At that point, his window had already been rolled down. So when the vehicle got close to us, he threw it out of his side of the vehicle.
Was anything said in the car before he passed Alexa Bartell's car?
He was told to speed up while he was driving.
He was told to speed up?
Yes.
Who told him to speed up?
Zach said to speed up.
And did he?
He did.
Was anything else said in the car about this rock?
We said that this was going to be the final one and that we were just going to go home after it.
So someone in the car said last one?
Yeah.
Objection leading.
Sustained.
Did someone in the car say last one?
It was said that this would be the last rock.
Who said that?
I can't remember who exactly said it.
Could it have been you?
It could have been, yes.
Describe what defendant Koenig did with this rock as he crossed paths with Alexa Bartell?
So, like he had been doing all night, he, with his left hand, threw it out of the driver's side window into the path of the car that was oncoming.
Had you had enough time to identify Miss Bartell as a target?
No, we had just seen the car coming at us, and that was that.
What did you hear once he threw the rock at Alexa Bartell?
So, with how we were going, we couldn't hear anything other than the wind. It was when we had passed the car that Zach looked out the rear windshield and he said to us, I think they went down into the ditch.
What did Defendant Koenig do once Zach said he saw the car go into a ditch?
So he said, holy and then it was said that we have to go back and see that.
Clearly, you can tell his voice is trembling, quivering. Let us know what you think. Do you believe that he's upset by what happened? We're going to take a
Saturday, 5 p.m.
We are listening murder trial. His defense attorney is a patient.
Kind of voice that he does.
When have you heard him do this high-pitched little voice that he does before?
He did it often when we were hanging out.
In what contexts?
It could be just about anything.
After Zachary Kwok said he saw this car go off the road, did Joe do anything?
So it was at that point that we pulled over onto the side of the road and we did a U-turn. So now we were facing northbound. And it was while we were facing northbound that we pulled onto the shoulder of the road. And me and Zach took the remaining rocks that were in our car and we threw them out into the shoulder of the road right there where we were parked.
Why'd you do that?
Because we just wanted to get rid of everything.
Did you consider the rocks to be evidence?
I guess so, yes.
Once you and Mr. Kwok threw the remaining rocks you had out of the car on the shoulder of the road, where did Defendant Koenig drive to?
So it was at that point that we continued going northbound. And it was then that we saw the car pulled over on the side of the road. And it was down in this ditch. And it was at that point that we kept driving past it. And then we turned around again for a third time. So we were coming back down south on Indiana. And at that point, we were going slower. And through the back windshield, Zach took a photo of the car.
To clarify, you say when you passed Alexa Bartell's car, now going in the opposite direction from which you had been, you saw her pulled over on the side of the road. She wasn't on the side of the road, to be clear, right?
No.
Was she in the middle of a field?
Yes.
Had she gone down an embankment?
Yes.
Had she gone through a...
Leading. Sustained.
Can you describe where her car had traveled?
As we were passing, we could see that it was several yards off of the road and that it was that it had been in the middle of this embankment.
And then you mentioned that Mr. Kwok took a photo of her car in the field. Tell us about that.
So that was on our third time passing when we were heading back south on Indiana. And Joe slowed down the car so that Zach could take a photo of it.
And what did he do with that photo?
He sent it to a group text that we had on Snapchat.
And did you see that photo?
Yes.
What could you see in it?
I could see the taillights of a vehicle that was off the road.
Did he tell you why he took that photo?
No.
What did you do with that photo?
I deleted it.
When you passed Alexa Bartell's car off the road, how was defendant Koenig acting?
It's hard to tell. He was excited.
What did that look like?
He kept turning from his seat in the driver's seat to look at me and to look at Zach in the back seat.
And what would he be doing when looking at you and Zach in the back seat?
He would just be smiling, and he would just look at us with his big smile on his face.
And was this after seeing Alexa Bartell's car in the field?
Yes.
When he hit Alexa Bartell, did he make a noise?
I'm not sure I follow.
When either he hit or passed Alexa Bartell's car, did he ever make a whoop sound?
Yes.
Can you describe that whoop sound and when he made that whoop sound?
So it was when we were passing by for the second time that we were going northbound and saw the car on the side of the road that he did that.
Sorry about that. Did not realize the video had finished. But wow, it kept going worse and worse and worse. I mean, it's been an hour and 20 minutes nearly. No movement, no nothing whatsoever from court. I am trying to keep an eye on it. I did found out another way as well to check it, but that one went down. Oh, it's back up now and again. But keeps getting worse. I think. So the next one, right? I left it for the end because we just literally listened to the closings of this case. So we've heard that part. Now I was wondering, and we're gonna watch the opening statements of this trial, because I was thinking after this, that's pretty much the coverage we have on this trial. We can listen to some court. It's still in Colorado, because I found another like trial. We probably could listen to that while we are on verdict watch and be that, because I don't know if it is going to be that long, but we'll see and hang out because it's lunchtime right now. I think all the courts are literally on lunch break. I am looking at them right now, and all the courts in Colorado are on break. So I was thinking after the lunch break, which finishes I think normally in about 10 minutes, we can watch a trial on that same courthouse. But I don't know anything about it, but we just keep ourselves entertained and listening to something while we all do our stuff. But yeah, and I think they are working through deliberations, because I don't think it's gonna take long. I think it's gonna take more time to fill all the paperwork and everything than actually come to a decision, I think, in my opinion. But we did not listen to the whole thing. But anyway, let's listen to the opening statements, which starts right about here. There you go. Hang on. I need to add this to the stage, don't I? That would be helpful. Let's go.
The defendant's attacks were frequent. The defendant's targets were focused. The defendant's weapons were fatal. This is the defendant, Joseph Koenig. This is the man who on 3 separate nights between February and April of 2023 threw landscaping rocks at drivers. To be clear, the defendant wasn't dropping rocks off bridges, off overpasses. The defendant was driving either his truck or his friend's truck and throwing large landscaping rocks primarily at oncoming drivers as they passed. Those relative speeds and velocities combining, creating enough force for that rock, for those rocks, to smash through windshields, to destroy the bodies of cars, to destroy the bodies of humans. The issue in this case will primarily come down to whether the defendant knew he was creating a grave risk of death to others, and whether he did so with an attitude of universal malice and extreme indifference to the value of human life generally. The first rock could have killed Michael Morosco. You'll meet him. He'll tell you that he's driving his truck with his family in it around 10 p.m. that night of February 25th, when suddenly he's hit with a large landscaping rock. It smashes into his windshield, goes over his hood, causes him to drive off the side of the road, crash into a trash can. He's shocked and looks over to his young son beside him, who's covered in glass. The 10th rock killed Alexa Bartell. Unlike the others, you will not meet her. Unlike the others, she will not tell you anything. And that's because of what the defendant intentionally did, purposely, with this rock. You won't hear from her, but you will hear from the last person she spoke with. Her girlfriend of a couple years, Jenna Griggs. It's around 11 o'clock at night on April 1st, 2023, and they're on the phone when suddenly the phone goes dead. Jenna Griggs thinks they're disconnected, so she keeps calling and calling and calling, keeps going to voicemail. Starting to get worried, Jenna looks at where Alexa is on her Find My iPhone app and sees that Alexa is in a field off Indiana Street. So Jenna calls Alexa's mom, Kelly Bartell, and says, I don't want to worry you, but I see that it looks like Alexa is in a field off Indiana. Her mom says, okay, I'll call 911, you go to her. Jenna goes to her. What Jenna sees when she parks next to Alexa's car in that field brings her to hysterics. When Kelly Bartell arrives, she runs into that field. She runs to her daughter's car, and responders stop her. They don't let her go to her daughter. They don't let her go see her daughter, or what was left of her daughter. They don't let her go see her daughter, whose face is not only unrecognizable, but whose face is not there. They don't let her go see her daughter, whose head is an empty cavity because her brain is in the back seat. Nicholas Karolchik was with the defendant on all 3 nights charged. Zachary Kwok was a newer friend, so he was with him for the last. Those 2 were charged. Those 2 took plea agreements. And as a part of those agreements, they've agreed to testify in this trial. So you'll hear from them. They will tell you, focusing on April 21st, what happened in the truck they were in. They see Alexa Bartell's headlights in the distance. over some rolling hills coming towards them. They see her coming, and the defendant speeds up. The defendant rolls down his driver's side window. The defendant reaches across his body, grabs this landscaping rock with his left dominant hand, and throws it outside the driver's side window as she passes like a shot put. It makes a huge sound. And as the forensic pathologist who did the autopsy will tell you, this rock blew through her head like a cannon. As the defendant literally blows her brains out, he whoops. As this rock crashes through her back windshield, he says, holy as this rock deposits part of her brain tissue on the side of the road before it lands in the grass, covered in her DNA, the defendant is excited. The defendant doesn't call 911. The defendant doesn't go check on this driver. The defendant does nothing to help. We don't have to prove he's the one who threw that rock, even though the evidence will. We also don't have to prove the defendant intended to kill Alexa Bartell or intended to kill anyone else. The instruction you will get is that the defendant knowingly engaged in conduct that creates a grave risk of death to someone other than himself. At the end of this trial, we will ask you to find him guilty of all of the charges.
What a powerful opening statement from the prosecution.
The latest developments as arguments tonight on TV. Doomsday cult mom
To murder her.
the cult Monday court TV.
Welcome back. We are against Joe claims 10-year-old 2020 took plea deal. This trial against old Alexa Bartell. Windshield hit a powerful opening Koenig new sentences. So now opening statement.
Joe Koenig's conduct on April 19th, 2023 was a lot of things. It was reckless and dangerous. It was incredibly stupid. And yes, it was absolutely catastrophic, but it was not first-degree murder. Now, this case, and this trial is not about avoiding accountability for Joe Koenig. In fact, at the end of this trial, we're going to ask you to hold Joe Koenig accountable, but we'll ask you to apply the law to the facts and not try to appeal to emotions. And applying the law to the facts, you'll hold him accountable for the offenses he actually committed, not these inflated charges that the prosecution has brought. Joe Koenig made reckless, impulsive, and tragic choices. There's no question about it, but he did not knowingly commit a murder. He did not act with extreme indifference to the value of human life. In fact, he didn't intend to hurt anyone. In Mr. Koenig's mind, he wasn't targeting drivers. They were throwing rocks at cars, as foolish as that sounds today. For the most part, the facts in this case will not be in dispute. On April 19th, 2023, Joe Koenig was in a pickup truck with two friends. One is Nicholas Karolczyk, who he had known for some time. Nicholas Karolczyk goes by the name Mitch, and you will hear him referred to as Mitch throughout this trial. And the other one was Zach Kwok, who he had also hung out with for a little while, but not as long as with Mitch. And each of these boys was 18 years old. Each of these boys was a senior in high school, all three of them. And on the night of April 19th, they were driving around all over Jefferson County because they really had nothing else to do. There certainly was no plan. They weren't heading out to meet friends for dinner or plan to go to a basketball game or anything like that. And there certainly was no plan to cause mayhem. But they all knew basically what they probably would do with the rocks, because all three of these guys had been in the car before when they threw objects at cars. It could have been rocks or glass bottles. And in one case, it was a fiberglass lawn ornament. And the thrill of doing this, as stupid as it sounds to grown adults, was causing damage. It was stupid and it was immature, but not one of the three of these boys ever thought that they would use the rocks to hurt people. And the prosecution will tell you that each and every instance of throwing a rock from their truck at one of these other cars is an attempt to commit first-degree murder. And your common sense will tell you that that can't possibly be the case. There's no dispute that the cause of Alexa Bartell's death was blunt force trauma to her head, caused by the rock that Ms. Decker just set on the ledge in front of you. However, one fact is very much in dispute. And contrary to the theory that the prosecution will pursue, the evidence will clearly show that Zach Kwok and not Joe Koenig threw the final rock of that night, the rock that killed Alexa Bartell. Now, the evidence that you'll hear about who threw that rock will come from two witnesses who are going to testify in this trial, Zach Kwok and Mitch Karolczyk. Both of them were with Joe that night. Both were involved in the same reckless behavior that all of them were. And importantly, both of them have changed their stories about their involvement and about who threw that rock, the last rock of the night, the rock that killed Alexa Bartell. Mr. Kwok pretended to have no recollection of where he had been that Wednesday night. This is the person that the prosecution is going to ask you to believe when he says that Mr. Koenig is the one who threw that rock. It was only when Investigator Manka decided to take a break in the interview and then came back and told Zach Kwok that he had information that people were implicating him as being the one who threw rocks, that Mr. Kwok said, wait a minute, it wasn't me, it was Joe Koenig who threw the rocks. You will also hear that in exchange for telling that story, Zach Kwok is getting a sweetheart deal from these prosecutors. And instead of facing most of the same charges that Mr. Koenig is sitting here facing today, he pled guilty to reduced charges. He'll receive a sentence that is drastically reduced from what he was looking at. I anticipate that you will also hear from Mitch Karolczyk. And Mr. Karolczyk will also come in here and tell you that it was Mr. Koenig. We think that's what he will say, that it was Mr. Koenig who threw that last rock of the night. But you're going to hear that Mr. Karolczyk has changed his story and on multiple occasions has previously said that it was Zach Kwok who threw that rock. All three of them aided and encouraged the others. And because of that, even though the evidence will show that Zach Kwok did throw the rock that killed Alexa Bartell, that won't mean that Mr. Koenig is not guilty. In fact, all three of the boys in that truck, including Joe Koenig, are guilty of causing Alexa Bartell's death. We are not running from that. And when the trial is over, we are not going to ask you to find Joe Koenig not guilty. We're not going to ask you to not hold him accountable. We're going to ask you to find Joe Koenig guilty of the crime he actually committed, manslaughter.
Sorry, guys, I was busy typing in chat. So I am not 100% sure if they went straight to deliberations or they went for lunch or anything, or did they pause for lunch? And we are not sure. We knew on a Lori Vallow case because there was a lot of information about it. But yeah, so I was just interesting that the defense was not saying that he was not involved. He's saying that it did not throw the rock that sadly unalived Alexa. So I don't know. They all need to take responsibility and accountability for their actions and literally just plead guilty and just not make this family suffer anymore, because it's very sad that they are having to go through this for a very, very stupid reason. And then the one thing that was like awful was like the prosecution was describing how the victim end up as, and that is just absolutely horrible to even picture that in our minds. Can you imagine that poor mom that actually saw that and she was there, or like she got there after when the she got the call and she went to the scene of the accident. That is just oh, absolutely crazy. Um Oh yeah, definitely. Definitely lost credibility after hearing they did this 3 times, escalating in their damage each time, and they went back and took. I know, and that is horrible. I absolutely. That is gut wrenching, and that's. I think that's why they have the aggravator factors on that one, and that could be possibly is the demise. Um, I know that is just. I think that's one of the charges. He's facing 19 charges. I literally thought it was the 3 initial charges, but 19. I think it obviously is gonna go for all the other people that is involved in the indictment, but it's wow. It is crazy indeed. I mean, if I wasn't sure from the guilty verdict or anything from before, I am sure now. That is yeah, that testified exactly. So that was like also yeah, for that for sure. So my days, this case is crazy. Absolutely sad and very very heartbreaking indeed. I'm still checking, still nothing. I don't think we're gonna have it just yet. Oh wait, no, hang on. Oh come on, they literally just went live. The court literally just went live. I don't know what it is. The court that I've been scourging and that we have the oh hang on, I need to put there you go. They literally just went live. So I don't know if it is verdict or if it is a question or if it is anything. um I don't know. I have absolutely no clue. So I literally just was like refreshing one more time the source of the feeds and everything for this, and I saw that they went live, the courtroom that we've been waiting for. So I don't know. I don't have any word. This is like, for example, because this is such sadly a small trial that is not being live streamed or anything. Um, there's no one saying that the verdict was reached or any information. So I think that the it might be the afternoon docket even that this is happening, and so I think this might be the afternoon docket, and they are doing the docket while they are on verdict watch. It might not be even verdict, but that's good because we want to stay in this courtroom just in case there is a verdict. So it could be, yeah, could be a completely different case, and it's the same judge. So uh So it's like it's the same judge. So it could be the afternoon docket that is just taking matters in. Um and yeah. And then while we're waiting on verdict, which is good because we want to stay in this courtroom anyway. So we might as well hang out with this judge, even though sometimes it's
Good afternoon. We'll start briefly with 24 CV 30531 Insicon versus Blue Line. I don't expect anyone. Is anybody here for that? Okay, doesn't look like it. And there was a notice of bankruptcy, and then a notice of the judgment creditor not seeking the interrogatories. So we'll vacate this hearing. And I understand we have both criminal matters here at this time.
Yes, Your Honor.
Do you have a preference of which one to start with?
No, Your Honor. Mr. Whitefield was set first in time, so I'm fine calling his case first.
Okay. People versus Adam Lightfield, 11 CR 161.
Your Honor, Jacob Matthews for the people. Mr. Whitefield is pro se today.
Okay, good afternoon.
How you doing?
I'm fine. How are you?
Just hanging in there. A little stressed out standing here, be honest.
It's understandable, and that happens. Well, I don't think you need to be too stressed. You can just kind of let me know what you're thinking, and I might have some questions. And Mr. Matthews here will give us his position, I imagine, and then we'll take it from there. And
so
I'll either grant the petition or not, and then
okay,
that's all.
Perfect.
That's all we have.
That's all we can ask for, right?
Okay. Yep. So let me start with that. What is the people's position on Mr. Lightfield's motion?
Your Honor, this case is a VRA matter. The people are VRA compliant for this petition through reasonable efforts. Since January, we've been attempting to reach out to the named victim via both phone, letter, and text messages with no success. Statutorily, Mr. Whitefield is eligible given he terminated probation in November of 2014, making us more than 10 years out. He does have no new criminal history. We ran a background check and confirmed that. Due to the time period, he is time eligible. He did complete treatment. However, we don't have any other info besides stability or any other info regarding stability in the community. So I would ask for the court to inquire regarding that. Mr. Whitefield did what he was supposed to do statutorily. The concern for the court, frankly, is the facts of this case are egregious. That's our largest concern, but should Mr. Whitefield be able to demonstrate stability with the court today, we don't object to termination.
So can I?
Thank you. Why don't you address that? Start with the people's concern and whatever else you want to address, Mr. Lightfield. And I think what I'm hearing Mr. Matthews stating is that it's stability, meaning like housing and job, employment, you have a place to stay, these kinds of concerns. Do you want to tell me about those?
So those have all stayed the same since this all started. I've owned my own business. It just turned 30 years old in March 1st. Wizard Transmission, I'm still down on Evans. And my housing hasn't changed since all this either. And I'm sorry, so I'm really hard of hearing. I got my hearing aids in, but were you saying I was supposed to reply to those text messages?
No, that was to the victim, not you.
I'm sorry?
Not to you. You're fine. They were to the victim.
Okay.
And if you have trouble hearing, we can keep our voices up, but we do have devices if you need them.
And I do, so I have from Progressive Therapy Systems, what I did when I was under intensive supervision probation, I have Cindy's letter here.
Okay.
And I brought one for you too, Your Honor.
Sure.
Is that okay if and I have another one. I'm still seeing a therapist. I go, well, once a week, not religiously because, life gets in the way of stuff, but trying to not go this.
Thank you. Let me
say, I put my cell phone in I left it in the car so it wouldn't be bothering me because it rings in my ears. But at 6 o'clock, if you're standing next to me right now, 6 o'clock at night, it would go off because when all this started, I had to be home at 6 o'clock at night. So I have kept that little alarm going just as my dad used to always thunk me in the head for screwing up. Just a little, I don't want to get in trouble again. I was running down a wrong path 100 miles an hour when all this took place. And I've been doing my best. I'm still active in my church and my community and got 8 employees working for me and trying to just live right, But as far as my housing, I'm still in the same location.
Okay. And give me what kind of work do you have again?
I own a transmission shop. It's called Wizard Transmission.
Great.
Yeah, been 30 years. I can't believe it's been that long, but.
So this letter confirms completion of treatment, October 15th, 2014.
Yeah.
Wisely, Mr. Lightfield appears to have held on to that, which is good because there's a lot of cases where these things get lost and some of these treatment centers don't keep them. And then we have an issue of trying to confirm that. And then the therapy letter as well from a social worker here. Okay. Yeah, do people wish to be heard any further on this?
No, Your Honor, thank you.
The court is looking at 1622-113, subsection 2E. The court does not have an objection here, nor input from the victim. The waiting time has expired. Thus, it turns to whether the court, and there's not subsequent criminal history, so the issue is if the court can make the finding that petitioner is not likely to commit a subsequent offense of or involving unlawful sexual behavior, the court must consider any treatment records provided pursuant to subsection 2B, any oral or written statement of the victim of the offense, and any other relevant information. I agree that the one concern here is that there are some serious facts involved in this case. That's always something that the court must and does balance because it really turns to the degree of criminal recidivism likeliness, but moreover, the community safety and considering community safety, not only the likelihood of a recidivist event, but also the severity of what that might look like. And in that connection, the facts certainly matter. But the court has before it the treatment records, the successful completion. It's more than 10 years ago. The people had question about stability factors. Mr. Lightfield has more than adequately addressed those in the court's view. He's not only employed, but owns his own business. He's lived in the same house. He's explained his daily patterns and reminders for keeping himself, having a safety plan of anything that he might need. So the court can make that finding and does so. And court finds that the petitioner is not likely to commit a subsequent offense of or involving unlawful sexual behavior. Therefore, the petition to deregister will be granted at this time. I'll hand these papers back to you. I'll send the order out in the mail. It'll be sent to you before long. Let me see if, just want to see. You have your address in the system, I take it? Yes, sir. Yeah, so you. Okay, yep, I see that. You have the Conifer address and that is listed here. So that's where the document will be sent.
Okay,
All right, I'll issue that this afternoon.
thank you, sir. Is there anything else I need to do? Do I need to take anything to the gentleman over here at the police station, the sheriff's office or anything? With all that?
Does that work? It should be taken care of. You
Okay.
will receive the order. So if there's any issues or if you want to verify, you're certainly welcome to drop by the sheriff's office or other agencies to make sure that that
I'd probably
happens.
do that just to be
Sure,
put my mind at ease, you know?
that makes sense.
All right, thank you.
It's all right. Good luck to you.
Yes,
Thank you.
sir. You want that?
Yeah, I'd like to add for my records. Thank you.
Eleven CR 532, People versus Kelby Young.
And Your Honor, Jacob Matthews for the people.
Good afternoon.
Good afternoon.
You are Mr. Young.
I am, Your Honor.
Let's pull up the file here. So the court has reviewed the petition as well as we have a special report from probation, a letter from probation, some community letters, including from a church here, and then what's marked as something that a copy of what probation filed. There's a document from RSA included in there. The people have a position on Mr. Young.
Yes, sure. This is a slightly different matter. This is a non-VRA case. It was a persona case. Mr. Young has no subsequent criminal convictions. Obviously, the court can see the letter from probation indicating that Mr. Young completed treatment and was largely compliant with his probation. Mr. West probation did indicate further that he does support deregistration. Lastly, Mr. Young is statutorily eligible given that the 10 years have elapsed, so we do not object to Mr. Young deregistering today.
Okay, anything else you want me to know, Mr. Young?
I've prepared a lot, but I appreciate appreciate you hearing my petition. We flew here from Maine. My wife is here with me. Our 16-year-old daughter is with my in-laws. We moved from Colorado shortly after my probation ended and subsequently started a farm. So now my wife and I run the business. We have 5 employees that work for us. We have a USDA inspected butcher shop, a commercial food processing business. I have a son that's going into the Navy. He's going to be commissioned officer in the nuclear sub program. We've been very blessed, and I've had a tremendous support around me since my whole life. This has been anxiously awaiting this opportunity, and hope that you're able to see fit.
Okay, well, I tend to agree with the people on a lot of what Mr. Matthews just stated. I do think these kinds of cases are a little different than the ones that involve victims. Not to say that they don't have their own level of seriousness and severity, they do, but I think they are a little different. And not as serious and severe as the ones that do involve real victims. So a persona case is in this court's view to be treated a little less severely. The statutory time frame has passed. I did see that. The people have confirmed that they see no additional criminal history. And the records from probation do report completion of treatment. The probation officer, including one of the chief probation officers here, have supported this petition. I can't see any reason that the court would get in the way of that. The people do not object. There's not a victim. And the court does make the finding at this time that the petitioner is not likely to commit a subsequent offense of or involving unlawful sexual behavior. Consequently, the petition will be granted.
Thank you, Your Honor. Also, thank you, Alexa.
You are welcome. And let me confirm that we have a good address where this is going to go.
Should be the 159 Togus Road, Chelsea, Maine.
Yep, it's in there.
If I may ask, the process with the multi-state is a little convoluted to me. The way I understood it is that I would be required to do some things in Jefferson County before I could then go to the Maine Bureau of Sex Offender Management. Or this has been an interesting process learning about how the interstate laws work.
I'm sure. And I can't give you advice, unfortunately.
Right.
I don't know if Mr. Matthews might have some information that he can give, but that sounds like the right way that I think that'd be appropriate for you to start going about communicating with the sheriff's office in Jefferson County and then going from there. I don't know what Maine's laws in particular, I don't know what those say. So
Basically
that would be where I just have kind of nothing to offer, but Do you have anything?
Judge, I think once someone is deregistered in one state, they then, I don't know if the registering agency out here then transfers it to the supervising state or not. Similar to probation, I think you need to dot the i's and cross t's out here and then circle back with the local agency as well.
That's how I understood it from the reading. And with that being said, I know that you had mentioned mailing the paperwork. I don't want to be presumptive. Is there a way for us to wait around and potentially get that paperwork? Because we do fly back tomorrow.
Okay.
I would love to be able to file things in person if possible.
Yeah, I'll
But I also
grant it right now.
Thank you,
Megan
Your
will
Honor.
do what she needs to do with that information, and we can print a copy for you before you go.
Thank you.
If
I
you want to
appreciate it.
come around kind of to the window, maybe, is that the best for you? It would be minutes. Okay, sure. Okay, yep, we'll do that. We'll provide you a copy before you go.
Thank you.
All right,
Appreciate it.
thank you. Good luck to you.
Right, sorry guys. I am trying to calm myself down. A hot flash wasn't coming. I just trying to calm myself down. I hope you guys don't hear my fan. But if I sound like I am running or cycling, I am not. I will never do that such a thing. So let's see if the judge carries on doing anything in this docket. Otherwise, we can jump to another docket in this courtroom and in the courthouse, and then see what's happening, and then we'll still keep an eye out for the verdict. These are going almost 2 hours. So water balloons, I'm sorry, I am lost to case one. I run away. I turned my head away for a second, and you guys went crazy, which is fine. I like it. I absolutely love it. But I don't know what the conversation is about. Don't ask me. I'm just in my own little world. If she knew, yeah, I don't know. I don't know anything. I do not speak English. I came here to see a case, and no, there's nothing happening. I lost. Oh, definitely lost my place. Yeah. So I think we're just gonna go jump onto another courtroom to see if okay, good. That's all that matters. As long as you guys are having fun and nothing is gonna get me in trouble, that's good, because a lot could get me in trouble, believe me. So let's not, wow, that court is not back yet. I'm just trying to see all above board Sunday school stuff. Oh, I don't know what Sunday school is. No, I'm joking. I do know. I was joking, trying to be funny. Um, like I don't know. They are coming back, like all the courts in Colorado at least. They are coming back from like lunch. They're starting some hearings. I don't know if this judge is gonna carry on something, so we might just bail out from it, go to another one if I find someone doing anything, and then come back to this one if there is a verdict. But so far, nothing. Susie is fun police. Yes, she is. Absolutely. Yeah, that's news now. Sorry. So, oh, it is. Oh, okay. It is 1:30. So do they normally come back like at 2:00? Is it so? Uh, I do not speak English, Hannah. On that, I mean, I don't know. Shall remain in place. Right. Okay. There we go. Zizzy has spoken. She's the boss, the chat boss, not me. I just talk and present court cases and say wild stuff on the thing. Shorts are acceptable. Mini skirts as well. Oh wow, that courtroom has a lot of people in. I think we're gonna go to this courtroom because they seem to have a lot of people. But it seems like just hearings. So, um, oh no, but I mean, no. Maybe I wanna have. Well, yeah, maybe about an hour and a half. Yeah, I would say so. Because I don't know, like it's so weird. They don't tell. Well, obviously this is um a different court than the Arizona that would be a lot of people talking about, but this one it barely has anyone covering or even no one. So we are just playing by ear and go with the flow. And just see what happens. That's good. That's good. That's good that we are. It's we work hard and to be funny and sassy and sarcastic, all the things that Zizi is very good at. So, we love it. We love everyone, and it's just a chill place to hang out and watch court, have fun. It is sometimes very heavy subjects, yes, but we on break times we like to have a little bit fun, a bit of a chat and a wild time. Um. Oh, okay. Right, that one is out. They are out. So let me go and have a look of where we're going now. Hello? Why this is not clicking? I'm clicking in new. Hello? Hello? Okay, let me see if I... Oh, that's so weird. It won't let me click on anything. It was not letting me click on anything. So let me see. Let me see if Latimer County. Where is Latimer County gone? Oh, there. 1A. They seem they are doing stuff. So we're gonna...
Get your name for the record.
Ryan Ashenbrenner.
There you go. We have some hearings.
You're in front of the court. It looks like for a failure to appear. Bond's been set at $100, cash only. In order to not drive without a valid driver's license, to remain law-abiding. And your next court date will be May 2nd, 2025 at 8:30 a.m. in courtroom 5A. Do you have any questions, sir?
How am I gonna get there?
You anticipate remaining in custody in Weld County?
I do, actually.
If the people can file a writ from Weld. Sir, would you like to appear virtually or would you like to appear in person?
Virtually, actually, because I do know one person in Colorado and they're here in Weld County.
Okay, we can do a virtual writ for the people. Okay. Anything else from the people?
What was that next court date, Your Honor?
May 2nd, 2025 at 8:30 a.m. in courtroom 5A.
Thank you.
Mr. Holtz, are you here for Mr. Howland and Mr. Arnold?
That's correct, yes.
Okay. Thank you, Weld County. Deputies, do we have Mr. Howland or Mr. Arnold available?
Yes, Your Honor, I have Mr. Howland on mobile station, I'm sorry, on station 1, and Mr. Arnold refused.
Okay, thank you.
In regards to Mr. Howland, I tried a few times to try to hook him up by phone, and of course, it just schedule myself didn't end up working.
Okay.
Do they have a phone number that I can call real quick to have just a moment to discuss with Mr. Howland?
Deputies, is there a number that Mr. Holtz can call to speak with Mr. Howland, or is a breakout session better?
A breakout session would probably be better at this point.
Okay. Are you able to do breakout session, Mr. Holtz, or? No. Is there a number Mr. Holtz can call? My understanding is he's having some issues with logging into WebEx.
And Your Honor, if you give me just 1 second, I'm going to get station 2 up so that we can use that while they're doing that meeting.
Okay. In the meantime, we'll call Arnold 25 CR 603 and 25M 218, 25M 223, 25M 403, 25M 444. The deputies notified the court that Mr. Arnold is set for a bond hearing today, has refused to appear. I'm inclined to call the case as set bond and bond conditions unless the people or defense have an objection or other suggestion.
I certainly don't necessarily have any objections. I certainly haven't had a chance to talk with Mr. Arnold, and he's refusing to cooperate. So I think the court's really two options, right? To do that today or set it for tomorrow, see if he changes his mind, and then set it tomorrow if he still won't come. And I leave it to the court.
I'm inclined to just call it right now. If that's okay.
No objection.
Okay. It looks like 25M 444. Bond's already been set at $25 PR bond. I'm inclined to leave that as is unless either party wants to make a record. On this matter. Just 1 moment, please. The bond will remain at $25 per recognizance bond. He's already complied with the mandatory protection order that states he shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that acts he's charged with committing. His next court date in this matter will be May 1st, 2025 at 1:30 p.m. in courtroom 4D. 25M. M 403. The bond's been set at a $25 personal recognizance bond. Mr. Arnold's order to remain law abiding. Comply with the mandatory protection order that states he shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that acts he's charged with committing. The next court date in this matter will be May 1st, 2025 at 1:30 p.m. in courtroom 4D. In 2025 M223. The court will leave bond at $100 personal recognizance bond. He's ordered to comply with the mandatory protection that states he shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim actually charged with committing. He's ordered to remain law abiding. His next court date in this matter will be May 1st, 2025 at 1:30 p.m. in courtroom 4D. And 2025 M218. Court will leave the bond as $75 personal recognizance bond. He's ordered to comply with the mandatory protection order that states he shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that acts as charged with committing. He's ordered to remain law abiding. His next court date will be May 1st, 2025 at 1:30 p.m. in courtroom 4D. In regards to 25 CR 603, court did review the affidavit's part of warrantless arrest and did find probable cause. We'll start with the people regarding bond and bond conditions.
In 25 CR 603, based on having multiple cases pending as well as damaging 5 cars, I'm expecting to have a pretty high restitution amount as well as noting the 28 failures to appear. I'd ask for a $2,500 co-PR bond in this case.
Thank you. From the defense.
I don't really have any information here. I'm sure Mr. Arnold would not object to PR bond in this case.
Okay. Knowing the history of 32 misdemeanors, 28 failures to appear, 7 failures to comply, as was mentioned by the people, multiple pending cases, the court will set bond the amount of $3,000 personal or co-signed PR bond. He's ordered to not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that actually charged with committing. The court will order standard pretrial services. The court will authorize NIPS. He's ordered to remain law abiding and report to pretrial services within 24 hours of his release. His next court date on this matter will be May 7, 2025 at 8:30 a.m. in courtroom 3A. Anything else from the people?
No.
From the defense?
Not in this case.
Okay, thank you. And then, deputies, is there a number for Mr. Holtz to call to speak with Mr. Howland? Well, I think they're trying to facilitate that, so we'll just wait if you don't mind hanging out for a second. Deputies, is that Ms. Peeler? Is this Ms. Peeler?
Yes,
Good afternoon. Could you state your name for the record?
Sarah Peeler.
Did you watch a video or read a piece of paper advising you of your rights?
Yes.
Do you have any questions regarding your rights?
No.
Okay. Do you have an opportunity to review the charges against you?
Yes.
Court did review the affidavit in support of warrantless arrest and did find probable cause to restore the people regarding bond and bond conditions. If you could also make a VRA record as well.
Yes, we do have a victim input who does want a no contact order put in place. They will need a civil standby as well. As far as bond, noting there's no similar history, no failures to appear. I don't object to a PR bond in this case.
Okay. Are you requesting a full no contact order?
Yes, I am requesting the full no contact order and the usual DV conditions as well.
Thank you. From the defense, I'm inclined to grant a personal recognizance bond if you want to be heard on bond and bond conditions.
I would just ask for a civil standby, as the DA noted. The alleged victim here and Ms. Peeler do live together currently, so Ms. Peeler will need to get some belongings.
Okay, thank you. The court will grant a $1,250 personal recognizance bond. The court will order that you remain law abiding and that you comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, stay away from any other location the victim is likely to be found. You shall refrain from any contact directly or indirectly. You shall not possess, purchase, control a firearm or other weapon. You shall not possess or purchase any ammunition. You shall relinquish any firearms or ammunition within your control or possession within 24 hours of your release. There will be a 50-yard distance restriction and a civil standby is authorized. Do you have any questions?
No.
Okay. Anything else from the people?
No, Your Honor.
In the defense? Oh, I don't think I gave a court date. If I did, it's May 1st, 2025 at 1:30 p.m. in courtroom L2 at the Loveland Courthouse. Thank you. Deputies, who we have next?
We have Mr. Size on the mobile unit.
Okay. Size 25 CR 615. Good afternoon, sir. Could you state your name for the record?
Chairman Size?
Did you watch a video or read a piece of paper advising you of your rights?
Yes, sir.
Do you have any questions regarding your rights?
No, sir.
Okay. You have an opportunity to review the charges against you?
Yes, sir.
Court did review that, didn't support a warrantless arrest and did find probable cause. We're going to start with the people regarding bond and bond conditions. If you could also make a VRA record as well.
Good afternoon, Your Honor. For the record, David Cheval for the people, it's CHEVAL.
Thank you.
With respect to bond, the people would be requesting $250,000 cash and in support. First, Mr. Sias is currently on probation, being supervised by Larimer County Probation. That was for two things. One, he has a deferred for assault on a peace officer plus a harassment conviction that he's currently on probation for. He has criminal history that dates back to 1988. But most importantly, the allegations in this case, Your Honor, are that Mr. Sias met the victim, eventually ended up in her home and sexually assaulted her. And just for the court to know, I'm sure the court has seen the affidavit, that this is an at-risk individual who has some possibly serious disabilities. I mean, she's physically disabled, needs a wheelchair and a cane to ambulate. She had a traumatic brain injury from a prior automobile accident. So we think that the allegations are very concerning, first of all, but second, we think that the community safety should be a forefront for you to consider when setting a bond in this case. With respect to VRA, I don't have victim's position as we speak.
Any recommendations on bond conditions?
Your Honor, we certainly, of course, the mandatory protection order, I'm sure the court has the
victim's name. If you'd like me to read that, I will.
We have it here in the date of birth as well.
And the address on Harmony Road, Unit 105. Other than that, Your Honor, I believe the conditions up to the court.
Thank you. From the defense?
Yes, Your Honor. Mr. Sias would not be able to post any kind of monetary bond. So understanding the serious allegation here, I would at least ask the court to do a cash surety bond so that he could work through a bondsperson here. Mr. Sias was cooperative with law enforcement in this investigation. Mr. Sias has significant ties to the community. He does have his own apartment. He has been employed at Jiffy Lube for the past 4 years. He has 4 adult sons, as well as his father and his brother, who all live in Colorado. And as the people stated, he is currently on a deferred sentence. It looks like he's about a year into that deferred sentence. He really has no history consistent with this charge here. So I would just ask the court to consider all that in setting bond.
Thank you. In reviewing the affidavits for warrantless arrest, the bond application arguments from the people in the defense, it's clear that there's a community safety concern. If the allegations in the affidavit are true, I understand are only allegations at this point, but the court has a responsibility to take community safety into account when setting bonds, especially on these type of cases. The court's going to set bond in the amount of $125,000 cash only. The court will order intensive retail services. The court will order a GPS prior to release. The order remain law-abiding, report to probation and retail services within 24 hours of your release. You order to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim the action charged with committing. There will be a distance restriction of 100 yards. You're ordered to have no contact with the named victim in the affidavit, with no exceptions to the no contact order. Your next court date will be May 2nd, 2025 at 8:30 a.m. in courtroom 5A. Do you have any questions, sir?
No, sir.
Okay, anything else from the people?
No, Your Honor. Thank
In
you.
the defense?
No, Your Honor.
Thank you. Deputies, who do we have next? Deputies, do we have anyone available? Who do we have on station 2? Who do we have on station 2?
Hannah Shear.
Okay. Shear 25M530. Good afternoon. Could you state your name for the record?
Hannah Shear.
Did you watch a video or read a piece of paper advising you of your rights?
Yes, I did.
Do you have any questions regarding your rights?
No, sir.
Okay. Have you had an opportunity to read the charges or review the charges against you?
Somewhat, yeah.
Would you like me to review them with you?
Please.
Okay. You're facing the charge of third-degree assault as a class 1 misdemeanor with a domestic violence enhancement tag. The court did review the affidavit in support of warrantless arrest and did find probable cause. We'll start with people regarding bond and bond conditions. You could also make a VRA record as well.
Yes, Your Honor. I believe it's Kraleen is present and wanted to address the court on bond conditions.
Okay. You can please come to the podium. If you can state your name for the record and spell your last name and let the court know anything you would like regarding bond conditions.
My name is Logan Breiling, K-R-E-I-L-I-N-G. And
just want to say that I know this isn't who Ken is. I don't want to get a restraining order. I want like that. I feel like it'd be best if we were just separated in different households for a week and to be able to pull our heads down and to be able to fully decide if we want to continue on together or if we want to focus on parenting.
Okay. Anything else you'd like to let the court know?
That's it.
Okay, thank you, sir. From the people regarding bond and bond conditions.
Based on the lack of history, I don't object to the recommended PR bond. As for a protection order, if victim doesn't want one, then I won't request one either. Just the standard mandatory protection order for no harassing behavior. And then the usual DV conditions as far as the firearms ammunition.
Thank you. From the defense, I'm inclined to grant personal recognizance bond if you want to be heard on bond conditions and the no contact order.
Yes, Your Honor. Specifically regarding the no contact order, there are 3 children between Mr. Shear and Mr. Creeling. I think Mr. Creeling's the father of the youngest 2, who are 3 years old and 4 months old. So if the court does impose a no contact order, I would ask that there be an exception carved out for the children being transferred through custody. It sounds like Mr. Creeling's mother perhaps lives in Fort Collins and could maybe assist with some of that. But I just know with a 4-month-old, it'll obviously be hard to transfer the children without them having car seats and all of that and being present. So I would ask that the court not impose a no contact order, but if the court is inclined, at least carve out that exception for the children. And we would also ask for a civil standby here as well.
Mr. Creeling, would you mind come back to the podium real quick? I know that you had mentioned that you don't want a no contact order, but you also mentioned that you probably need some time apart. So I guess I'm going to ask you if you would like a no contact order or if you would like to be able to have contact. And I'm not indicating that I'll do whatever you request, but it seems like I received 2 different requests from you. One, that you didn't want a no contact order, and 2, you need time apart. So are you requesting that there be no contact right now? It could be modified at a future court date if need be, or is your request that you be allowed to have contact? And if you don't know, that's fine also.
I guess for the sake of our children, contact would be nice. So we could monitor and see how the kids are doing.
So are you requesting no contact with an exception for the children?
I don't want anything like that. I feel like we can be adults. We can handle it. Just feeling it. I don't even know how to word it, but I feel like some time apart would be good for in our heads, but I don't see the problem in us contacting.
Okay. All right, thank you, sir. The court at this time is going to grant a $1,250 personal recognizance bond. You are to remain law-abiding. You are to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that acts or charged with committing. At this time, based off the statements of Mr. Creeling, it seems like it's appropriate for there to be a no contact order, with the understanding that that could be modified in the future in the trial division. So you're to vacate the home of the victim, stay away from the home of the victim, and stay away from any other location the victim's likely to be found. You shall refrain from any contact directly or indirectly. You shall not possess, purchase, control, firearm, or other weapon. You shall not possess or purchase any ammunition. You shall relinquish any firearms or ammunition within your immediate possession or control within 24 hours. There will be a distance restriction of 50 yards. The court will authorize a civil standby. Court will also authorize talking parents for parenting purposes only. And what was the request? To allow contact through Mr. Crammond's mother for exchange of children, or?
Yes, I think that she lives maybe down the street from Mr. Creeling and would be able to assist with transporting the kids from one parent to another.
Mr. Crammond, is that true that your mom could facilitate exchanges?
Yeah, she lives 5 minutes away.
Okay, so the court will also allow contact with, and what's her name?
Jill Riley.
Okay, with Jill Kryling regarding matters with the children. Okay, so Ms. Sherry, there'll be a no contact order at this time, but you're allowed contact for parenting purposes through Talking Parents, which is the monitored app. And there's also contact with Ms. Kryling regarding the children, whether it be exchange or other matters regarding the children, but the children only. So contact regarding children is allowed, but anything else is prohibited at this time, okay?
So I cannot see them?
No, you just can't have contact with Mr. Kryling.
Okay.
I'm not restricting your time with your children.
Okay, thank you.
Your next court date will be May 1st, 2025 at 1:30 p.m. in courtroom L2 of the Loveland Courthouse. Anything else from the people?
No.
From the defense?
No, Your Honor.
Thank you.
Judge, just briefly, I do have a 2 o'clock and 3A, so I think we're gonna have to run up there and then come back down.
Of course.
Your Honor, we have
yeah.
Ms. Elwell next on station 1.
Okay, thank you. Yeah, I just want to head back and we'll try to facilitate that. Okay. LL 25M526. Good afternoon. Could you state your name for the record?
Sean Mark Elwell.
And did you watch a video, read a piece of paper advising you of your rights?
Yeah.
Do you have any questions regarding your rights?
No.
Have you had an opportunity to review the charges against you?
But I just thought, I don't know, I thought this was all taken care of.
I don't know what case you might be talking about, but have you had an opportunity to review the charges of secondary criminal trespass as a petty offense?
Kind of.
The court did review the affidavit in support of warrantless arrest and find probable cause. It looks like bond's already been set at $150 personally cognizance bond. I'm inclined to leave it as such unless the people or defense would like to make a supplemental argument.
No, Your Honor.
Anything from the defense?
I'll just note that she has court in courtroom 5D on May 1st, so we're hoping to set this in at the same time.
Okay. The courts will leave it as $150 personally cognizance bond. The court's not going to order any pretrial services. Your order remain law abiding and to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the action charged with committing. You also already have no contact with the named victim in the affidavit. Next court date will be May 1st, 2025 at 1:30 p.m. in courtroom 5D. Do you have any questions, Ms. Elwell?
No.
Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
All right, thank you.
Thanks.
Your Honor, I have Ms. Sanchez on station 2.
Okay. Sanchez, 25M980. Good afternoon. Could you state your name for the record?
Maribel Sanchez.
Okay. Did you watch a video or read a piece of paper advising you of your rights?
Yeah. I don't
Do you
think
have any questions regarding your rights?
No.
Okay. Have you had an opportunity to review the charges against you?
Mm-hmm.
Court did review the affidavit in support of warrantless arrest and did find probable cause of start the people regarding bond and bond conditions.
I'd ask the court to adopt all of the recommendations in the application.
Okay. From the defense?
Yes, we would also be asking for the recommended $125 cash bond here. Ms. Sanchez is pending screening for drug court. She has not missed any of the evaluation dates for that, so.
Okay. The court will set bond the amount of $125 cash only. The court will order enhanced pretrial services. No alcohol, no drugs, no marijuana without prescription. Monitored sobriety is directed by pretrial services. You are to remain law abiding and comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim to action charged with committing. Court will order random UAs. You are to report to pretrial services and probation within 24 hours of your release. Your next court date will be May 1st, 2025 at 1:30 p.m. in courtroom L2 at the Loveland Courthouse. Do you have any questions, Ms. Sanchez?
If I don't post bond for the 125, would I be able to get out on like a PR bond or no?
No, your bond's been set at $100, $125 cash, but you can always address it at your next court date if you would like.
Okay.
Okay, so we'll go ahead and put the people on notice that there may be a potential that Ms. Sanchez will want to address bond on her next court date. Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
Thank you. Thank you. Can we email him that? Just email to him. WC we have next.
Your Honor, I have Ms. Trujillo on station 1.
Trujillo 25M529. Good afternoon. Could you state your name for the record?
Carla Trujillo.
Did you watch a video, read a piece of paper advising you of your rights?
Yes.
Do you have any questions regarding your rights?
No.
Court did review the affidavit and support a warrantless arrest and did find probable cause. We'll start with people regarding bond and bond conditions. It looks like bond was already set at $125 cash. Is there any additional record you would like to make?
No, Your Honor. I would just note 22 failures to appear. I think that does merit a cash bond in this case.
Thank you. From the defense?
Yes, Your Honor. My notes have that it was set at the 1,250 cash surety. Ms. Trujillo is asking for the straight 125 cash, so I'm not sure if that was what it was supposed to be set at. But because the drug misdemeanor 1 is the most serious charge, I do think that is an appropriate request.
I'm showing $125 cash. Do the people have any objection to essentially that be the cash equivalent to the 1,250?
No, Your Honor.
Okay. If it was 1,250 cash as surety, the court will modify it to $125 cash. You order to comply with standard pretrial services. The court will authorize MIPS, no alcohol, no drugs, no marijuana without a valid prescription. Monitored sobriety is directed by pretrial services. Random UAs, remain law abiding. Report to pretrial services within 24 hours of your release. Your next court date will be May 13th, 2025 at 1:30 p.m. in courtroom L1 at the Loveland Courthouse. Do you have any questions?
No.
Okay, anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
All right, thank you.
Your Honor, I have Mr. Hill on station 2.
Okay. Hill 25T697. Good afternoon, sir. Could you state your name for the record?
Willie Hill, sir.
Did you watch a video or read a piece of paper advising you of your rights?
Yeah.
Do you have any questions regarding your rights?
No, sir.
Have you had an opportunity to review the charges against you?
I saw a paper like a while ago, but I haven't seen anything like fully, but it's fine.
Do you want me to review your charges with you?
If you could, please.
You're charged with driving while ability impaired as an unclassified misdemeanor traffic offense, violation of registration provisions as a class 2 misdemeanor traffic offense, position turning method violation as a class 1 traffic offense, drove, suspended, revoked, denied, or canceled as a class 1 traffic offense, and a turn signal violation as a class 1 traffic offense. Court did review the affidavit in support of warrantless arrest and did find probable cause to start the people regarding bond and bond conditions.
I'd ask the court to adopt the recommended PR bond. I would ask for supervision given that it is a DUI. So I'd ask for standard supervision and then a condition for monitored sobriety as well.
From the defense, some in client ground personally cognizant bond if you want to be heard on bond conditions.
Yes, Your Honor, I would just note that the BAC here was a 0.044. We would be asking for no pretrial supervision.
Thank you. The court will grant a personally cognizant bond of $1,000. The court does know, as was mentioned in the affidavit, the lower BAC. So the court will not order any pretrial services at this point. You order to remain law abiding and you order to not drive without a valid driver's license or insurance. Your next court date will be May 13th, 2025 at 1:30 p.m. in courtroom L1 at the Loveland Courthouse. Do you have any questions, sir?
I do actually. On one of the charges, it was talking about something about the license and insurance. I had insurance. The vehicle's registered.
Mr. Hill, the purpose of today's hearing is to set bond and bond conditions.
Oh, okay. Sorry.
Not determine guilt or innocence. So I would suggest that you speak to counsel about that, or if you are representing yourself, that you can discuss that with the district attorney. Okay.
Yes, sir.
Anything else from people?
No, Your Honor.
For the defense?
No, Your Honor.
All right, thank you.
Mr. Lujan on station 1, Your Honor.
Lujan 25 CR 563. Good afternoon, sir. Could you state your name for the record?
Moses Lujan. Good afternoon, Your Honor.
Good afternoon. Did you watch a video or read a piece of paper advising you of your rights?
Yes, Your Honor.
And do you have any questions regarding your rights?
No, Your Honor.
Have you had an opportunity to review the charges against you?
Yes, Your Honor.
Looks like probable cause was already determined on this matter by another judicial officer. So we'll go and start with people regarding bond and bond conditions. If you could also make a VRA record as well.
Yes, Your Honor. No input from the victim at this time. Noting that there is a recent failure to appear in a county court case. There's allegations of gang involvement, as well as possessing a weapon despite a burglary of a habitation out of Texas. Mr. Lujan's history, I'd ask for a $1,000 cash only bond, as well as a no contact order with the victims and witnesses.
Thank you. From the defense.
Yes, Your Honor. Mr. Lujan has lived in Colorado for his entire life. He owns his own construction company and he has 4 children who are all minors that live here as well. Mr. Lujan's last conviction was 2010. He has a lot of family here, including his grandmother. He is really motivated to comply with any bond conditions that the court sets. He's working through a very difficult divorce at this time and is just trying to focus on his kids and being able to see them. We are asking for a co-signed PR bond here. If the court is inclined to set a cash bond, we would ask for a low cash bond around $150.
Thank you. Reviewing the affidavits portal and let's arrest the bond application arguments for the people and defense. Court does note a history of 4 failures to appear, 1 failure to comply. Court has seen many more, but also has seen less. Court also takes into consideration community safety with the allegations of the affidavit. So the court doesn't feel a co-signed personal recognizance bond is appropriate. That in addition to CPAT score 4, overall score of 16. So the court will set bond in the amount of $400 cash only. Court will order that you remain law abiding. You comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim that acts or charged with committing. The court will issue a no contact order with the named victim in the probable cause affidavit. Next court date will be May 2nd, 2025 at 8:30 a.m. in courtroom 5A. Do you have any questions, sir?
No, Your Honor.
Okay. Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
Thank you.
Your Honor, I have Mr. Nee in station 2.
Nee 25 CR 597. Good afternoon, sir. Could you state your name for the record?
Good afternoon as well, Your Honor. It's going to be Robert Nee.
Did you watch a video or read a piece of paper advising you of your rights?
That's affirmative.
Do you have any questions regarding your rights?
No.
It looks like probable cause is already, or do you have an opportunity to review the charges against you?
I'm sorry?
Did you have an opportunity to review the charges against you? Did anyone speak to you about what you're being charged with?
Oh, yes, sorry.
It looks like probable cause has already been determined in this matter, so we're just setting bond and bond conditions. Start with people regarding bond and bond conditions. If you could also make a VRA record as well.
I do not have victim input at this time. As far as bonds go, the affidavit for arrest starts getting very concerning starting on page 3, where there is repeated attempts to contact. There is, despite a trespass from that particular emergency department, there is bringing in a box cutter. There is another allegation on a separate day of bringing a knife into a different emergency department, I believe. All very concerning behavior. Especially noting the effect it's had on the victim, who's been documenting this history that's been ongoing for approximately 3 years or so. Especially seems to be escalating in the last 6 months. Based on all of that and concerns for community safety, I'd ask for a $50,000 cash only bond with GPS conditions as well to stay 100 yards from the victim's residence. I would also ask that as part of the no contact order here, that include any UC Health facility, while acknowledging that may have some difficulties for the defendant. I think in this case, where the victim could be at any UC Health facility in the state, as well as the behavior of bringing a knife and a box cutter into one, noting that there are other medical facilities he could go to, as well as noting that while doctors and the hospitals do have some ethical obligations and would be able to at least do stabilization work, as demonstrated in the affidavit where there was a trespass, but still complying with their own obligations. I don't think that would necessarily be harmful to Mr. Nee, but I think it would be in the interest of community safety to restrict at least 5 yards from any UC Health facility.
Thank you. From the defense.
Yes, Your Honor. Mr. Nee has no prior criminal history. He has lived in Colorado for 17 years. He is not currently working. He does not have a lot of financial means to post a monetary bond. He does live with his mom and his 2 dogs. His mom is out of town at the moment and so would be unable to assist him with bond at this time. When he was arrested at his home yesterday, it was without incident. He was cooperative with law enforcement. He has a very low CPAT risk score. We would object to the request to have the no contact order apply to all UC Health hospitals. It is one of the main health facilities in Colorado, and certainly not knowing more information about Mr. Nee and his insurance and what is in or out of network, it could be very restrictive for him if he's not allowed to go see, half of the doctors in the city. We have no objection to a no contact order with the victim, obviously, and the 100-yard distance we would be fine with. If the court is inclined to order something about UC Health, I would just ask that he be prohibited from going there absent having some sort of medical appointment or medical emergency. But I certainly think he should be allowed access to doctors if needed. And we would just be asking for a PR or low cash bond in this case.
Thank you. After reviewing the affidavit, arguments from people in the defense are reviewing the bond application. This is a tough one for the court because the court does notice CPAT score of 1, overall score of 2. Looks like no criminal history. The court also has to take into consideration the allegation of the affidavit, which seem to be escalating over time, which is concerning for community safety going forward. Court will give an opportunity with personal recognizance bond, but it will be a high personal recognizance bond. It'll be a $15,000 personal recognizance bond. The court will order enhanced pretrial services. The court is going to order a GPS monitor prior to release. You order to remain law abiding. You order to report to pretrial services within 24 hours of your release. You order to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim to action charged with committing. There will be a no contact order with the named victim in the affidavit, and there will be no exceptions. Mr. Nee, that means no contact. No contact means no contact in any form, okay?
Yes, sir.
The court will order no contact with any UC Health facility unless it's for a legitimate medical reason, okay?
Yes, sir.
Your next court date is April 30th, 2025 at 8:30 a.m. in courtroom 5C. Do you have any questions, sir?
No.
Anything else from the people?
Could I just get exactly what the exclusion zones will be for the GPS?
It'll be for her home. I don't. My understanding is she works at different facilities. Okay, so I don't really know if it would be appropriate to do UC Health facilities with the current court order. So it'll definitely be 100 yards from her home and anywhere that she is likely to be located. And what that means is if Mr. Nee has any suspicion that she may be at a current specific facility, it'd probably be in his best interest to go to another facility. But if she happens to be there, there will be that distance restriction. And I would assume that he could, if he's there for a legitimate medical reason, that there could be others that would be able to tend to him that does not include her. So, and Mr. Nee, if that does happen, is he still on? Okay. Well,
He stepped away, Your Honor.
okay, so it'll just be 100 yards with the GPS monitor prior to release, and then no contact with any UC Health facility, understanding that she may be at any of them unless he's there for legitimate medical reason.
Your Honor, Erica Wagner with pretrial. May I ask for the supervision level to be intensive?
I was just going to ask if it had to be intensives. Thank you.
Yes, sir. Thank you.
And then, actually, if we could do a half a mile exclusion zone from her home as well. Thank you. Deputies, who we have next?
Your Honor, I have Mr. Roberts on station 1.
Okay. Roberts, 25M892. Good afternoon, sir. Could you state your name for the record?
Michael Roberts. Michael Roberts.
Oh, thank you. I was just looking for something. Did you have an opportunity to read a piece of paper, watch a video advising you of your rights?
Yeah.
Do you have any questions regarding your rights?
No.
Court did review that, or have you had an opportunity to review the charges against you?
Yeah.
Court did review the affidavit in support of warrantless arrest and did find probable cause. I will start with people regarding bond and bond conditions. It looks like this falls under 16.4113. Do the people believe there's an exception?
No, Your Honor. I don't have an objection to a PR bond, noting that there's also a parole hold here.
Okay. Is there any record the defense would like to make?
No, Your Honor.
Okay. Court's going to grant a $750 personal recognizance bond. Your order to comply with the mandatory restraining order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the action charged with committing. Your order to remain law abiding. Your order to report to pretrial services. Actually, let's see. Did the people mention there's a parole hold?
There is, Your Honor.
Okay, so the court's not going to order pretrial services. You're just ordered to remain law-abiding and to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the action charged with committing. Your next court date will be May 1st, 2025 at 1:30 p.m. in courtroom 4D. Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
All right, thank you. Mr. Holtz, did you get the email with the phone number?
Let me look, it was in court.
Okay. You have this. Mr. Holtz, if you would like to approach, here's the phone number.
Yeah.
If you would like to step out. Yes. Give him a call and come in when you're ready.
Appreciate that.
Deputies, who we have next?
Your Honor, I have Mr. Watson up next in Station 1.
Watson, 25T908. Good afternoon, sir. Could you state your name for the record?
Yes, sir. Gavin Watson.
Did you watch a video or read a piece of paper advising you of your rights?
Yes.
Do you have any questions regarding your rights?
No, sir.
Have you had an opportunity to review the charges against you?
Yes.
The court did review the affidavit in support of warrantless arrest and find probable cause. We'll start with the people regarding bond and bond conditions.
Noting that the defendant is currently on a PR bond for a pending DUI, is continuing to consume alcohol and get behind the wheel of a car. Might ask for a $500 cash only bond in addition to all of the recommendations in the application.
Thank you. From the defense.
Yes, Your Honor, we are asking for a PR bond here with more enhanced pretrial supervision. Mr. Watson is, he owns a home here. He is employed full-time. He does have a wife and 2 kids, ages 6 and 7. He has been compliant with pretrial so far, made all court appearances, and is represented by counsel in his other case. If the court is not inclined to issue a PR bond, we would be asking for a low cash bond in the amount of $200.
Thank you. Reviewing the bond application arguments from the people in the defense and reviewing the affidavit, the court is concerned for community safety going forward. The court does recognize a lower CPAT score, but does also notice, as was mentioned by the people, pending type of a similar type of offense at which Mr. Watson's already under pretrial services for. So the court's going to issue bond in the amount of $250 cash only. The court will order enhanced pretrial services. Your no alcohol, no drugs, no marijuana without a valid prescription. Mark sobriety is directed by pretrial services.
Yep.
Random BAs, UAs, random with ETG authorized. You order to report to pretrial services within 24 hours of your release. You order to remain law-abiding. No driving without a valid driver's license and insurance. Your next court date will be May 7th, 2025 at 1:45 p.m. in courtroom 3D. Do you have any questions, Mr. Watson?
No, sir.
Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
Thank you.
Thank you.
Your Honor, line 14, Mr. Roberts, his pull is refused to show today, but I do have Mr. Folks for you.
Is this, you said, is it Mr. Pulis refused?
Yes, sir.
Okay. And then we have Mr. Folk.
Yes, sir.
Folks, 25M663. Good afternoon, Mr. Folks.
Good afternoon, Your Honor.
So Mr. Folks is in front of the court. I think there may have been some miscommunication between well, I think there's might have been a miscommunication. So I'll just have to make a record on this matter. Mr. Folks was in 1A on Tuesday, April 22nd.
Correct.
There was concerns that he may have been under the influence.
Correct.
Based on a record from the district attorney's office. The court asked Mr. Folks if he was under the influence. He indicated he was not. We conducted a portable breath test through the deputies. Mr. Folks blew over 0.20. The court admonished Mr. Folks, gave him the opportunity to go home as He had a sober ride home. He was instructed to return the next day, Wednesday, April 23rd at 8:15 a.m. And he was ordered to appear sober.
Correct.
And to handle his court matter. Mr. Folks appeared on the subsequent day, Wednesday, April 23rd. The district attorney's office again approached the court and they indicated concerns that Mr. Folks was under the influence. The deputies came in, conducted another breath test. Mr. Folks blew over 0.10. Court at that time found Mr. Folks in contempt of court and sentenced him to 1 day in jail. So
Correct.
the court doesn't feel there's a necessity for a bond hearing at this point unless the people in defense feel otherwise.
No, Your Honor.
No, Your Honor.
So, Mr. Folks, you are ordered to be released at this time, as you have served your 1 day in jail for contempt of court. Your next court date will be May 7th, 2025 at 1:45 p.m. in courtroom 3D. Okay?
Yes, sir. I have a question about bond. Do I contact a bond office or how does that work?
There's no bond, Mr. Folks, because
Oh.
you're serving a day in jail for contempt of court.
Okay, roger that.
So you're originally on a summons and that should continue.
Okay, yes, sir.
Thank you.
Thank you.
And then the court has received information that Mr. Zapulis has refused to appear in court to address bond and bond conditions. I'm inclined to call this matter and just set bond and bond conditions unless the people in defense have a strong objection.
I don't have an objection.
Okay, we're gonna go ahead and call Zapulis 25 CR 609. Court did review the affidavit, or Mr. Zapulis has informed the deputies that he's refusing to appear for court today. The court will find that a waiver of his appearance and will go ahead and set bond and bond conditions. The court did review the affidavit in support of warrantless arrest and did find probable cause. We'll go and start with the people regarding bond and bond conditions.
Noting that we have approximately $45,000 in stolen items, as well as using a stolen vehicle. There's a recent failure to appear, and that Mr. Zapulis was on a $250 cash bond at the time of the event. I'd ask for a $1,000 cash only bond.
Thank you. From the defense.
Yes, Your Honor. Mr. Zapulis would not be able to post any kind of bond other than a PR bond in this case. He doesn't have any financial resources. He has been experiencing homelessness and he is not employed. So he is anticipating remaining in the jail while this case is pending based on that.
Thank you. In reviewing the probable cause affidavit arguments by people in the defense, court does no CPAT score of 4, overall score of 20. It does look like there is a minimal failure to appear and failure to comply history in Colorado, but there is looks like 2 other pending matters. So the court does have concern for community safety. The court will set bond the amount of $5,000 cash or surety. Court will order intensive pretrial services. Court will authorize MIPS, no alcohol, no drugs, no marijuana without a valid prescription. Monitored sobriety is directed by pretrial services. Random UAs with ETG authorized. He's ordered remain law abiding, comply with the mandatory protection order that states he shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim acts he's charged with committing. He's ordered, if I didn't already mention, to report to pretrial services within 24 hours of his release. No contact with Mr. Fromm and Miss Deach. I hope I'm saying that correctly. Distance restriction of 50 yards from their residence as well. His next court date will be May 2nd, 2025 at 8:30 a.m. in courtroom 5A. Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor.
All right, thank you. Do you have any more matters? Or just the ADC, right? Ms. Remy, do we have any more matters on your end?
I don't see any.
Okay. Well, you're welcome to log off if you want. Thank you so much.
Yep, thank you.
Your Honor, I do have Mr. Howland ready for you. It looks like he just got done talking to his attorney.
Okay, thank you. Hey, Howland, 25 CR 621. Good afternoon, sir. Could you state your name for the record?
Sean Holland.
Did you have an opportunity to watch a video or read a piece of paper advising you of your rights?
Yep.
Do you have any questions regarding your rights?
No.
The court did review that. Oh, I'm sorry. I didn't realize Mr. Holtz was in here. My apologies. Mr. Holtz, I called the matter not realizing you weren't in here. I apologize. But I, just so you know, I did call the case. I asked him, he's had an opportunity to review his rights. He indicated he did, and I was just getting ready to ask him if he has had an opportunity to review his charges against him, which I'm assuming he did. Have you had an opportunity to review your charges, sir?
Yeah.
Okay. The court did review the affidavit in support of warrantless arrest. It did find probable cause. We'll start with the people regarding bond and bond conditions.
See, noting again, there's a fairly recent failure to appear from April 15th of this year, as well as having active warrants. I would ask for a $5,000 cash surety bond.
Thank you. From the defense.
But yes, Judge, I believe the recommendation was a $370 cash bond, if I remember that correctly.
That's $370 cash or $3,700 cash or surety.
Mr. Howland is 43 years old. He lives in this area approximately since 2018. He initially started his own business going installing windows. Unfortunately, that business was not successful. He started construction, which is what he generally does. So he is able to be employed and make a living. I came here to Colorado essentially to get away from New Jersey, where I wanted some drug habits and that got clean. We got here about 2 years ago. He says his girlfriend passed away of an overdose, and his life kind of spiraled downhill since. He really wants to get into rehab. That's essentially his priority at this time, and get his life back together. He does have 2 kids, one's 24 and adult. The other, however, is 12 and lives in New Jersey, and he does have contact with that child. He's asking her to consider a $100 cash bond.
Thank you. I'm reviewing the bond application, arguments from the people in the defense, and also reviewing the affidavit in support of warrantless arrest. The court does find this a similar situation as the co-defendants. That court previously set $5,000 cash or surety bond, but the court also does note that there are what appears to be one less pending matter. And one more, please. So it does appear that Mr. Howland does have less of a criminal history than his co-defendant, but has more failures to appear. So in weighing those two together, the court does find that they are in a similar situation, but Mr. Howland does have a lower CPAT score than his co-defendant. So the court's going to set bond in the amount of $400 cash only. The court's going to order intensive pretrial services. You order to remain law-abiding. You order to comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim that actually charged with committing. You order no alcohol, no drugs, no marijuana without a valid prescription. Modern sobriety is directed by pretrial services. In order to report to pretrial services within 24 hours of your release. Or to have no contact with the named victim in the affidavit. A distance restriction of 50 yards. Your next court date. Pretrial services, is there any type of monitoring that needs to be ordered, or is modern sobriety is directed by pretrial services sufficient?
Your Honor, we didn't see anything about drugs or alcohol in the affidavit, so this no drugs, no alcohol, no marijuana can be sufficient if you would like.
Okay, so we'll go ahead and just do no alcohol, no drugs, no marijuana without a valid prescription. I won't order that modern sobriety, that there be modern sobriety is directed by pretrial services. All other conditions remain the same, and there'll be a distance restriction of 50 yards. Next court date will be May 2nd, 2025 at 8:30 a.m. in courtroom 5A. Do you have any questions, Mr. Howland?
No.
Okay, thank you. Anything else from the people?
No.
From the defense?
No, sir, I'd just like to thank the deputies for getting that over the court, for giving me a moment to.
Of course. Thank you and have a good day.
You, sir.
Deputies, that's all we have. Do you have anyone else on your end?
Thank you, Your Honor. I think that's it. Have a good afternoon.
Thank you too.
All right, I think it's now time to jump to another courtroom. Sorry. Oh, sorry. Hang on. The microphone is near me now. I don't know why this always happens. Let me see. I think we're gonna go to the same county we were earlier. I don't know what's going on. Our courtroom is not back. But it seems there's more dockets going around in the same courtroom, so we're just gonna watch that. Let's get to this. Yeah, so the guy on verdict watch that we are on at the moment, he has 19 charges, so they need to go through all of that. So yeah, so this one, I don't know what's happening. I don't know if it is a trial, if it is what it is, but we have the judge on the stand, but it might be hearings because of the people that is on the top. So
And I just granted that
we'll see
order.
what happens.
So I have Christopher Crowell, 25M1093. Mr. Crowell, could you raise your hand? I just want to make sure I've got the right person moved over.
It's me. I'm muted.
Okay. Okay, great. Sounds like you're eligible for pathways. And so what I'm going to do is I'm going to authorize a $1,000 personal recognizance bond, which means that you will be released, but you have to comply with pathways as a condition of your bond.
Okay.
And then let me just see real fast. Has he ever entered a plea of not guilty on this case?
We are still at the arraignment stage. Your Honor.
Perfect. Okay, thank you. And so your next court date will be on
June.
June 20th at 2 p.m. You must appear for that court date unless the case has been dismissed prior to that next court date, okay? So make sure you're here, but if you do what you need to do, it sounds like you get this case dismissed. Do you have any questions for me?
No.
Okay, all right, good luck, sir. Make sure you follow through with pathways, okay? It's a good opportunity to get this dismissed. Okay, we're done.
Sorry.
All right, no, we're good. All
Your
right.
Honor, I just want to let you know, like, when I did get arrested with this,
And
with
Mr.
this
Crowell, I'm
assault.
going to advise you to not make any statements about this case, okay?
He's worried about you're gonna say some, okay, all right. We're
Your
done.
Honor, and just for the record, I think what he's going to say is probably that last court date 2 days ago.
Oh, that he meant.
He was in his way. They kicked him off the bus.
Shoot, okay. Well,
But
that's.
I wasn't sure if that's what he was going to
Okay.
say. So
Sorry. Well, he's not here now, but he got his court date. So I will just put in a minute order on that. It's like Curtis, but. Okay. Yes, oh. Oh, sure. Oh, no, okay.
Henderson.
I think I already issued a warrant on it. Henderson? I don't have a Henderson.
Anderson.
Anderson, oh,
ALZO.
yes, I was okay. We'll have to vacate that warrant. Okay, my next case is Dawson Hartman, and that is 24M7359.
Danielle Wu for the people.
Hi, sir. Good afternoon. So it looks like the prosecution's moving to dismiss your case because you completed a class. So you're entitled to seal your records. I've just put in that order to dismiss the case and seal it. It's automatic sealing, but it's not automated. So we do need to send it to someone else to send out the paperwork. But I'm going to give you your order today that it's been dismissed and sealed. I would suggest you keep a copy of that so that take a picture of it, put it somewhere safe. Because once it's dismissed, then and sealed, then it's a lot harder for you to get a copy of it. You'll be told if you called that it'd be no records exist. So just want to make sure that you have a copy of that. Do you have any questions for me? Okay. All right. Go ahead and take a seat or come on up here actually, and we'll get you on your way. Thank you, sir.
This judge needs to move along a little bit more on because she's giving me that no, sorry. Sorry, I'm having candy and it just went to the wrong pipe. I might have just moved to another court. There's a little bit more alive than this one. This judge, she seems all right. Oh, we have a guy on the phone on this one. That seems interesting. But that means probably problems with the connection. So I don't like that. For sure. There's so many options that I don't even know where to start from. Oh, that looks like Baby Huey's courtroom. Oh no, she was Weld County, so she was not that. See if I can find Baby Huey's judge again. No, I can't find him. I know. This judge is a little bit slow. I think we're gonna move on from her. Shall we go to the Garfield? Are they still alive? Hang on. Garfield courtroom are alive, but they look a little bit dead too. That would be awesome, the Garfield one, especially if he had lasagna. Oh, Sergio, which one? Sergio went offline, which is sad. I don't know why Sergio went offline. He needed to stay online. Oh my god, it's like there's a lot of options, and sometimes that's the bad thing. Can always go back to a trial, but we'll be starting halfway through, and I think they're just going on break. Like, yeah, Stacy just is not alive. This one is all alone in the thing. Looks creepy. This one we see the ceiling. That's not gonna be interesting.
These are done.
This one is reading a document. That's boring. It's like this judge needs. Oh yeah, the
All right,
Halen.
Roberta Gertis, 25T1329. Ms. Gertis, can you hear us okay?
Yes.
Okay, good. Thank you. All right.
Well, Ryan Glower on behalf of Ms. Gertis, who appears before this court via WebEx from the Jefferson County Jail.
Okay, thank you. And we're here on appearance on arrest warrant. How are we proceeding today?
Yes, Your Honor. We're just going to ask him to set this for an arraignment after, I believe it's May 27th. This case is contemplated to be dismissed should Ms. Gertis enter a plea in a case set on May 27th. So just asking for a date after that.
After May 27th? Okay. All right. Based on that record, what we'll do is we'll have her, I'll set it for continued arraignment. And We can set this for, should I just set this on June 10th? Is that a work? Okay. June 10th or 11th. Why don't I set it on the 11th, since this is, will you keep this case?
Someone will.
Okay, okay, June 11th at 8:15. All right, Ms. Curtis, we'll see you back here at that time, and bond remains set. Thank you.
Thank you, Your Honor.
No problem.
Sorry, I think another time. Do we just get another one?
And another break, another pause, a very awkward pause. The discharge. I'm trying to find another one, but the other one that I was looking at seemed interesting. It's on jury instructions. We're not gonna do that again. I ain't doing that. That again. Hang on, sorry. So, we're not gonna do the jury instruction again. That judge is all alone on the screen. It seems a little bit creepy to go and watch him. This one is the ceiling judge. This judge looks all right. We might swap to this one because this judge takes like forever. I'm sorry, but you take forever to do anything. I'm sorry, Judge. Love you, but I'm gonna leave you. Let's go. Where we go? Longmont. I got no clue where that is, but we're going to Longmont apparently. It seems a bit more lively.
Old. It's mostly because Mashulina had, I'm his fourth public defender at this point. So he's had to kind of restart the cycle, you know, getting to know the attorney, going over discovery, looking at offers on the case, looking at the three options. So that's really the delay. Mashulina definitely wants to resolve these cases. I do think he will do well on probation. He's also had a lot of trouble in his life, just losing people and
Sorry, let's go to that Adams Division E and see how is it. Let's go to that one.
Building, as you said, right?
Thanks for that, Gail.
And then an explosion or an incident of violence followed by a honeymoon phase, correct?
Correct.
And then the cycle repeats, right?
Correct.
But not all relationships where people argue or even where there is violence, not all of them fit that pattern. Is that fair?
That's fair. I think we just see that more commonly in intimate partners.
And not every person in an abusive relationship experience all three of those phases.
Correct.
Some never go back to the honeymoon phase, right?
Correct.
Some never experience the tension building phase. It just happens like that, right?
Excuse me. Correct.
So when we're talking about the cycle of violence, we're talking about a generalized framework. We're not talking about a diagnostic tool, correct?
Correct.
And you said that sometimes victims are not able to walk away because they're scared, right?
Yes, there can be multiple factors that would keep them in a relationship that's abusive.
But sometimes people who are in an abusive relationship, they do walk away.
Yes.
And sometimes people who are in an abusive relationship, they fight back.
Yes.
And sometimes when people are in an abusive relationship, they choose to end that relationship.
Correct.
Now, you've never met Fantasia Velasquez, correct?
Correct.
You're not offering any medical opinion about her psychological state.
No.
You're simply testifying that some people in some relationships might follow this pattern.
Correct.
But you can't say that this specific relationship actually followed it.
I don't know the details of their relationship, so no, I can't speak to that.
Okay. And of course, your role as an expert for this jury is not to tell them what happened. They are to decide that, correct?
Correct.
So your role today is not to give us an opinion about what happened in this case.
Correct. My role is to educate on some things we might find in intimate partner violence.
So you're here only to describe general concepts that relate to strangulation victims or in domestic violence cases.
Correct.
So you're not telling us that Fantasia Velasquez was strangled
No.
or was choked, which is different. I just learned.
Yes.
Because without seeing her or her records or her injuries, you simply don't know.
Correct.
And neither can we.
Correct.
Thank you, Judge. I have nothing further.
Redirect.
Yes, Your Honor.
Ms. Ringel, I'd like to bring your attention back to something that defense was just asking you about, and that was trauma response and flight, freeze, fawn, etc. Could you provide the jury education on what is trauma response?
Trauma response is based on the parasympathetic system. That is to say, when someone is faced with a traumatic event, like let's say the presence of a growling bear that you come upon, some common trauma responses might be that you flee, so you remove yourself from that danger. Some might be that you fight back. Maybe you throw rocks at this bear. Some might freeze. They literally don't move as though their body isn't working because they're sort of in a state of shock. And then another common trauma response would be fawning, which is to, let's say, play dead, that sort of thing, where you're just going along with whatever violence you're experiencing so as to not make it worse.
And when a person is in an active trauma situation, how does that affect their ability to track time?
We're not good at tracking.
This is beyond the scope of this expert's expertise.
There was a question asked, there was actually an objection that I sustained, but based upon that question, the door's been opened for this line of direct questions. Overruled.
You may answer the question.
Can you repeat the question?
Yes.
Sorry.
If someone is in an active trauma situation, something's going on, how does that affect their ability to track time?
In my experience with patients I evaluate for strangulation, sometimes they'll say something like, I assumed, or the duration of time that sustained pressure was applied to my neck was a minute. And so I'll stop them and I'll say, well, let's go over how long a minute really is. But let's start with 10 seconds and I'll count 1001, 1002, 1003, again, to kind of just give them a frame of reference. And oftentimes they change that perception of time and they report something different.
And I don't even know if you recall this, but Ms. Fleischman had asked you a question, and you may have just answered it, about 2 to 3 minutes. Someone would be of sustained pressure, someone would be dead. you said in your practice, and Ms. Fleischman said, I'm not asking you about your practice. So I am asking you about your practice. How did you want to answer that question?
Objection, this is anecdotal, it's not scientific.
And this is actually what I was referring to. This was the line of questioning that opened up the door. I believe this is appropriate redirect examination, so I'll allow it.
You may answer.
In my practice with evaluating patients of strangulation who report that they were strangled for 2 or 3 minutes, again, I sort of give them an example, or we go through actual time together to see if they might consider that the amount or the duration of pressure applied might be less than what they originally reported.
And similar to that, how is, when you're in an event, how is your ability to track the type or the amount of pressure?
Well, we
Beyond the scope.
Sustained on that.
I've got a question, y'all. Sorry to interrupt that case, but we're not following 100%. Is this our courtroom? Because it has a different number, but I'm like, is this our courtroom that we've been following? Because it's under a different number though, so I'm not 100% sure if we are in a correct, because I was just like again checking if everything was fine and everything, if the verdict, but I don't know, it looks like our courtroom, isn't it? Hi Denise, welcome back. I'm glad that you're heading home. I'm not sure if this is our courtroom. It looks like it. Like, it's the carbon copy of it. Oh, it is. Okay, good. I'm glad. So we'll stay here for now. I'll still keep an eye out for the other. Oh, is it? Like, it's so similar to the other one. I don't know. Yeah, it's courtroom 520. Yes, Jade. Thank you for that. I appreciate it. This is courtroom 540. So, oh well, I might as well stay here now and see what's going on, because I'm nosy and I need to know what's going on. They do look like they all are different, but this one, it's very similar. And then ours, the one in the morning, even the witness stand, it's in the same place. But where that is, it that a white vase or something? It's a bit different. So they do move attorneys. They move around the courthouse. I can't speak anymore. But oh well, we'll see. We'll stay here for now, just in case. If 520 shows up, I will jump on that one instead. But I'll stay here. Here. But first of all, case one, I hope you stay safe, my friend. But and y- Alexis, he was saying, I do get scared a lot about the weather in the US, because we don't, over here in the UK, we don't experience that. We have bad winds, but it's not that bad that um Anna. I forgot to put that. Thank you. I will keep that in mind. Only you to make me laugh, girl. Appreciate that. You're making Garden Bot laugh too as well. But it's like, yeah, here in the UK we don't experience that bad of weather. I think especially here in the northeast is more winds than anything else. But so when you guys say like tornado watch or hurricane watch or hails that like in Nebraska it happened, I'm like, what is going on? Because I'm like, this is new to me. I'm not used to. I'm trying to figure it out. Right, when is the best time of the year to go to the US to visit, because I want to visit a bunch of you guys. I know we've been talking about that. but I haven't even figured out the time. And the time to go, because it's either too cold, too hot, too hurricane, too hot tornado heat, and I just want like a normal time where there's nothing happening. Oh, you know, and I just refreshed the wrong page. Good. It won't affect the stream, so that's fine. Uh, um, just me being tornado-y. It's the tornado season, so okay, all right. Give a picture. So and then you, if you go to Florida, for example, you have crocodiles all over the place. Like, well, yeah, it is normal for you guys, and I understand, but it's just for scary fans like me, it's very serious. So it's something that I do not want to mess with. Well, I want to see a bit of everything, Iris. I want to visit everybody. Well, almost everybody as much as I possibly can. I want to visit people, of course. And yes, okay, alligators. What is the difference between an alligator and a crocodile? Now I'm remembering of the song. But ooh, people are coming into this courtroom. I think we're gonna stay here for a little bit. So because our courtroom is not back yet. I mean, they have still 2 hours of the day to go. So, oh, hang on.
CR case first. This is People versus Douglas Lindell, 24 CR 1456. I'll take appearances.
Thank you, Your Honor. Good afternoon. Ben Hepler for the people.
Good afternoon, Your Honor. Amber St. Clair on behalf of Mr. Lindell. It looks like he is appearing by WebEx from Crowley. Unfortunately, I need a breakout session with him to talk about the plea paperwork.
I understand. I'll ask court staff to create that breakout session so that you can speak. Let me just make sure. Let's get Mr. Lindell's appearance. Mr. Lindell, I've unmuted you. Will you say your full name, please?
Yes, sir. My name is Douglas Dean Lindell.
Mr. Lindell, good afternoon. This is Judge Lower. Miss St. Clair, your attorney is going to be, the two of you are going to have a breakout session. So there's going to be an invitation on the computer to accept. Are you there with a detentions officer?
Yes, I'll holler at her right now. All right. Okay, she's on her way.
All right. It may be something you're able to do on your own. I'm not sure.
Yeah, I'm not sure either. She'll be right here.
All right.
A breakout session, yes.
So just take your mouse and hit join now.
Okay. Just click it.
Just click it.
Click it here.
Yeah.
I can ask her what, you want me to ask her if that's her number?
All right. On the People versus Lindell matter, we'll be in recess on that matter. Ms. St. Clair and Mr. Lindell are in a WebEx breakout session. Mr. Hepler, I'm going to call a civil matter. Feel free to keep your seat there, and I'll be back on the Lindell case here shortly. The court staff needs to switch, or we'll just keep the connection. All right. Counsel, on the civil matter, one moment as I transition to your case, and you'll have my full attention here shortly. All right, let's call 24 CV 31042, and this is the case in which the plaintiffs are Ace American Insurance Company, New Hampshire Insurance, St. Andrews Construction, XL Insurance, and then we have defendants, Consolidated Electrical Distributors, Eaton Corporation, RMS Cranes, and RMS Riggin. And let's go ahead. We'll go around the horn in that same order. And Mr. Blockwick, I'll take your appearance first.
It's Craig Blockwick, Eisenstein, Crane Buell 7638 for St. Andrews Construction Services Corp.
Thank you. And then do we have Mr. Is it Matter?
Yes, yes. Glenn Matter with Denenberg Tuffley, counsel for plaintiffs, XL Insurance America and New Hampshire Insurance Company. Thank you.
All right. Thank you for that. And then Mr. Lindsay?
Yep, Greg Lindsay on behalf of Consolidated Electrical Distributors, Inc.
And then I believe we have, is it Mr. Holman?
Good afternoon, Your Honor. David Holman for Defendant Eaton Corporation.
Mr. Holman is appearing also by WebEx, but by phone line. That's fine, Mr. Holman. And then Ms. Bell?
Good afternoon, Your Honor. Shannon Bell appearing on behalf of RMS Rigging and RMS Cranes.
And then Mr. Vandeford, I did not call on you, and help me know where you are situated with these parties.
Yes, Your Honor. I am representing insurance company Ace American, plaintiff in the consolidated matter.
All right. Your appearance is recognized as well. Thank you, counsel. This is a case management conference, and it is our, I will say, second effort to do so. Mr. Matter, I believe, if my recollection is correct, that you were not present when we convened previously on April 4, 2025. And since then, there has been a consolidation of another First Judicial District case 25 CV 30442 into this matter. Is that correct, Mr. Matter?
That's correct. Thank you, Your Honor.
All right. So, Mr. Matter, the attorneys were true to their occupation. They were convincing to say that we should hold up the show and let you join us before we go too far and start setting trial dates. I have received then the second proposed case management order, and it's substantially similar. It provides some information from the Mr. Matter's perspective on behalf of New Hampshire and XL Insurance. And I am convinced that we are squarely not within the simplified procedure, and that Rule 16 applies, and that the presumptive limits of discovery are at issue. Mr. Blockwick and Mr. Vandeford, while I'm convinced that those presumptive limits are appropriate, I still require for proportionality, but also for my understanding and to start this conversation with defendants, what is the monetary relief that is being sought at this point? And my asking you is not intended to create limitations down the road.
Right. Just to summarize, our initial claim is $250,000. One of the complicating factors in this case that is mentioned in the second proposed case management order is that my client is the subject to a demand for liquidated damages from contracting parties who are not parties to this case. It's upstream contractors, and those claims have not been formally determined at this point, and they represent a significant uncertainty moving forward. Mr. Matar and others can speak in, but then there's a subrogation claim, which is identified in the summary that's approximately $3 million as to RMS and Eaton. I think those are the principal damage claims at this point.
All right. Mr. Blockwick, that helps me. Mr. Matar, is there anything else that you wish to add as counsel for additional plaintiffs in this matter?
No, yeah, that's accurate. My clients and Mr. Vandeford's clients are kind of collectively the subrogation plaintiffs on this. And yes, their damages, that's a fixed sum that they paid, and it's about 3.2 million.
All right, I understand. Is there, while I have nothing in mind, I want to give equal opportunity, any counsel for defendants in this matter to weigh in on this topic? Hearing nothing, I'll move forward. And counsel, as far as experts, we've got the conventional presumptive deadlines, 128 days before trial for plaintiff's expert disclosure. defendant's experts 98 days and rebuttal 77 days. One of the things that I want to address is states that mediation will be had 90 days before trial. I'm fine with that. I just want to let you know when I make any changes to the case management order so that you have a heads up. We'll include the language that is included in the court's civil procedure order, paragraph 8, so that mediation should be set within 35 days of submission of the proposed case management order. Prior to today, it wasn't practical for you to start doing that because you don't have trial dates. Here shortly, we'll get trial dates, and so that you can get that on your calendar and know when discovery will be concluded, when you will have opportunity to fully digest the discovery and then be in a position to have mediation. Also, what I'll add is in the court's civil procedure order is oral discovery motions, or rather a discovery dispute policy. I don't want you to have to wait a month because there's a discovery dispute. And so the policy is that parties are to all confer, and then each party has up to 2 pages double spaced to state what the discovery issue is in your position, so that I can have that, read that ahead of time, and then we'll reconvene by way of WebEx, in person if necessary, but I'm happy with WebEx like we're convening today. It's going to be hard to get all of our calendars always working together, so I'm happy to set any discovery dispute issues before 8, after 5, or even over the noon hour, just to get this moving. I think that this is the most efficient way to address this. So we're not waiting 21 days for responses, another 7 for reply, and then additional time for me to get to it. So we'll include that language also in the case management order. Counsel, other than getting dates for trial, I think that everything else that is contained in there, I'm not seeing anything that you all are in disagreement on that you'd need my further attention on. I'll just go, Mr. Blockwick, is that correct from your perspective?
That's correct, Your Honor.
Mr. Matar?
Yes, Your Honor. Thank you.
And I'll look to defense counsel. Mr. Lindsay?
Nothing, Your Honor.
Mr. Holman?
Nothing. Thank you, Your Honor.
And Ms. Bell, anything further other than trial dates?
Nothing further, Your Honor.
All right, thank you, Ms. Bell. And let me confirm, as when we convened earlier this month, there was belief that 5 to 7 days would be necessary. What I am presuming, which is dangerous for me to do, but I think that then the longer side of that, with the addition of additional plaintiffs, might be necessary. Is 7 days sufficient for trial? And I'll just ask for any objections or anyone who disagrees, thinking that we.
Your Honor, Craig Blockwick, we had in the proposed case management order suggested 10 days based on the new issues involved. We did have a case management conference among counsel earlier this week, and that's where we all came out.
Mr. Blockwick, I see that right there, smack dab in paragraph 17 on page 9. And I'll tell you that the court staff already has proposed 10-day trial dates for me to propose to you. So you're just ahead of me. I appreciate that correction. Anyone disagree with that? Hearing nothing, I'll invite you to look at your calendars. And we have February 18th through March 4. February 18, that's a Wednesday. And then March 2nd is a Monday. I have a criminal docket that I'm not going to vacate, so that Monday, the 2nd, we would not have court, so that we would conclude the 9th and 10th day on March 3rd and 4th. So February 18 through March 4, skipping March 2nd. I'll let you look at your calendars. And I think it'd be easiest just to go around the horn again with starting with Mr. Blockwick.
Those dates are available for me.
Mr. Lindsay or Mr. Matar?
Yes, I think that that's enough time personally, and I am available those dates. I'm talking about between now and trial, but that was something else we discussed in the call, but I'll let others talk if they disagree.
Okay.
Yes, Your Honor, I'll address that. I think collectively, counsel did not feel strongly about trying to keep things within the 1-year period or going out to close to the end of the 1-year period because of number one, the extensive issues in the case, and also because of some of the uncertainties of some of the issues. So I'll just mention that. I think that's Mr. Matar's reference.
Yes, but those dates are fine with me, Your Honor. Thank you.
I understand. Then I'll keep those cases or those dates proposed. And Mr. Lindsay?
Your Honor, I have a conflict starting on March 2nd, a 10-day arbitration where I represent a general contractor that would impact the first couple days of that, or the last couple days of this trial.
All right. Mr. Lindsay, I'm not ignoring what you said. I want to hear from others if that works, because I think if I propose other dates, we may have similar conflicts from other counsel as well. Mr. Holman, does that still work for you, February 18 through March 4?
Yes, Judge, it works for me. Thank you.
And then Ms. Bell.
Those days actually do work for me, Your Honor.
Okay, Mr. Lindsay, what I'm going to do is propose other dates, and we may have to circle back to those dates that I just proposed. Mr. Lindsay, you said you're in arbitration starting on March 2nd until when?
13th.
Well, I'm going to propose this one more, March 23rd through April 6th.
Your Honor, those dates are available for me. Craig Blockwick.
Thank you, Mr. Blockwick. I'll just let you go in that same order. Mr. Matter?
They do work for me as well. And I do just want to check with Mr. Vanderford too, because he's also counsel for the subrogation blues. Okay, yeah, so it works for both of us. Thank you.
Mr. Vanderford, thank you. All right, sounds good. Mr. Lindsay?
Those dates again were March 23rd through April
6th, and that would skip the Monday of March 30th. March 23 through April 6th.
I have a conflict, another trial that starts on the 30th. I'm a minor subcontractor. If I were to set a trial over one of the two cases, this would probably be the one I would set over the top of. So I do have a conflict, but I would work around it.
I understand. Thank you, Mr. Lindsay. Mr. Holman?
It works for Eaton, Your Honor. Thank you.
Ms. Bell?
Works for RMS, Your Honor.
Let's go with that then. Mr. Lindsay, thanks for that accommodation. March 23rd through April 6th. The one date that we will skip is the March 30th date, which I'll have a criminal docket. Counsel, I'll include that in the minute order and the case management order. No further notice of hearing or the trial is required. And that'll be I'll just confirm with counsel, that is intended to be a jury trial, correct?
Correct.
That is correct. All right. Counsel, I'll let you know, I'll issue today also a jury trial procedure order. Not that you have to do anything with it now other than review it. Those are things I usually address later on at a pretrial conference. It helps you understand some things that I want to address or will be addressing. And then I will have a pretrial conference. I'm not going to set that now. I don't know if we are going to be addressing lengthy motions in limine, and we're going to need a couple hours, or if we just need 15 minutes, just to let you know how voir dire is going to look or how you are all situated in the courtroom. So we'll not set that now. I usually have that set about a month and a half prior to trial. So just heads up on that. Other than that, counsel, I'll just open it up. Is there anyone who has additional issues, any clarification, or need me to restate anything?
Not from St. Andrews, Your Honor.
All right. Hearing nothing else, I'd presume that no one has any further questions or other issues. Mr. Matar, I'm going to pronounce your name one way rather than two. Pronounce your last name again, please.
It's actually Matter, but
Mr. Matter, I'll do that then. Mr. Matter, welcome to these proceedings, and counsel, good to see you all again. With that, parties are excused.
thank you, Your Honor.
Thank you. Your
Thank
Honor.
you, Your Honor.
We continue to be on the record. The court recalls 24 CR 1456. This is People versus Lindell. Mr. Lindell, I'm going to unmute you. Mr. Lindell, are you still able to hear me?
Yes, I can, Your Honor.
All right. I'll note for the record that Mr. Hepler and Ms. St. Clair are both present in person in the courtroom. Mr. Lindell appears again through WebEx from Department of Corrections. What's our status, counsel?
So, Your Honor, we do have a proposed disposition. It does include a proposed stipulation as well. I realized I neglected to inform the court of that. But the proposed disposition would be to a DF1 stipulating to 24 years concurrent to another case he has in Adams. I don't know if the court has any questions, but I just point out that in 23 CR 1145, that was his co-defendant, and that was ultimately the sentence he received.
And Your Honor, the Adams County case is 23 CR 3631, for which he's doing a 32-year sentence that he just got sentenced on about 2 months ago, and that's why he's in Crowley.
All right. And then, Mr. Hepler, the co-defendant, was that a stipulated sentence as well?
Your Honor, in that case, we had a stipulated range, and that was what the court sentenced him to.
And that's what I sentenced him to?
Correct.
Okay. Mr. Hepler, I promise you, I'm not going to tell you I believe or know things I don't. I don't remember that specifically. And it's your representation that the parties are postured similarly in terms of criminal history and your belief of the involvement in this matter?
Yes, Your Honor. The one difference I would say, and if it helps, that other individual was named Bo Warner. In that case, I'd say Mr. Warner probably had significant more drug-related offenses, whereas here Mr. Lindell has, I guess, more felony charges, but less drug-related charges. But I do think it evens out.
Okay, thank you.
Warner is the one that drove out of state and brought it in state and allegedly met Mr. Lindell in Blackhawk and gave him some of the product.
You have both sufficiently and quickly refreshed my recollection. Thank you. Let me just take one moment. I'm looking at the pretrial services criminal history report. I've had a chance to read this previously. I was not certain how we were proceeding. Let me review this again, just in my contemplation, whether or not to accept this proposed stipulation. I've had a chance to review that. Also, in anticipation of today's pretrial conference, I've had a chance to re-review the affidavit for arrest warrant in Mr. Lindell's case. Mr. Lindell, I'll speak to the attorney still right now. I just want you to listen in as I'll ask if this is your understanding of the proposed agreement as well. Okay, sir?
Okay.
Mr. Lindell, is there a way, if we're going to use that video, can you modify that so I'm able to see your full head rather than just your eyes up?
Okay, yeah, let me just put this other chair here. I think this might help me if I stack these chairs. There, that's gonna help. Is that any better?
That's good, Mr. Lindell. I
Okay.
appreciate that. Thank you,
Yeah.
sir. Ms. St. Clair, Mr. Hepler, I see the proposed agreement is to plead to count one. If Mr. Lindell wishes to do that, that's distribution of a controlled substance which is a drug felony 1. The normal range for that is 8 to 32 years. I understand that there's a proposed stipulation of 24 years Department of Corrections concurrent with Adams County 23 CR 3631. With that stipulation, the way I read that is that it is an attempt with the agreement of counsel for the court to agree and then obligate the court to proceed with that sentence. What I would say, and I'll talk to Mr. Lindell about this, is that if I would learn about anything that would cause the court to believe that this proposed agreement and sentence is not appropriate, then Mr. Lindell would have the full opportunity to withdraw his plea of guilty and restore his right to trial. That, of course, could only be had up until the court is contemplating sentencing, so at the point of judgment of conviction entering. Let me ask, I do have one other question, or one question. Is Mr. Lindell enhanced or aggravated? Is the 8 to 32 what the court would be considering if he pled to this without a stipulation?
Your Honor, I thought I had that, and I can't remember if the Coca case was after. I believe it was.
Yes.
Yes, the Coca case was after. I think.
Yes. He's enhanced, Your Honor.
So on the DF1, I'll look that up. What is that range on the DF1 then?
I think the top end is still 32, but I think it bumps it up to like 10 to 32 range.
Well, Your Honor, on my sheet, I don't see actually enhanced affecting drug felony sentences. I see that there's a discretionary aggravation that keeps the range the same versus a mandatory aggravation that would make it 12 to 32.
I don't see one either.
Yeah, I don't think actually drug felonies do have an enhanced sentencing range.
Maybe I'm thinking of old law.
But I guess what I would just say is regardless, I know this would not be mandatory aggravation. And if the court for some reason did find discretionary aggravation, there's no difference in the sentencing.
Okay. These are the things I want to make sure that we're all on the same page on. Ms. St. Clair, do you agree with that representation?
Yes, Your Honor.
I do as well. One thing that isn't completed on the petition is how high Mr. Lindell has gone in school. Ms. St. Clair, do you have that information?
I will inquire. I was in the hall, so my apologies. Mr. Lindell, how far did you go in school?
I acquired my GED.
Okay. And any problems reading or understanding the English language?
No,
Okay. And you don't have any military career, do you?
no, I don't.
Counsel, I'm in a position where I'd accept this proposed agreement if Mr. Lindell wishes to enter into that. Counsel, anything else before I speak with Mr. Lindell directly?
I don't think I have anything to add. Your
No,
Honor.
yeah, thank you.
Mr. Lindell, I'll speak with you directly. Say your full name, please, sir.
My name is Douglas Dean Lindell.
Mr. Lindell, I see presently there are 6 counts against you. The lead count is a drug felony 1. It's possession or distribution of controlled substance, and that's the drug felony 1 that it's proposed that you would plead guilty to. Are you the Douglas Dean Lindell that's charged with that count 1?
Yes, I am, sir.
And do you read and understand the English language?
Yes, I do.
Mr. Lindell, we're having an easy conversation in English right now orally, but this plea paperwork that I have in front of me, I have a hard copy of it. It's a petition to enter a plea of guilty. On page 6, there's today's date, April 24, 2025, with a signature. And it looks to be likely Miss St. Clair's signature stating on behalf of and with permission of Douglas Lindell. Did you authorize Miss St. Clair to sign on your behalf on this petition to enter a plea of guilty?
Yes, I did, Your Honor.
St. Clair, is that your signature on behalf of Mr. Lindell?
Yes, Your Honor, and I actually showed him what I wrote on the screen when I was in the breakout session with him.
All right. And Mr. Lindell, having authorized Ms. St. Clair to sign for you in that fashion and having her present this paperwork to me, are you telling me that you understand everything contained in the petition to enter a plea of guilty?
Yes, I do, Your Honor.
Mr. Lindell, I know that you're in Department of Corrections, but this question still pertains. Are you under the influence of any alcohol, drugs, or even any prescribed medication?
No, I'm not.
Are you thinking clearly right now?
Yes, I am.
Are you in a sufficient place mentally to make an important decision for yourself?
Yes, I am.
Mr. Lindell, I can only consider accepting this proposed agreement if I'm convinced you're entering into it voluntarily. Is anyone forcing you, threatening you, or coercing you into entering into this plea agreement?
No.
If you enter into this agreement, is it of your own voluntary decision?
Yes, it is.
Have you had enough time to talk to your attorney, Ms. St. Clair, about this petition to enter a plea of guilty?
Yes, I have.
Do you need any more time?
No, sir.
Have you also had enough time to talk to her about how to proceed in your case otherwise?
Yes,
You
I have.
previously entered a plea of not guilty. That was back in 2024. You have the opportunity to maintain that not guilty plea on all 6 original counts and proceed to trial. Have you had enough time to talk to her about proceeding in that fashion as well?
Yes, I have, Your Honor.
All right. Are you satisfied with your attorney, Ms. St. Clair's representation of you?
Yes, I am.
And this is not a VRA matter, correct, counsel?
That's correct.
All right. Mr. Lindell, Ms. St. Clair in front of me asked you how far you went in school. Is it accurate to say that you earned your GED?
Yes, it is.
Okay. And you don't have any military service?
No, sir, I don't.
Ms. St. Clair, I'm obligated to ask, to the extent there are any immigration consequences, have you fully advised Mr. Lindell?
Yes, Your Honor, and there are none.
All right. Mr. Lindell, I'm going to look to Mr. Hepler, the Deputy District Attorney, who's going to give a factual basis. I want you to listen to that. If for any reason you're unable to hear, get my attention and we'll accommodate to make sure that you can hear. When he's done, I'm going to look to you and ask you if this is what happened. Do you understand?
Yes, I do.
Mr. Hepler.
Thank you, Your Honor. So, Your Honor, this case derived from a larger operation by the West Metro Drug Task Force. And on May 9th of 2023, the defendant was observed by law enforcement placing items in his Jeep from the co-defendant in the Monarch Casino. Later that day, law enforcement did search that co-defendant's house in Jeffco, which is how we have jurisdiction here. But ultimately, a search warrant of the Jeep found 21 pounds of meth, 49.64 grams of fentanyl, 51.9 grams of cocaine, 1 gram of DMT, 1.82 grams of Xanax, and 3.17 grams of alprazolam was found throughout the Jeep.
All right. Mr. Lindell, were you able to hear and understand that?
Yes, I was.
And is that what happened, sir?
Yes, it is.
Mr. Lindell, do you have any questions for me or your attorney before I ask you then, how do you plead to count 1?
No, I don't have any questions, Your Honor.
All right. Mr. Lindell, I'll state before I ask you how you plea, as I have addressed with the attorneys, there's a stipulated sentence of 24 years to run concurrent together with the Adams County case that I understand you're serving. If for any reason between your plea of guilty and sentencing, I'd learn of something that I believe that sentence is no longer appropriate, I would then give you permission to withdraw your plea, restore your right to trial. Do you understand that?
Yes, I do, Your Honor.
All right. Mr. Lindell, then as to count one, distribution of controlled substance, a drug felony 1, how do you plead, guilty or not guilty?
I plead guilty, Your Honor.
The court has fully advised Mr. Lindell, consistent with Rule 11, both in today's hearing and he's been advised more thoroughly, in the petition to enter a plea of guilty. He's made a knowing, intelligent, voluntary plea. He's represented by competent counsel. Mr. Lindell is satisfied with Ms. St. Clair's representation of him. The conviction enters, and counsel for sentencing, do we wish to proceed to immediate sentencing?
Please.
Uh,
All right, we'll do that. And Mr. Hepler, I'll hear argument.
Thank you, Your Honor. Your Honor, frankly, I don't have much to add here. While Mr. Lindell was found in possession of the drugs I just mentioned, you know, the co-defendant had over 130 pounds of meth in his house. I walked through that the court did sentence the co-defendant, Mr. Warner, to the same sentence we're asking for here. I know the court's just reviewed his pretrial report with his criminal history. The only change I have is what Ms. St. Clair alluded to earlier in the fact that he did plead guilty to a DF1 and COCA charges in 23 CR 3631. And in that case, he got sentenced to a total of 32 years in the Department of Corrections. I think that this amount of fentanyl and this amount of cocaine and methamphetamine is incredibly dangerous to our community. But I do acknowledge that Mr. Lindell is taking responsibility to obviously the top count in this case and a very serious sentence that he's facing. And if it wasn't for that, Your Honor, people probably would be asking for the max. But for that, I guess, accountability that he is taking here, the people do believe this to be an appropriate sentence.
Mr. Hepler, thank you. Ms. St. Clair.
I concur with the district attorney, Your Honor. They stopped him at the casino, the Monarch Casino in Blackhawk. I've watched the body worn camera. I mean, he was actually really cooperative with law enforcement, didn't give him any trouble. In fact, after they searched his pockets, took possession of the keys of the car and took the car, they let him and his girlfriend go and continued on. And I think it speaks volumes. I think you're aware from sentencing the co-defendant, the amount of involvement he had as well. I think that 24 years is a long time when you're a 58-year-old man, especially running a concurrent to the 32-year sentence that he's looking at in Adams County. So I would hope that you would just indulge him. We've been trying to get this done a long time. I'm the problem before he went to DOC because I wanted to make sure that the stop was right. And I wasn't pleading him to something that had an unjustified stop in a violation of his constitutional rights. So I take full responsibility for dragging this out. And in the meantime, they sent him to Crowley to do his Adams County sentence. And I apologize for the delay I gave to the court. It was one of those situations where my life got in the way and it took me a long time to get through everything. I'm hoping you won't hold that against him. But in the end, we came to the resolution since Mr. Warner got a 24-year sentence for the extraordinary amount of drugs and bring it into the state, that the same sentence was appropriate, taking into account the 32 years. Kind of involved in the same investigation that he got in Adams County. I can tell the court that he had, since a warrant was served on him and attached to him on the 9th of July, he has 290 days credit I'm asking for.
200, how many?
90. And I'm certainly asking that it run concurrent to 23 CR 3631. Adams County.
Thank you, Ms. St. Clair. Mr. Lindell, this is your opportunity to make a statement. What would you like to say and share with me to consider before imposing sentence?
Well, Your Honor, I just think back to my misdeeds, and I live every day with my regrets. I can honestly say that I've never considered doing anything like that ever again. I just want to get this sentence done. I want to get into therapeutic community while I'm here, doing as many programs as I can. I just completed this apology letter group. I get my certificate in a week. So I'm just staying focused on trying to stay positive and get through this.
Mr. Lindell, thank you for that. I will disclose that I'm sentencing Mr. Lindell consistent with the stipulation, 24 years to be concurrent with Adams County 23 CR 3631, 290 days pre-sentence confinement time. Mr. Hepler, was there any restitution or any fees or costs?
No, Your Honor.
All right. The court imposes that sentence. The 290 days is concurrent with the Adams County case as well. We'll include that in the minute order. Mr. Lindell, I look to 18.1.102.5. I've decided from the Colorado revised statutes, and that's the statute that is entitled Purpose of Code with Respect to Sentencing. I refer to this a lot. I think it's necessary. The legislature tells me that these are the things I'm to consider. And right off the bat, the first thing listed is to punish a convicted offender by assuring the imposition of a sentence he deserves in relationship to the seriousness of his offenses. It talks about fair and consistent treatment. It talks about thereafter prevention of crime. A big one comes next that I often look to that talks about promoting rehabilitation, that the sentence does that. Mr. Lindell, I think what you are doing thus far in Department of Corrections is within your control to work towards rehabilitation. I have to say that the primary purpose of this court's sentence is to punish you. I often talk about contribution to one's community. And I look at that in some way a type of restitution, or what one is able to do to pay back. And your opportunity may be limited while you're in the Department of Corrections. There's an expectation that after your sentence on parole that you begin that. And it's expected that you have a law-abiding lifestyle. It is your obligation to work on your substance use disorder. It is your obligation not to just sit back and wait for people to come to you and help you. You need to take ownership so that when you get out, you can take this seriously. You can take life seriously. I also will talk about your contribution to the community prior to you being incarcerated. Your contribution to the community has been such that you have contributed to people fostering their own substance use disorder. While I can't give you all responsibility and fault for that, you have enabled it. You have made it available. You have profited financially on people's addictions, their substance use disorder. When I look at the amount of drugs found in the red Jeep Cherokee, I'll restate it because it's impressive in a bad way. 21 net pounds of methamphetamine, fentanyl 49.64 net grams, cocaine 51.9 net grams, DMT estimated 1 gram, Xanax 1.82 net grams, and alprazolam 3.17 grams. I read those as I am relieved that that did not go out into our community. Mr. Lindell, it is appropriate to punish you to 24 years in the Department of Corrections. I do wish you luck, sir, and I wish you much success as a law-abiding citizen when you've completed your custody and as you begin engaging in parole. Mr. Lindell, good luck to you, sir, and parties are excused.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, so let's find another one to watch while we're still on verdict watch. Where shall we go? Oh, I forgot I have to do this. Let's refresh this. See if our courtroom is back, which they are not. Man, I did find the courtroom of Stacy. Let me see if I can find it again. I think they are not on anymore. Oh man. Hang on, let me go to I think I found it, but it's a little bit tilt, so yeah, that's gonna annoy me. Let's try to find something else. That's making faces. What is she doing? She seems she's doing something. Let's watch her. Is it this one? Yes. Let's watch this one.
Dismiss this, well, in terms of moving to dismiss, so if she says to you, she's gonna move to dismiss the case, she's gonna do it. But it needs to come to me and I need to approve it. And I might get hit by a bus. So unless you know that this hearing has been vacated and you get a notice that it's been dismissed, you got to come to court that day. You understand? Okay. All right. Perfect. You want a written reminder?
Yes, that would be nice. Thank you. I'll be in contact.
Okay. Anyone else you're ready to call?
Yes, and could we approach just briefly?
Yeah. Do we need a bench trial or a bench conference?
I was just gonna say, man, I have a very good thing on picking streams today because every single one that I'm picking, they are not as speedy as we want to. It's just like you're done with the case, call the next one. Like, do not. I understand it's starting to be like the end of the day, going towards the end of the day. I think they are like wrapping up some of their cases, some of the courts, so not like all the courts are on or doing anything. So I'm just trying to look for something to see if it shows up. Oh, we have a judge on the bench on a phone, which that sounds interesting. This sounds like a trial. Do know. Oh, that one is. Let me refresh just in case so we can see if our case has come up. New. Like the one thing that the one case we wanted to come up is not coming up. Wait, let me see this one because this was it. This one. Yeah, this one seems like they're doing stuff. So let's go to that one. Let's because I think the judge now forgot to put the thingy back on. Larimer 3A. No, let's go on this one.
Reports that she has been essentially kidnapped and sexually assaulted. Do you know what the relationship was between the victim and the defendant? mean, is this random act of violence on a complete stranger, or is this someone that they had a relationship? I'm just trying to kind of wrap my head around.
So it is suggested that he had some awareness of her because he was able to provide the name Sherry or Mary Ann.
Okay.
But that doesn't imply they're close associates.
So we don't know.
I don't think he was a random stranger. I believe that he made my client feel very unsafe, but
The hard part is it sounds like she went to his home.
right, invited with some other people, as far as is what I understood. There was not just the two of them that were there. There were other people. I don't want to talk about the facts of the case.
Okay.
Yeah.
And thank you for helping me kind of understand. So she didn't just randomly show up at this person's house and then attack him.
No, I don't think anybody believes that.
No, but she was in the house with another group. They were eating dinner and then.
Okay. And I'm sorry, as far as the hospital, I don't have a lot of information, Mr. Oxmacher. Did the victim, I know it's dangerous, no doubt about it, when somebody is essentially stabbed in the neck. Is he still receiving treatment? Is he having anything permanently medical? I don't know how superficial or deep this was. I know there was 3 drops of blood on the ground, so there was that. Can you help me know if this person, how badly he was wounded?
Yes, Your Honor. So I did go to the hospital. The attending physician there did sign off on serious bodily injury. This was approximately an inch stab wound that punctures his neck and the cartilage around his thyroid. I believe that he was very fortunate that it wasn't worse, but there have not been any requests for restitution. So in terms of ongoing medical, if that occurred, it's not been submitted to us.
I appreciate that. And then, am I right that this F3 is not subject to mandatory prison if she's found guilty?
It would be subject to mandatory prison, 10 to 32 years.
I don't believe and I could be wrong, but I don't believe the named victim has filed a victim impact statement in the case either. And I think it's notable that he didn't have any position or response to the issue about the bond as well. And again, I know this is not binding on the court, but accepted to wellness court. I believe the offer was for halfway house.
I'm going to pass your case, Ms. Autry, for a moment. If you please have a seat, I just need to think clearly for a moment, please. In the meantime, Adam Draper, 23 CR 663. Mr. Draper's not there, but somebody's there.
Your Honor, my name is Dennis Padilla. I'm the program support manager for E1. Adam was having a little bit of issues. He did request that we go get him once his case was called. So if you allow me, I'll go get him and bring him in.
Is he nearby?
Yes, he is.
Okay.
He's just down the hallway.
So I'm just going to wait for a few seconds, it sounds like.
Yeah.
All right, I will wait for you. Thank you.
All right, thank you.
So the decision is not back. We're still waiting now for this defendant to come from somewhere, and yeah, like
in a moment.
Do not tempt me, guys.
Mr. Landers, is your client here who needs an interpreter? Is Mr. Landers here?
Yes.
Okay, I'll call her next after this case, please.
Hello, Your Honor.
Yes.
Adam has refused. He will not come down the hallway with me. I apologize.
No need. That's not within your control. Thank you for coming back and letting us know. I'll just make a record. Ms. Lowry is present as counsel for Mr. Draper. This is 23 CR 663. That the record as to why he's not here has been made. Mr. Oxmacher, do you know if the civil certification through the state hospital is being pursued?
So that's my understanding. I'm not sure if the case manager or individual from CHMIP can give us the latest on the ground update.
Your Honor, I believe the psychiatrist was going to be talking with him today.
And so we don't know if it's being pursued.
Not offhand. I oversee 3 different units, and I'm in and out of Adam's unit throughout the day.
And Isaac indicated that he was advised that they will be pursuing it. I don't think they have it yet, is my understanding, but that they will, they are.
I got this email from Janice Lewis. It says, per Dr. Galley, I don't know how you say that, Anna, maybe you can correct me. He does meet criteria for certification. Once the charges are dropped and our legal department, Jennifer Lott receives the information, they will proceed with the M1 and short-term certification. And I got that about 20 minutes ago.
All right, so that was from 20 minutes ago. And so I think that the dismissal has to happen before they pursue it. Is that your understanding?
So, and I believe our actual timeout date is the 26th. Here's my request.
Sure.
That the court issued the dismissal on the 26th, but stay it for the 35 days, and that we come back next week just to confirm that it has in fact been effectuated.
The only problem I have with this idea is the 26th is Saturday, isn't it?
Have a seat.
Okay, hi Adam, thanks for joining us now. We're just talking about what's going to be happening with your case, okay? Your lawyer is here, Ms. Lowry. Mr. Oxmacher is here on behalf of the people. There is an ability for me to dismiss the case, but it's going to place a 35-day waiting period before it completely closes. And that's kind of what the DA so far is asking me, but I'm still trying to learn the details. So hang tight. Mr. Oxmacher?
Yeah, sure. I mean, that's exactly what the statute contemplates, is that the stay is to ensure that he's not released, but does allow them to do what they need to do.
Would you object to us issuing the order tomorrow and then starting the 35-day stay?
Yeah, that's fine.
That makes sense.
All right. So the court is going to issue a dismissal, Adam, of your case effective April 25th. It still plays a 35-day period of hold for examination as to whether short-term certification is appropriate. And I think instead of triggering the county attorney, it sounds like we're just going to be leaning on the state hospital. So I won't trigger anything to their office. Is that what you're contemplating?
Yeah, and that's correct. So the short-term cert needs to be pursued where he's physically located. And so that's why this needs to occur in Pueblo.
Okay. And so give me one moment. And so Adam, even though your case is going to get dismissed, And even though in 35 days, everything will be closed with this court, your journey is not done. Your wellness is extremely important. You and I have known each other for a long time, and you have to engage in figuring out how to navigate your wellness, because that's what essentially the short-term certification is going to be looking at. And so I know you're in a difficult situation, and I can't choose what you will decide to do, but I can still hope, because I've seen you when you're doing really well, that maybe it'll get back to that place again. And so that you will hopefully be able to be back in touch with your aunt and all of the other things that were good that you had going on when I knew you in wellness court. 35 days from April 25th brings me to Friday, the May 30th. I guess what I could do, if there's no objections, just call it on the May 29th docket to officially decide what we're doing in the event that you haven't asked me to completely close it, because a short-term cert has already gone into place.
We can't wait that long. I also sincerely hope that CHMIP is able to act in the next week. And I always think it's nice just to check in, and if we can come back next week, if they have gotten the cert, then the court can lift the stay then, and we'd be done.
Okay. I'll set this in next week, May 1st at 4:30, just to check in on the 35-day stay that again would expire on May 30th. And I don't know if the state hospital can have him available at 4:30 by video, because I know we can provide a writ, but I'm not sure how quickly that'll get processed. Is the case manager still there?
Your Honor, if you can send a writ, I will pass on the information as well. And
I appreciate
I won't be available, but I'm sure we can get somebody available to get Adam on.
I really appreciate that. And that way he can know what's going on. So May 1st at 4:30, we'll revisit the case. And if the short-term cert has gone through, then I will close this. If it hasn't, then maybe whomever is helping Adam get on would give us an update, or Isaac might be able to give us an update. Okay. So Adam, I'll see you in 1 week, next Thursday at 4:30. Okay.
Okay, and I don't have to stay here, or do I have to stay here?
You have to stay there, and I think until you're doing healthier and better, you might be there for longer than even this case lasts. That's what I'm saying. Do your best to try to engage like you did before when we worked together at Wellness Court.
Okay.
All right, hang in there. I'll see you next week virtually, Thursday, May 1st, 4:30. Thank you. Take care, Adam.
Thank you, Your Honor.
Thank you. And let me call the interpreter matter, Demetrio Loera, 23T210, 24T960, 24T691, 24T2440, 24T2600. Mr. Landers is present as counsel. Our defendant is out of custody. I have Manuel Larola present as certified court interpreter 22068 to help us today in the courtroom. All right. Give me 1 moment. Mr. Loera, I think you're doing a nice job working with Emily. And I want you to be connected to Summit Stone, because they want to help you apply for some benefits that might be helpful to you. There's a special screen. It can be done by Denver First. Depending on what the screen tells us, it may make you eligible for additional benefits or support, even if you don't have a case in the court system. So I want you to participate in that screen so that you have that information with you no matter what, whether you're in the court or not. I have your evaluation scheduled June 4th at 11 o'clock. So that's going to be the next court date. But overall, I think you're doing a really nice job working with Emily. I want you to keep up your good work. Any additional record, Mr. Landers?
I just want to acknowledge his wife, Josie, who's in the courtroom today. And she's very helpful. There's some memory deficits at play here. She's helping him try to stay on top of all these appointments. Her help is greatly appreciated.
I have nothing to add. If the eval is going to happen on June 4th, maybe we set 2 weeks after that.
Actually, that's a bond returnable date for this courtroom. So I'm going to set it for June 4th at 11. Make sure he shows up for the evaluation. Mr. Loera, as long as you come June 4th at 11, then you're still in good compliance with the court. And that way we can get the evaluation done. Do you have any questions?
No, gracias, es todo, creo.
Yes, thank you, Evan. That's all.
Thank you.
Thank you.
James Berg, 23M 1151. Mr. Berg is present in the courtroom. He's out of custody.
So hate to interrupt Mr. Berg, but I hear that Mr. Arguello has a babysitter in the car with his children. I wonder if you might.
Mr. Berg?
I'm sorry, Mr. Berg.
You don't have a baby in a car, so I'm gonna skip you for a minute, okay? Right. Maybe you feel relieved you don't have a baby in a car, Mr. Berg. So, all right, let's help Mr. Arguello next. And his case numbers are 16 CR 1846, 16 CR 1563. My apologies, Mr. Arguello, for overlooking you earlier. You're present before the court. You're out of custody. You're doing an awesome job. I hear you're supporting your family, you're working, you're going to North Range, you're doing really well. You keep up your communication with Logan. From everything I see, this is a really positive, wonderful report. So well done, Ms. Lowry.
It is, Your Honor. I think you knew as a child with health issues that got a little off track there, but he is re-engaged with North Range. He's doing great. Yeah, we're just looking forward towards the next evaluation whenever that time comes.
Mr. Oxlacher?
Nothing to add.
June 5th at 4 o'clock in the afternoon. Is that a good time of day for you?
Yeah.
June 5th at 4 o'clock in the afternoon. Keep up your communications with Logan. I like to know that things are going well. So I like that you check in with him. And I'll let you go tend to your family. Thanks for being here today.
Thank you, ma'am.
Okay, Mr. Berg, come forward, please. And court will call your case 23M 1151. You are out of custody, appearing here in the courtroom with Ms. Lowry as counsel. And right, your schedule is efficient, but it's causing a little bit of heartburn for us. Let me tell you what's happening. If you go 10 days and you haven't been in class, it puts you on this status that's called low engagement, that you're at risk of being kicked out. So when you go for 2 classes, then you don't go later in the week, you don't go to the first sessions of the week, and you go to the last 2 of the next week, you're not getting kicked out, but you're alerting everyone essentially to a low engagement place. And so I know that it's more efficient the way that you're doing it, but it kind of puts you in this not great place because you're going in and out of potentially low engagement means potentially getting kicked out. And so you're not getting kicked out, you're okay, but you're kind of dancing on that line because of the way you're attending. So there's classes are offered twice a week, right? 2 times a day. So the way that you're structuring it, I logically understand, but it's kind of putting you in this risky place. And I just want you and your lawyer to be aware of that. But you are attending, and I think you're doing a great job with pretrial services. You keep in contact with Kenny. It's a great report. I just want you to be aware of the way that you're doing it, what's happening there, okay? Ms. Lowry?
All I can say is that Mr. Berg is incredibly responsive. I was surprised to get the low engagement from Maria. I contacted him. He contacted me back immediately. He explained the schedule. I contacted Maria and she said, yes, he had shown up for the classes and it was all fine. So
Just right on dancing on that edge. It makes me a little nervous.
Where I live.
That's where you live? That's not where I live. Now I have to live there with you. That's not, yeah.
we are
Okay.
getting close to the evaluation. I did see that they are expecting to file a report around May 16th.
Okay.
And hopefully he'll be ready to move forward with this case after that evaluation. That's
Do you want me to bring him back May 22nd?
if you could go out another week after that,
Then go May 29th at 4, would that work?
that'd be great.
Mr. Oxmacher, anything else you want to say? Do you like living on the edge?
Well, that's a deep question, isn't it? No comment.
Okay.
May 29th is great.
All right, May 29th, 4 o'clock.
Someday you'll find out what I really do for a living.
Okay.
You'll know why I live on the edge.
Okay, just please be careful. I don't want you to get kicked out. You're so close to maybe even being all done, sir. Okay, thank you that you're engaged. And hopefully we'll have good news on the 29th when we come back, okay?
Great, thank you.
You're welcome. And do I have one Martinez present, 24 CR 1281? If not, I'll pass it, Ms. Lowry.
He is not here.
Let me pass it so that you might be able to, maybe he's on his way. One more case and then I'm going to go back to the Autry matter. And the next case is Yvette Muniz, please, 25 CR 589. She's present before the court and she is out of custody. Mr. Landers is normally Ms. Muniz's counsel. And so I'm going to appoint the Public Defender's Office in 25 CR 589. Can you accept that appointment, Mr. Landers?
I think I may have already filed on tree.
And the court did appoint Bridges, but I don't think it ever, the order ever came through. I just covered the 130s because Magistrate Lemus used to be counsel for Ms. Muniz and had a conflict. So on Monday when I set the bond for her, I did order Bridges, but we'll make sure the order goes into place. I don't think we need a new evaluation, but maybe to adopt the findings. Are you in agreement?
That is going to be my request, is you got the findings in the newer case from the older case.
Mr. Oxmacher?
No objection.
Okay, court is going to find that you will benefit from outpatient restoration in order for you to work on being in a place where you can aid in your own defense, and that you're not able to do that adequately at this time. And I'd like to, Mr. Landers, I guess, pull the outpatient restoration plan as also a condition of the 25 CR 589 bond. Do you have any objection to that?
No objection, because she'll be doing the same work for both cases.
Yes. All right, so in addition, Ms. Muniz, to the no contact orders and the things I ordered on Monday when we were together, you need to do outpatient restoration, stay in contact with your Bridges liaison. So all that stuff you were doing for the old case, you need to do it for this case too. Do you have any questions about that?
Ma'am, I do. It said it is on a pause right now. Is that?
It's not totally, I don't believe, on a pause. I think what's happening is sometimes in life, in order for us to take those classes, we need to have a good, stable foundation. You got a lot going on, you know? And I know that you're juggling a lot because I even know when you're in here and you have a baby, a daughter, and the things that you're dealing with. I think what they're doing is saying, first, before you make us give classes to Ms. Muniz, let us work with her a little bit just on therapy to get things nice and stable before we add more to her plate. And so that's my understanding of what's going on. Is that kind of what they told you?
Yeah, but you're aware of that, right? I just want to make sure that it's all.
You're not in trouble as long as you're working with North Range, okay? Okay. I think I just need to reset this. I'm not sure. I guess let's do one more thing, and that is I'm aware from pretrial. Again, they have a rule if people pick up a felony while they're on pretrial supervision, they file the affidavit. I'm anticipating that that's going to come my direction, but I don't have it in my hands today. Would you like to address that issue? Because I think the main issue is the new law violation, and we can address it now.
Yeah, if I consult with DA for one moment.
Sure.
So Your Honor, Ms. Muniz posted a significant bond in this new case. So if that affidavit comes in, I'm not anticipating asking the court to take action on the old cases.
And so I'm gonna just, we have addressed it. Nick, if you can let your colleagues know if they want to file the affidavit, if they could, again, at that last paragraph, remind the court that we're not taking any action. Ms. Muniz, if you pick up new charges, they asked to revoke the bond on the old cases. So we can't have you picking up anything new. I'm not going to rearrest you on the old case, even though we could. Let's just get on track. Let's keep you going in a positive direction. You continue to stay in contact with Emily, meet with pretrial, call them, and just do your North Range behavioral work. And let's just stay on track right now and see where we get, okay? All right.
Just on that note, she actually met with me in my office for an extended period of time. She's meeting up with therapy, so I just want to give her praise for what she's doing. So,
okay.
Thank you.
All right.
And she was set previously in terms of the return court date on the old case. I think it was June 4th, if I recall, or thereabouts.
5th?
June 5th must have been. I don't know.
I don't have her on my calendar for that. It was June 12th.
Oh, was it June 12th? I remember.
3:30. Is there any objection to set this at that matter?
No.
At that time? Okay, on June 12th at 3:30, we'll call your cases both at that time, Ms. Muniz, okay?
Thank you.
Thank you. Let me recall Sherry and Autry's matters, 22 CR 1897, 24 CR 1286. All right. Ms. Autry, I'd like to be honest with you, never have to make this difficult decision, but I know I'm going to have to. And your affidavit is awful. It's terrible. That means when the officer wrote to me under oath, the reason why he's investigating you and eventually charged you for potentially, I don't want you to talk about it, stabbing someone in the neck. That's awful. That is so risky of behavior. You are blessed that this person did not get harmed worse, where you might be facing a totally different set of consequences. I accept when you tell me that you have been a victim, I accept that as being true. I believe you. But you have to figure out how you're going to be in a healthy place. Otherwise, it's not going to work for you. You're going to be in and out of jails for the rest of your life, maybe in and out of prisons. So this way that things have worked up until now they don't work for you. You keep getting in trouble, and the things that you're getting in trouble for, they're escalating. If you're found guilty, the Judge Sherrard, is going to have to send you through those doors to prison. He's not going to have an option if you're found guilty at a trial or otherwise. That's serious. The court would normally never modify a bond like this to a PR bond. But I am going to modify 24 CR 1286 into a personal recognizance bond in the same amount. That is the $30,000 for a few reasons. Ms. Autry, my reputation is now tied to yours.
I understand. I understand.
Whatever decisions you make, you're not only affecting yourself, you're not only affecting the victim, because out of respect, you better follow all the rules. I am going out on the line. My job is to protect the safety of the community as well as respect and honor your rights. So I never give a PR bond at a $30,000 amount, and I don't give PR bonds for these types of charges. My reputation and my job is tied now to you because I believe that you can do this. Please do not let me down.
I won't. You have my word. Left hand on the Bible, right hand to God. I swear I will not let you down.
Court is going to require, as conditions of this bond, you are to comply with all work release program rules. I am going to add substance monitoring here, Ms. Lowry. That's something the program needs. There's not going to be any use of alcohol, controlled substances without a valid prescription, marijuana. I want to remind you, you may not have contact with Gilbert Alcozer, Christopher and Russell Nichols, Teresa Drummond, Chad and Alexandra Allerheiser. I assume these are all people that might be associated with that night or day. Don't have any contact with them. You are to remain law-abiding. You are to keep in contact with pretrial. You may not have weapons, firearms, or ammunition. You need to work with Anna. You need to work with Brandy at pretrial. You're going to have outpatient restoration ordered. So you'll have to start taking classes for your restoration. And you're going to stay at work release starting on April 28th. The team is going to have you releasable at 8:30 in the morning. They're going to pick you up. And so you'll be going over to work release. Do not get tempted to take off, because if you take off from work release, it's not a jail that's locked down. If you leave, I'm going to put a warrant out for your arrest immediately, and I'm never, ever going to feel comfortable trusting you again. So you have to follow all the rules. Do you understand?
I do understand. Thank you very much. I won't ruin your trust, I promise. Thank you.
I need to reset us to come back in, Ms. Lowry, in about 3 weeks, just to make sure things are going okay. And then this is not your forever home, Ms. Autry. If you're doing well, I think that at some point I'm going to be asked to revisit your bond for you to potentially be in the Montrose area near your family. That's going to be a difficult decision for me as well. But I need you to do your best so that there's an option potentially where you're not living inside of our work release program, okay? Let's reset this for 3:30 on May 15th. She may appear virtually if she needs to from work release. Ms. Autry, do you want a copy of this order or this plan?
Yes, please. Yes, please. Thank you so much.
And I'm adopting the conditions of the outpatient restoration plan as conditions of the 22 CR 1897 bond, in addition to whatever was previously ordered there, Ms. Lowry. Okay. All right, I'll see everyone back in 3 weeks.
Thank you. I thank you very much.
Right. Scott Alleman, 22 CR 1985. He's present before the court. He's out of custody. Ms. Lowry is present as counsel. Thanks for your patience. Did you get a chance to meet with Ms. Lowry and go over that report? Okay, Ms. Lowry.
Yes, Your Honor, and I'm not objecting to the findings or asking for a second opinion. Given the length of time that Mr. Alleman's been in restoration, successfully, the prosecution did modify their offer some. We do have an agreement. They will need a couple of weeks for to prepare paperwork and get VRA. We didn't know if you'd be willing to set it maybe on your regular docket.
Sure.
Or one thing that's a little unusual, Mr. Alleman's had several attorneys before me, but something that's been frustrating to him is the offer in the case is for a straight deferred sentence. And I was explaining to him that if he successfully completes the deferred sentence, he will be allowed to withdraw his plea. The case would be dismissed, and since it's not a tag deferred, he would be able to seal his record. And when the felony would be dismissed, his civil rights would be restored. He had not been advised that previously. I know the court often tells people just that same thing in court. I just wondered if you would let him know that that's not deferred.
So a deferred sentence, if you give me your plea, I don't enter it on your record as a conviction, but I hang on to it. If you do everything you're supposed to do, you'll have a review date immediately at sentencing. When you come back on the review date, I give you your plea back, case is dismissed. It's eligible for immediate seal, but there will be one more court date to seal it because it's a victim's rights case. And so I have to set it over one time after it's dismissed. But here's the rub. If you don't do what you're supposed to do and you come back for revocation, the conviction can enter on your record and there's never a trial. And so the nice part of it is that you have some control over the thing getting dismissed if you work on the terms and conditions. The tough part of it is, you're giving up the right to go to trial and so forth. And so you need to kind of think through all those pieces. But if you go to trial, I always tell people, I can't give you a deferred and neither can a jury. A deferred means that the DA has made an agreement with you that they're not going to push that issue further if you follow all the terms and conditions. Okay, Mr. Oxmacher.
Thank you. I guess these are nuances, but I want to make sure that we're being correct. Under a deferred prosecution, the conviction does not enter during the time of the sentence. On a deferred sentence, on the time that he's on it, that conviction is on the record. And so, for example, the ability to purchase a firearm is.
Well, he can't purchase a firearm. That's true.
And just to be
But
clear,
it's-
because that's an important part, during the period of the deferred, but once the deferred.
Once the deferred is done, that's true. But it's not a.
Correct.
No, you can vote anyway.
So I guess I will just say from this court's perspective, if you are applying for a job, my understanding is it's not a permanent conviction on the record. He's not a convicted felon, but that the plea is essentially sitting there. But for purposes of the federal government, you can't go buy a gun.
I just would hate for us to improperly communicate that during that time period, there aren't adverse consequences.
There are adverse consequences. You cannot have a firearm. And there might be others.
Also, the other issue, voting rights would get restored afterwards.
So right. And so I guess when Mr. Oxmacher says these things, I'm hoping Ms. Lowry has talked to you. When you go to apply, for example, a job, they're going to see that you've been charged with this. They might see that you're on a deferred sentence for this. There might be an adverse consequence. You go to get an apartment. They see you were charged with this. You have provided a plea that there's a deferred sentence. I mean, there might be adverse consequences. Anytime somebody has charges like this, to that extent, there could be some stigma and some effect. But for sure, you cannot have a firearm during this period of time. That is clear from case law. So
I think where he'd gotten some conflicting information and was really once the deferred was successfully completed, provided it is successfully completed, that his civil rights are then restored. And I think we all
Yes,
agree.
we are all in agreement. Mr. Oxmacher, are you in agreement?
I do agree that after a successful deferred, guilty plea is withdrawn, the case is dismissed, and it is eligible to seal.
And he'd be eligible to possess a firearm legally, purchase it, and other.
Our case would not prevent him,
This
from what I understand. I will say, Ms. Lowry, I do have some concerns after hearing from the FBI that once somebody has even been deemed incompetent, that there could be some effect of that on his ability to have a firearm, but that has nothing to do with the conviction. That's something he's going to have to address even if he wins at trial. So
That's a very good point.
I'll let you talk with him more about that. I don't mind bringing this back in a couple of weeks. And I will just say, Mr. Allen, you've really stuck with this. You've been super consistent. And I do appreciate all of that. Your questions are good ones. Ms. Lowry can go over those with you in more detail than I can in the courtroom at this time, but I can answer more questions for you when you come back. Mr. Oxmacher, do you think you'll be VRA compliant by May 7th?
I do, Your Honor. I'm actually meeting with the victim tomorrow in the afternoon. So the 7th would be great. This is one that I may appear in person on as opposed to having the courtroom DA handle.
Okay. Would you be available at 11 o'clock on May 7th?
Yep, that'd be great.
Would you be available, Ms. Lowry?
Yes, Your Honor.
Does that work for you, Mr. Allen? May 7th at 11? Does that work for you? Okay. May
Yes.
7th at 11 o'clock, we'll have you come back to this division. If there's not an agreement, that's okay. We will just reset you essentially back in front of Judge Cure, okay? Correct. You're welcome. I guess I should finally adopt that he is competent to proceed. I don't know if I did that. All right, thank you. Angelique McDaniel, 240111, 20.
All right, so there he goes. I think I'm gonna leave the stream here because we've been on for quite a long time. There's still another way to get. Oh, actually, no, sugar, no. Actually, sorry, we were gonna go. We ain't going nowhere. They just literally came live. The court that we were on about is back, so we ain't going anywhere, guys. Don't go, don't go, don't go, don't go. They literally just went live, and we might. I don't know if we have a verdict, if it is just to dismiss for the night. I don't know. Oh my days. I was literally like, oh okay, yeah, bye, let's go. But I was just like, yeah, no, we're not going anywhere. I don't know where Zio is. We need to text Zio. I was like, let me just refresh one last time before we go. And see what's actually going on. So we're not allowed to have a like she needs to come. Hang on. I'm gonna text her that we have a verdict even though I don't know if it is a verdict. So just she could she can run. Awesome, Paula. I'm glad. I was just like, we're just gonna go home, or we're gonna end the stream. We'll find the verdict tomorrow somehow. There's gonna be available anyway. And we'll do that tomorrow. It's fine. It's cool. But yeah, now they come back. They literally went live. So we'll see what happens. I know that circulage is just like, oh my days. Like, Hannah, I am hoping that is guilty. If we spend the whole day waiting for this and it's not guilty, I'm gonna throw my mouse away because how many times have I pressed the button to refresh my. No, I am not gonna be doing that all for a not guilty thing. Oh, at least the lesser. But the thing is, if he is found guilty of the first degree, he's gonna have a penalty phase, which I don't think is gonna be today. That's for sure. Sorry, I did not put the sound on, but no one is saying anything anyway. if he's found guilty of the first degree unaliving, he's gonna have to have a penalty phase, which would be tomorrow. I'm assuming. I don't think they're gonna do that now because it's so close to 5 p.m. So we might even do the penalty phase tomorrow and then just speed watch the Wagner hearing. But we'll decide what's happening when we know the verdict more. If this is the verdict. I mean, I'm assuming it is the verdict, or they could be just them dismissing the jury home for the end of the day and then come back tomorrow and carry on deliberations. So for all I know, it could be that. So we'll see. What do you guys think? Do you think we have a verdict? Do you think no, we are just gonna come back tomorrow? Let me know, because it's rather interesting. My days, come on, court. Like, I was so ready. I was just like, oh, okay, I'm going to bed at the reasonable time. Yeah, I had to refresh one more time. Actually, I could find if there was a verdict just by going into the court TV website, because they have that, and then I could probably pump ourselves with. No, they still have their counter up. They still have their counter on going for the verdict watch. In the case, probably they. Yeah, I don't know. We'll see what happens. But it is rather interesting that when I decided, and Robert did say this yesterday, I think the court looks guilty as well, and it's empty. So if it is a verdict, it's gonna take forever. Because they're gonna have to wait for everyone to come in, family to come in, the defendant to come in. So it's gonna take a while. So hopefully it's just a dismissal for the day, and they don't need everyone. I don't even know why they went live. Literally there was barely anyone live, from the Colorado thingy. So I was just like, oh, okay, that is interesting. So barely anyone was live. Yeah, they're still live. I'm still checking that they're still live. I'm crazy. Oh, I think they are getting ready to come back, because they put themselves in there in the way that normally is the judge on top and everything. So, oh, is it? On the Stacey Rodriguez, they had a penalty phase, a sentencing phase. Sorry, yeah. That was straight away after the guilty. Was it the judge that decided the sentencing, or was the jury? I think it was the judge. I think it was the judge. But yes, because I know that the first degree unaliving, the first degree red rum, is an automatic life sentence, and then it's just to see if there's a possibility or not of parole. I think. Do not quote me on that. But yeah, so that's what's gonna happen, because that happened with Stacey Rodriguez case that we followed here it was already a couple of months ago, like a month ago. It was not that long ago, and to be fair. But yeah, so we're just waiting. I might play just some music just while we're waiting, so I don't have to talk all the time. Hang on, let me grab a song in 1 second. Yeah, okay. Thank you. Appreciate that. Yeah. See, I was kind of right-ish. All right, I'm just gonna play music so I just can rest a bit my throat, because yeah.
She's a Portuguese soul in the UK, rolling dough at the bakery day by day. Sugar on her apron, flour on her face, but when evening comes, she steps into a darker place. Grab the keys to the car for that Costco run, loading up on snacks before the work's all done. 'Cause once she's home, it's time for the show. True crime on YouTube, spotlight aglow. Late night Documents on Discord.
Okay, so now we were watching this, and I got the will of, you know, the will that nobody likes of the loading. So uh yeah, hang on. Let me, oh my days. Now let me check if they are still actually live or not. And because if they're not live, we're not gonna like waste our time. Yeah, no, they're still live. They're still live. I just wish they would come quick. I don't know if they have a verdict. It's not doable. So I'm just gonna put the music back on. Is it gonna play? Ah.
In the hush of midnight, she's on the front. She's got her boyfriend by her side. Together they host this chilling ride. Nightbots watching, chats alive. Everyone's hooked, ready to die. Her days are sweet and filled with bread. Her nights are dark, deep in her head. From morning dew to midnight files, she dances between the day and trials. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord. She's on the hunt. In the hush of midnight, she's on the front.
Oh, we have someone in a courtroom. I think the court clerk is there. Will we have a verdict? Will not? We'll find out. At least we have someone there. It's not just us looking at the nothingness of the courtroom. I think she's setting up things. So, well, if they were breaking out for the day, she wouldn't be setting up things, right? Hang on. That's true. Yeah, it might be a verdict. Because she's plugging in at a computer. Exactly. So that's what I'm thinking. Because if he wasn't, if he was just to go home, she wouldn't be plugging the computer, right? Oh, we might have a verdict. We still do, if we have a verdict, we still gonna do the thingy, the thingy, the Billy Wagner hearing, because it should be like a rather quick hearing. I don't think it's gonna be that long, but that's all we're gonna do tomorrow. So I am crossing my fingers too. I hope it is. Yeah, oh yeah, that's true. If the judge, even if it is just to go home, she has to write it. You are right. Oh, Paula, I was hopeful. But hopefully it is. Hopefully it is the verdict. So, one second. Garden, but oh, she's standing up. Is the judge coming in already? Why is she standing up? There's no one there. There've been on deliberations for about 5 hours. So yeah. There could be people outside in the hallway. Yeah, that is true. I think there is. Oh, she's just maybe stretching her legs. Deliberations have been about around 5 hours, 4 hours and a half, 5 hours. Depends if you are taking the lunch break out of it or not. So around that mark. I know Hannah, I know it, but it's very very cute. I like it very very much. Well, yeah, normally they do. Yeah, that is true. So just, and there's apparently, it looks like there's like a chair in front of it as well. But we'll see. I mean, what was happening? I'm trying to check the court TV to see if they know anything that we don't. Um, yeah, ads. Ads are the worst thing. I'm sorry, but they are. Oh my days. So I think I don't know. It feels a bit. Oh, she's putting her headphones in. See, she needs some music. Hang on. Do I have chord sound on? Yes, I do. Yes, I do. Um, let's just see what happens. I think I might play just a bit more music while we wait. Just like instead of me talking and not knowing what to say, I'm just gonna play a bit more music. I'll stop if anything happens.
On the record, 23 CR 1034, People versus Joseph Koenig. The jury has indicated they would like to go home for the evening and resume tomorrow. We're going to honor that request. We're outside the presence of the parties as they have waived appearance for the purpose of advising the jury before they go home for the evening. Pursuant to 13-1-132, the court views it is not appropriate for live streaming for that brief advisement before the jury goes home, and for that reason, the live streaming will cease at this time. Deliberations will resume tomorrow when the jury determines it's best to do so.
All right, there you go, guys. Dang it. Well, now there we go. Jury's gonna go home. I think we might have a verdict in the morning when they do come back. We'll be back in the morning. Probably around the same time. I'll set up the stream tomorrow. For the Billy Wagner and verdict watch a little bit for this case, and we'll see how it goes. So no verdict. I'm so sorry. Definitely no verdict today. Hopefully tomorrow. I mean, yeah. It's gonna be okay. It's gonna be all right. It's still early. But see you for tomorrow. Exactly. Have a good night. Have a good evening, afternoon, morning, wherever you are in the world. I thank you very much for the company. I'll see you all tomorrow, and thank you. And it is Friday. Bye.
And I'm a real-time crime professional.